Good morning and welcome. Before we come to order, I want to announce that as we continue to move through and protocols, we're asking that folks who are not members of the Senate or their staff take their places in the gallery, and then as witnesses, we'll have you come down when it's time for you to testify. So if you're not a member of the Senate or Senate staff, we ask you to take your place. Well, you don't have to go to the gallery, but you can't stay here. But you can stay close, and we'll look forward to your testimony. And with that, Senate Committee on State Affairs will come to order. We'll ask the clerk to call the roll.
Campbell. Hall. Here. Lucio.
Here.
Nelson.
Here.
Powell. Schwertner. Zaffarini. Birdwell. Hughes.
Here.
There are 9 members present.
Senators, we have a quorum, and good morning. Sure good to be here, and it's my pleasure to get to welcome you to this first hearing of the State Affairs Committee for the 87th Legislature. Thank Lieutenant Governor for putting us each on this committee and allowing us to take these roles. And I know everybody around here is busy, and I thank each senator and the members of their staffs for all the work that's already done and will happen over the next days and weeks. For those wishing to testify, make sure to fill out a witness card. And members, of course, I'll recognize our esteemed Vice Chair, Senator Birdwell. We also welcome our returning members, Senator Hall, Senator Lucio, Senator Nelson, Senator Zaffarini, going around the table. And then new members, new for this session, Senator Campbell, Senator Schwertner, Senator Powell. Welcome to each of you. I want to make sure that y'all are familiar with the State Affairs team that'll be working and facilitating our work. Drew Tedford is our committee director. Many of you know Drew. We've worked together since I first got to the Senate. Drew is from East Texas. He's actually in Senator Nichols' district, but close enough. And so worked as a prosecutor and also legislative counsel, so we're glad to have him with us. Katriana Corkle is our deputy director. Katriana is also an attorney who joins us from Senator Perry's team from last session. Courtney Smith, our committee clerk, you know from administration last session, who with great talent handled that committee, and we were all thanking her for those local and uncontested bills. Taryn Taylor's with us again, an SFA lumberjack. She's also from the district as our assistant committee clerk. Hope Shelton, general counsel, also from the district. We were able to, Hope was with this committee last session, helping Chairman Huffman, and so we're so glad to have her back. And from Baylor Law School, my law school, and one that many of us are partial to, Lexi Winter is our Baylor Law School intern, and she's already done excellent work on this committee. And so contact me or them, probably more effective to contact them for anything you need. You all know how that is. We are set in the tentative early session schedule for 9 a.m. Mondays. As you returning members will recall, this committee has historically met twice a week, and so we're all working through the protocols and try to get the work done. So we are Mondays at 9 a.m., and if that changes or expands, we'll get your input on that, of course. And senators, you each have a copy of the proposed rules in front of you. They've been sent to you previously. They're standard committee rules, and I don't think you'll find anything unusual. And with that, Senator Birdwell moves committee rules be adopted. Is there objection to adoption of the committee rules? Hearing none, so ordered, the committee rules are adopted by unanimous consent. And I'll begin beginning with Chairman Birdwell. Vice Chairman Birdwell, if you'd like to make any remarks or introduce your team or share or give us some good stories, we'd love to hear from you.
Well, thank you, Mr. Chairman. This isn't the time for good stories, though I have plenty. Let me do this, just simply say it's a treat to serve as your vice chair and continue to remain on state affairs doing the important work that this committee does. Let me introduce my staff member, Ms. Tori Villarreal. Tori, if you would stand so that, because I don't, there you are. Tori is interned with us almost 2 years during her University of Texas Austin time, but she recently graduated back in May. We brought her on full time. She staffed us for the Judicial Selection Commission in the interim, and so she'll be staffing both state affairs and jurisprudence. So we'll be very busy. So with that, Mr. Chairman, it's a treat to be on your committee. Thank you, sir.
Thank you, Senator. Senator Lucio, do you care to make any remarks or introduce your staff?
Thank you, Mr. Chairman. I'm happy to be back with this wonderful committee. My assistant is Nathan Golden. Have him stand. He's my analyst and an outstanding young man doing a good job for us all. Thank you.
Thank you. Senator Campbell, go ahead, please.
Thank you, Mr. Chairman. I'm honored to be part of this committee. Excited to work with everybody. Never been on state affairs before, so this is great. We'll work together to keep Texas strong because we don't have another Texas to move to, right? So with that, I want to say thank you. I do have Zach Dooley. He's my staff. He'll be helping me. And I'm also on the esteemed Finance Committee, and I'll be leaving just a little bit before 10 to make sure I'm on time.
That's important.
Thank you, Mr. Chairman.
Thank you, Senator. Senator Hall.
Thank you, Mr. Chairman. It's an honor to be back on State Affairs. I really enjoyed it last year. I'd say right after Finance, I think State Affairs is the action committee where things really happen. And so I do look forward to it. And today I've got my Chief of Staff, Amy Lane, that will be here with us for today, and I look forward to working with this entire group here today.
Thank you, Senator. Senator Powell.
Good morning. Thank you, Chairman. It's a pleasure to have been appointed to serve on this committee, and I look forward to learning everything that I can about state affairs. My Deputy Chief of Staff, Rick Satora, is with me today, seated behind me over here.
Thank you, Senator. Senator Schwartner.
Thank you, Mr. Chairman. It's good to be meeting. Helping me is Lola Fender, my general counsel, as well as Quade Murray, who's interning and helping out as well. Thank you.
Excellent. Thank you. Senator Nelson, please.
Good morning, Mr. Chairman. I'm delighted to serve on this committee again. Do you know I've been on State Affairs every session that I have served in the legislature?
I did not know.
And I love this committee. I love the issues that we deal with, and I'm delighted to serve under your leadership, Mr. Chairman. The staff member who will be staffing me this session is the same who staffed last session, my legislative director, Michael Ruglieri, and looking forward to serving with this team. Thank you.
Thank you, Senator. Senator Zaffarini.
Thank you, Mr. Chairman. I, too, am delighted to be reappointed to this committee. It's one of my favorites, and congratulations to you. And I'd like to note that, not counting the chair, for the first time we have 4 men and 4 women on this committee. So that's progress. My staff member and legislative aide, Andrew Hendrickson. Where are you, Andrew? Might be behind me.
Oh, here we go. He's over.
Is covering the State Affairs Committee for his 2nd session. He's a graduate of Bard College, has a JD from Brooklyn Law School, and is a licensed attorney in Texas and in New York. Andrew and his wife had their first child, Imogene, in April, and are expecting their 2nd child in June after session. Thank you.
Excellent. Thank you, Senator. And as we begin to hear bills, for the benefit of those watching online or whatever vehicle by which folks may be watching, members of the committee will be coming in and out because there are other committees meeting. In fact, Senator Campbell mentioned the Finance Committee. Obviously kind of a big deal, and so Senator Nelson, who chairs that committee, and many members of this committee are there, so we'll try to move through quickly, but no one should be concerned if you see senators coming in and out. They may be visiting with a constituent in another committee hearing, but staff members are watching this, paying attention, and everything is going into the record, so your testimony and what you give us is being taken down. And so with that, without objection, the chair will lay out Senate Bill... Oh, Senator Lucio, thank you. This glass makes it hard to see sometimes. Go ahead.
Mr. Chairman, I just wanted to ask, in case I missed it, I might have, because this, my technology here is going in and out. When it's working, it is unbelievable. I can hear somebody's conversation upstairs if they're talking.
So y'all be careful.
Yeah. But what is going to be your preference at the end of the day? Are we going to get back, vote on these bills? Are we going to leave them pending? Could you tell us so we can have an idea of what to do?
No, Senator, that's a great question, and each committee handles those things a little differently. Thank you for mentioning that. So the bills we're hearing today, we realize that members will be in and out, and so it may be that some of these bills that have strong support and are not controversial, if we can get a quorum, we'll probably vote them out. But only the only ones voted out today will be the ones that everyone is comfortable with and ready to vote on. And if we can't get a quorum to get them today, then we'll vote them out next week.
Okay, because I personally obviously want to go on the record with most of the bills that I hear in any committee for that matter, but I'll be happy to sign. You're going to accept that, right?
Senator, we will. And again, knowing that members have to be in other committees, so yes, sir, you can leave your votes. Thank you.
Thank you.
We do want you on record on those bills. Thank you.
Sure. Thank you.
And members, thank you. Members, any other questions or comments or anything before we hear our first bill? All right, thank you. So then, again, knowing that the Finance Committee will be starting shortly, we want to move through those. So Senator Nelson has Senate Bill 198, and so the chair lays out Senate Bill 198 by Senator Nelson. And so we recognize Senator Nelson to explain the bill.
Thank you, Mr. Chairman, and I really do appreciate you allowing me to lay out this bill early because we do have finance. Mr. Chairman and members, Senate Bill 198 makes it easier for retired law enforcement officers to maintain their licensure in retirement. Under current law, retired officers must receive their firearms qualification at the department from which they retired. This requires travel and cost. It poses an undue, unnecessary burden, and our law enforcement deserves better after a career of putting their lives at risk to help keep us safe. This bill allows the firearms qualification to be obtained through any Texas license to carry instructor. Retired federal officers and those who serve out of state are allowed to do this already. This bill affords our retired Texas law enforcement officers the same convenience. I would respectfully request passage of Senate Bill 198 to the full Senate, and we do have a resource witness here if there are any detailed questions, Mr. Chairman. Thank you.
Thank you, Senator Nelson. Senators, any questions for the author? Senator Lucio.
Chairman Nelson, wonderful bill, and I certainly support it. One question only. Is this from this moment on, or do we go back and it's retro?
It's not retroactive. It's
not retro.
From now on, yes.
From now on. Thank you.
Well, now on after the bill passes, yes.
Senators, any other questions before we hear from the witnesses? Okay, the chair calls Chris Jones, Director of Member Services for CLEAT, Combined Law Enforcement Associations of Texas, well known to this committee. Chris, welcome. Please
take this off, right?
Yes, sir. Yes, sir. Good point. So witnesses, when you get to the table, please take off your mask if you're comfortable with that so we can see you and hear you better. And so even though we know you, Chris, introduce yourself. You know the routine, who you are, who you represent, and give us your testimony. And welcome.
Good morning. It's a strange new world, isn't it?
It is.
Good to see you all again for the first time this session. My name is Chris Jones. I'm with the Combined Law Enforcement Associations of Texas. I'm also a retired Houston police sergeant. So this bill is important to me in both ways. We've had a lot of complaints from our members who move after they retire or they go back to their own department. The federal law, LEOSA, the Law Enforcement Officers Safety Act, allows officers who retire or who are qualified because of years of service to carry their weapons, but there's no requirement that departments allow them to demonstrate weapons proficiency. And the law requires that, and TCOL does as well. So this would give them another avenue to demonstrate weapons proficiency in order to get their LEOSA credentials and carry their firearms. They could do it at a department that is near them, or they could do it with a handgun proficiency instructor and then turn that into TCOL, and then they can go back to their department and get their credentials. So it's a great bill.
Thank you. Senators, any questions for Mr. Jones? Thanks for your testimony.
Thank you so much.
Yes, sir. Chair now calls Colonel David Sinclair with the Game Warden Peace Officers Association. See him making his way down. And while the Colonel's coming, I want to say that we will continue to refine the process of getting folks into the chamber before they testify to help this go as smoothly as possible. First of all, to make it easier for the witnesses and also for the members of the Senate and their staff. So, Sinclair, welcome. Again, we know you, but
Thanks, sir.
Introduce yourself, tell us who you represent, and proceed with your testimony.
Okay. Mr. Chairman, members of the committee, my name is David Sinclair, and I'm here today representing the Game Warden Peace Officers Association in support of Senate Bill 198 by Madam Chair Nelson. First of all, the Game Wardens would like to thank this committee for all your support that you've given us over the years, and to the employees as well at the Parks and Wildlife. Currently, TCO accepts firearms qualifications for retired out-of-state and federal officers under the circumstances described in the bill. However, for retired Texas officers, officers must seek out a Texas agency head that is willing to sign off on a firearms qualification. This proves difficult for a number of reasons, including agency heads not being acquainted well enough with the retired officer to want to go out and sign the documents. Additionally, in the ranks of retired Texas game wardens, it proves to be difficult sometimes and expensive to travel long distances to game warden qualifications around the states. An example is most recently a retired warden in Brady who would be required to drive as much as 4 hours to attend firearms training. So if there's a local instructor there in Brady, it's certainly going to save him time and money. It's my understanding, after discussing the bill with Director Vickers, that TCO is willing to step up and help retired Texas officers meet the qualification requirements. The bill levels the playing field for retired Texas officers, and the GWPOA encourages State Affairs Committee to report Senate Bill 198 by Madam Chair Nelson favorably to the full Senate. And this concludes my comments. I'd be happy to answer any questions.
Hey, thanks for your testimony. Senators, any questions for the witness? Thanks for being here. Thank you for serving. We also have a resource witness, as Senator Nelson mentioned. If we have questions, Kim Vickers is here from the Commission on Law Enforcement. Senators, any questions for our resource witness? Very good. I'll ask then if there's anyone else who wants to testify on, for, or against Senate Bill 198. Anyone else wishing to testify on, for, or against Senate Bill 198 by Senator Nelson? Not, public testimony is closed, and the bill's left pending for now, and we'll move some very shortly. So,
great. Thank you.
Thank you, Senator.
Thank you, Mr. Chairman.
The chair now lays out Senate Bill 231 by Senator Seliger. And as we continue to work out our system, if you are in the gallery or in the sound of my voice and you want to testify on Senate Bill 231, go ahead and make your way inside the Senate chamber. We do have room for folks who are about to testify to come in. So if you're going to testify on this bill, please make your way to the chamber. And again, the chair lays out Senate Bill 231 and recognizes its esteemed author, Senator Seliger, to explain the bill. Good morning, Senator.
Thank you, Mr. Chairman. Congratulations on becoming chairman of this committee. And in honor of that and for your acclamation, this first bill is a very brief one and a very simple one, but it's an important one because it deals with something I think very important to this committee and this legislature, that every legally vote be correctly counted in the state of Texas. And what this simply does is it designates that there will be some training for county elections officers. There is information disseminated now, but doesn't go quite far enough. Those county election officers can either be a county clerk, a district clerk, or an appointed administrator. In the case of one county in the 31st district, it was an appointed administrator by the county court at law. And then in 2020, there was a school bond election. There were about 23,000 votes cast. And when things were counted, the bond passed on election night by 18 votes. After counting the mail-in votes, the prospect failed by 25 votes. And there were a recount, and the measure passed by 11 votes. And then somebody found a box of paper ballots. A nightmare that I'm not sure that we've seen in the state of Texas since 1952, but it's important because the chain of evidence that must stay with a ballot box It was at this point that I asked the Secretary of State to dispatch some people to the county to oversee and consult on the election, not tell them how to do it, but oversee and count it. And that was done, and then the measure failed by 26 votes. The outcome is largely immaterial. It's that things be counted correctly. The people who are in favor of the measure decided not to challenge it. After all, they'd been counted 3 or 4 times at that point. And there we go. What this bill does with no fiscal note is it mandates a certain amount of training, because a county can appoint anybody, whether they have any election such things or not, or any experience, to see to it that they understand the basic principles of voting and how to correctly hold an election and count all the votes.
Senator Zilliger, thank you for that explanation. Senators, any questions for the author of the bill? Very good. So we do have some witnesses that wish to testify, and so.
Thank you, Mr. Chairman and members. I appreciate it.
Senator Zilliger, thank you. The floor is open for public testimony, and the chair will call Keith Ingram, the Director of Elections Division for the Texas Secretary of State. Keith Ingram, Esquire. Mr. Ingram, welcome. Introduce yourself, tell us who you represent, and proceed with your testimony.
Yes, members, my name is Keith Ingram. I'm the Director of the Elections Division at the Texas Secretary of State's office, and I'm happy to answer any questions that y'all might have.
Senators, any questions for, he's here as a resource witness, of course, but if we have questions about how this would work or what it would look like. Mr. Ingram, were you involved with the case that Senator Zilliger was telling us about?
Yes, it was a very interesting situation. Been using DRE. Some of them, when they go back to paper ballots, have a problem with muscle memory on record retention, and so our trainers that we have right now have been working with counties on that.
Thank you very much. Given that you were involved in that, we thought it'd be interesting to hear from you. And Senator Zilliger's right. It sounds like a nightmare situation for all of us. Thank you. No other questions for the resource. Oh, Senator Hall, couldn't see you through the triple glass. Please, Senator Hall, go ahead.
Too many pieces of plastic there, in there.
That's right.
Anyway, Mr. Ingram, I'd like to hear a little bit from you about what you might. Texas really has about 254 election processes. Each county kind of makes it up on their own of what they're to do, with very little state oversight and guidance. And hopefully, as we move forward in this session, Mr. Chairman, with election security being right at the top of most everybody's list, because there's nothing more important that citizens do than voting, and to have confidence that their vote is going to count. And so I think this training that Senator Zilliger has brought forward is a key part of making sure that happens, because what you've described happened, or what was described by the Senator out west, we have seen other things. Hill County, not too long ago, had one. We've seen problems in Dallas County, in Tarrant County, in Harris County, and counties all over. And a lot of it goes back to people not really understanding their job, kind of making it up as they goes along. But recognizing that we don't have a lot at the state level that says this is what an election should look like, what do you see needs to be done, and how would you approach this just generally? Don't need to get in a lot of detail, but how would you see implementing this?
So in years past, our office had a bigger staff and a bigger budget, and we used to go out and do regional trainings, so smaller groups of counties and some one-on-one interaction. And it has been my desire since I've been in this office to bring that back. We would very much like to have one-on-one interaction with counties, see how they're actually doing their job, and make sure that they're doing it correctly. It's been the gap that I've identified and that you've identified, that to make sure that all the counties are doing the procedures that they're supposed to be doing in the way that they're supposed to be doing them. And so we've asked for 4 trainers in our exceptional item in our LAR, and we think that this would be a very good use for them.
Okay. All right. Thank you. Mr. Chairman, I think I agree. This is one of the foundational things that we need to do. And I know there have been a number of other bills that have been filed. that will help Mr. Ingram in laying the framework for the training so that we have consistency from one county to the other and do more to actually ensure that every vote counts. And so I think this is a really good bill and a good start on our effort for election security for this session.
Thank you, Senator Hall. Senators, any other questions for the witness? Thanks, Mr. Ingram. Thanks for your testimony. You're excused. The chair now calls Ed Johnson from the Republican Party Ballot Security, and someone who's familiar with elections and conducting of elections. And of course, again, since we sent folks to the gallery and there wasn't a lot of room in the gallery, it may take folks a moment to get here, but Ed Johnson had registered to testify and expressed his opinion, expressed his desire to do that, and we'll give him a little time. And so the chair calls Robert L. Bob Green, chairman of the Travis County Republican Party Election Integrity Committee. And we'll also ask if Bob is here. There, so come on down. Thank you, Bob. I look better with a mask, but it's hard for me to recognize folks. I see you there. So Bob, you go ahead. We'll have Ed after you. So welcome.
All right.
Get settled and introduce yourself and who you represent and give us your testimony.
Thank you, Mr. Chairman, members of the committee. My name is Bob Green. I am the chair of the Travis County Republican Party Election Integrity Committee. I have been a precinct chair here in Travis County and an election judge for about 10 years now. And we can look at the priorities that have been set up at the Republican Party national level, state level, and local level. Everyone agrees that election integrity is the most important priority. The governor has said it, our attorney general has said it, and we must be able to let our public have confidence in the election. We have to be confident in the results of the election, that it was fairly conducted, and that the winner is determined fairly. I have witnessed irregularities at Central County here in Travis County, and that's why one of the main reasons that I feel it is so important that our election judges and our officials have the same type of training so that they can be educated as to what is permissible and what is not permissible in the vote counting process. And it's been said for a long time, it's really almost more important who counts the votes than who actually votes. So we want to ensure that remains the same. I have been trying to work very closely with the House Elections Committee, through which a very large number of bad bills are going that incorporate parts of the horrendous H.R. 1. If I'm halted now, I will quit. I thank you for your kind attention and would appreciate your support for this bill. Thank you.
Thank you for sharing your experience with us. Senators, any questions for Mr. Green? No. Very good. Thanks, Bob.
All right. Thank you.
And the chair now calls Ed Johnson. I think you saw Ed come in. There he is. Good morning, Mr. Johnson. When you get situated, introduce yourself, tell us who you represent, and give us
Good morning. Could I ask a little question on clarity of how the committee works?
I beg your pardon?
I would like to have a little clarity on how the committee is going to work with the COVID. I thought you asked us to come down if you're speaking on a bill. So I was sitting here, and they made me go back upstairs. I have run downstairs 3 times now trying to testify for this bill. So if your bill is being heard, should you come down here to be sitting, or do you wait in the gallery?
So thank you. It wasn't our intent to help you get your steps in, and I apologize. This is our first hearing in the Senate chamber as we work through the protocols. And so what we're going to try to do is, as each bill comes up, announce that if you're testifying on that bill, you should come into the chamber. So in a moment, we're going to call for witnesses on on some bills. When you hear that, come down and tell the nice folks outside that you're on that bill and I told you to come in. And if that doesn't work, we'll try something else. But thank you for letting us know how it's working out.
Yeah, I just wanted to have clarity on where I'm supposed to be sitting.
You're in the right place now. And thank you for your patience with us, and thank you for telling us what's going on as we work through this. So, and that doesn't
Ed Johnson.
Go ahead. Go ahead.
I am here representing Harris County Ballot Security, Republican Party. Also, I have worked in elections in Harris County for over 20 years before retiring, and this is a big problem. You will find that most large counties have the funding to send their people off to be educated on how elections work, and there's national training that they can go take, and a lot of them do. Medium, small counties, they don't have the funding to do this. They desperately need this. So you're asking somebody that's training people how to run elections that have never been trained themselves. So it's a very important thing that we put this in. Talking to other sales reps of election equipment and stuff that go around the state, Florida used to have a big problem running their elections. They put this law into place, and their elections have turned around tremendously. Have seen in other states that have implemented this, it has been a big, big help for running elections, to be able to educate people how to do it. Pass the bill, please. Thank you.
Ms. Johnson, thanks for your testimony and for all the trouble you went to testify. Senators, any questions for Mr. Johnson? Very good. Thank you for being here. Those are all the witness affirmation cards we have, witness registration cards. Is there anyone else wishing to testify on, for, or against Senate Bill 231? Hearing none, public testimony is closed. And let me just say that in light of the difficulty to get in and that sort of thing, if we miss someone, we'll give you a chance to testify. But as of now, public testimony is closed, and the bill will be left pending at this time. In a moment, we're going to begin to hear some of Senator Perry's bill. So if you're here to testify on Senate Bill 156 or Senate Bill 157, 156 or 157, please make your way down, and we'll try to make arrangements to get you in the Senate chamber. So if you're testifying on 156 or 157, please make your way inside the chamber, and we'll have a place for you to sit. And with that, Chair lays out Senate Bill 156 by Senator Perry and recognizes its author to explain the bill. Good morning, Senator.
Thank you, Mr. Chair and committee members. Senate Bill 156 is a refile from the previous session. It left the Senate 31-0 and out of the House and Civil Jurisprudence Committee 7-0. It's been in the making now 4 years. It came about, my brother passed in October of 16. He was not a wealthy individual and had very little estates to administer. My mom and dad at the time, 80 plus years old, were the beneficiaries, and he had left nothing to tell people how to administer that. I found myself going to Houston not once but twice and hiring attorneys for an estate that had a net value of pretty much insignificant monies. What Senate Bill 156 does is allow for a probate administrator, court-appointed administrator, executor, to move that to the residence, the county of residence for that administrator, if there's no sibling or other relative in that county of residence where the deceased died. It's just an efficiencies issue. I could have done it from Lubbock, Texas, had this been in law, and it just doesn't make a lot of sense when it's pretty much an uncontested and no other relatives involved in that process.
Senator Perry, thank you. Members, any questions? Senator Bardwell.
Thank you, Mr. Chairman. Senator Perry, on just as a quick example, as I was reading the bill, I'm very supportive of it. But if the individual that deceased was, say, in El Paso County, next of kin are in Reeves County, which is not too far from El Paso, but the executor is in Harris County, does the bill allow whoever's appointing, the magistrate that's appointing, does it allow for the convenience of next of kin, even if they're not in the home county where the deceased lived?
You petition the court, and the court will make that decision. So if you had two of those competing people, hopefully there's a will that says A, and then if the A is not in that county, this was where that would come into play, so that that person doesn't have to go back and forth and incur the expense. And you go to courthouse, you may be there all day. That's 8 hours of an attorney time.
Right. I'm just trying to make sure it's not if the family's even more greatly inconvenienced by traveling to Harris County from Reeves County, that's not a mandate to do so.
No, it's not a mandate. It's a petition to the court to do it when it makes sense.
Thank you. Appreciate it. Thank you, Senator.
And Mr. Chair, if there's public or not on this, after it's all done, if it's local consent, if it's uncontested, I would appreciate you send it to local and uncontested if it's not contested.
Senator Perry, thank you. And committee members, any other questions for the author on Senate Bill 156? Very good. In that case, we will open public testimony, and Chair calls Jerry Jones, Esquire, testifying against Senate Bill 156. So welcome. Please, when the space is prepared, take a seat and introduce yourself. Tell us who you represent, if anyone, and give us your testimony.
Thank you, Senator. My name is Jerry Jones, and I'm here on my own behalf. I'm a board-certified probate lawyer, and my focus is on fiduciary litigation, so I have some concern with issues like this. And while I think this bill is extremely well-intended, I have traveled halfway across the state on many an occasion, my client forced to go to the right county. What worries me about this bill, I think there are three reasons why this bill may not be necessary. Number one, it only kicks in after the will has been probated and somebody's been appointed executor. That's 99% of the hearings that we have. After that, if there are other hearings, it's because there's some problem, there's some issue. With our Zoom hearings, I haven't been inside a courtroom in a year. This is actually quite an honor to be here in front of you folks today. And I understand there's legislation to allow us continue to have our probate hearings by Zoom, which I think we've all been surprised at how well it's worked and how grateful we've been to the government to flex and to solve this. And the third thing is, we already have a statute that's titled Transfer for Convenience. And the only test there is the court to determine it's in the best interest of the estate. So I'm not sure we need this. Thank you very much.
No, we didn't.
I'm sorry?
You can.
Oh, okay, real quick.
You've got some more time. Thank you.
There are particulars about the statute that I criticized, but I don't want to do that. I just don't think we need it. I mean, it could create an issue for family members or non-family members who inherit, and much less creditors. If the decedent had local creditors owed money to, they're going to have to go across the state. Thank you.
That's okay. You can. No, thank you, and thank you for your testimony. And let me say, I do just little minor probate stuff, so I'm not an expert in this area. But just so we can understand, is the concern that if the proceeding were moved outside that county where the decedent lived, that interested parties might not get notice or might not know about it? I'm not cross-examining you. I want to understand what it might look like.
No, actually, it's a great question. The problem is this statute and lots of other statutes don't require that you give notice to the beneficiaries that you want to do this. If we have an independent executor, they're pretty much ollie in free. Now, it might be a good idea if the statute required notice to all the beneficiaries and all the creditors, but I even have an issue with that. The brother who's not the executor, he might say, yeah, I don't care. And then a year later, when he finds out that he wants an accounting, and he's got to go to North Texas or South Texas to enforce his rights. It could create some unnecessary problems. But a judge right now, we've got plenty of statutes that he could allow a transfer in those unusual situations where it really needs to be moved to another county. Is that fair?
Well, thank you. Senators, any other questions for the witness? And let me ask, I know you've already come down here to testify and spent some time on this. To the extent you have ideas of how this might work, we'd be tickled if you'd share those with the author, share those with us. And you don't have to do that, but if you have ideas of how we might get to where we want to get and avoid the problems you're concerned about, you don't have to, but we value your experience on that. And I'm with you. I like those Zoom hearings. I've been in court in person only 2 times this last year. I've won once and lost once, but on Zoom, I'm curious, do you prefer the cat filter? What do you like to use when you're...
I'm allergic to cats.
Okay, all right.
I'm sorry, much to my wife's disapproval. Yeah, thank you, sir.
Thank you for your testimony. Thank you very much. Members, we do have as a resource witness, Judge Guy Herman, Judge of the Travis County Probate Court and Statutory Probate Judges of Texas. Do you have any questions? Judge, come on up. You don't have to be just a resource, so we'll call Judge Guy Herman to testify on Senate Bill 156. Judge, welcome. We know you, but introduce yourself, who you represent, and proceed.
I'm Guy Herman. I'm proud Statutory Probate Court judge here in Travis County, and I want to echo a little bit about what Mr. Jones said. To me, this problem, which came up, Senator Perry raised it with me a couple of years ago, 2 sessions ago maybe, I don't remember, but he did make an adjustment about the creditor issue because I was concerned about the creditors, let's just say, being in Harris County, and then we've moved it out to Lubbock, and then the creditors would then have to go to Lubbock for their lawsuit. And I question the fairness of that. But the real thing that's going on is this is the first live hearing that I've been in since last March. This is unbelievable, seeing real people here in person, and I'm much closer now than I've ever been. We are doing nothing but in probate but Zoom hearings. There's 2 bills, one by Senator Menendez, one by Representative Mahadas, to allow us to do Zoom hearings the rest of the way, and that's like you're in the town. So the issues that may come up with someone having to travel from this county to that county, I don't think are issues anymore. I want Zoom hearings. Our lawyers, I've polled them over and over again, do you want Zoom hearings? I have saved so much money for people in the states by doing Zoom hearings. I've asked people where they're from. I'm from Oregon. I'm from California. I'm from the East Coast. They're not having to fly down as they did in the former times. And I will say this pandemic is terrible, but there are some things that have come out of it that are really well placed and make the courts modernize. And that's what my position on that bill is. And I think it's unnecessary because we are solving the problem through technology.
Thank you, Judge. Senators, any questions for Judge Herman? Thanks for your testimony. Anyone present wishing to testify on, for, or against Senate Bill 156?
Mr. Chair, real quick.
Senator Perry.
You still have proper notice to the creditors. You still are supposed to do that anyway, or I don't think wherever the venue's at. So that's a red herring. Secondly, and it's just a personal observation, I kind of refuse to acquiesce to a pandemic that has produced the reasons for people not to be in front of each other and actually have communications. It may work, and I'm sure it does. I've had attorneys tell me it works sometimes, and a lot of times it don't. But the bill may not be as needed as it was the time I had to deal with this issue, but I think it's a slippery slope when we go down this road of continuing to find reasons why people don't really need to have a conversation in person with each other. So I just add that.
I understand that, Senator. Senator Campbell has a question for you, Senator Perry.
Thank you, Mr. Chairman. Bill makes sense to me. One, it's a petition. It doesn't have to be done, right? Number 2, in regards to creditors, there's no guarantee that all the creditors are clustered.
You basically put a public notice in the paper.
But I'm saying a creditor, to not pass this because we're thinking of creditors can be anywhere across the state.
Right.
not an assumption that they're all right there. So I do think it's a good bill, and
There's clearly specifics on how you go about notifying creditors as well as benefactors.
so I think that it's a good bill.
But it's really geared for that small family that had that
Yes.
Casey. So
Thank
no,
you.
no problem either way, whatever
Thank
the
you, Senator
committee's
Perry.
pleasure is.
Thank you, Chairman.
Senator Campbell, thank you. And Senator Saffarini is recognized for a question for the author.
Thank you, Mr. Chairman. Senator Perry, just as the bill did last time, this bill would allow for petition only if no immediate family member of the decedent resided in the same county where the decedent resided, correct?
Correct.
Thank you. Thank you.
Senator, thank you. Any other questions for the author? Okay, at this time, just to make sure, because we got a lot of folks moving around, anyone wishing to testify on, for, or against Senate Bill 156? Hearing none, public testimony is closed. Bill will be left pending at this time. Now, by way of housekeeping, we're going to ask if you are here to testify on Senate Bill 157 or on Senate Bill 270. So if you're here on Senate Bill 157 or Senate Bill 270, please make your way to the Senate chamber and ask them to let you in. Senate Bill 156 or Senate Bill 270. Please make your way to the chamber so that we can hear your testimony. And Chair now lays out Senate Bill 157 by Senator Perry and recognizes its author to explain the bill.
Senate Bill 157 is eminent domain reporting. It's a refile from last session. Again, 310 out of the Senate, 60 out of the House Land and Resource Management. 84th Legislature created a continuous reporting process for entities granted eminent domain authority by Texas Legislature. School districts are one of those authorities. However, in many smaller districts, it is the superintendent that is responsible for filling out these requirements, giving all of his numerous responsibilities. This requirement may slip by, incurring a $1,000 fine for the school district. This reporting requirement is particularly difficult in rural school districts that have smaller staffs, as well as smaller counties and cities. The bill addresses this by allowing districts located in a county with population less than 25,000, cities or counties with a population less than 25,000. Under the bill, the entity does not have to report the eminent domain changes if there were no changes in the district. So basically, it's a report that's not needed if you don't have any changes in your eminent domain. Very few of these rural districts are seeing acquisitions of land to expand. They've got the opposite problem. They're trying to effectively continue growth in those districts. So it's just not there.
Senator Perry, thank you. Members, any questions for Senator Perry on Senate Bill 157? Okay, at this time we'll open public testimony. No one has yet asked to testify on Senate Bill 157, so we'll ask again. Anyone wishing to testify on, for, or against Senate Bill 157? Seeing none, public testimony was closed and the bill be left pending at this time. Now, if you're here on to testify on Senate Bill 270 or on Senate Bill 155, so this is for the benefit of those outside the chamber. If you're here on Senate Bill 270 or Senate Bill 155 to testify, please make your way into the Senate chamber. Senate Bill 270, Senate Bill 155. And the chair now lays out Senate Bill 270 by Senator Perry, recognizes its author to explain the bill.
Senate Bill 270 is Nursing Home Responsible Payer Bill. It actually passed last session, 9-0 out of this committee and 31-0 off the Senate floor on local and uncontested calendar. And I think with COVID, it even highlights a bigger need. Since some nursing homes residents lack the cognitive ability to manage their own financial affairs, a resident may have a third party or a responsible payer. Usually the child manages their funds. Some responsible third parties improperly divert or steal residents' funds that are needed to pay their long-term care. Senate Bill 70 prevents financial abuse of nursing home residents by allowing facilities to seek injunctive relief and pursue their debts against responsible payers who improperly divert residents' funds, leaving them unable to pay for long-term care susceptible to the discharge and lawsuits. I ask favorable consideration of the bill. To be clear, if you're a responsible payer, let's assume your mom goes in the home. Mom has some resources, be it Social Security, retirement benefits, home sale, whatever those may be. Mom's resources are now being managed by a third party, typically a child. If child takes those proceeds and buys a resort vacation and a boat and doesn't pay the nursing home, those funds would be subject for lawsuit and recovery. If the third-party payer is a wealthy individual that has millions of dollars in the bank, those are not subject to, if they're the payer's resources. So this only goes after the resources that were available that the nursing home had a commitment to pay them with when they signed up for the program.
Thank you, Senator Perry. Committee members, any questions for the author? Okay, we'll open up public testimony for Senate Bill 270. We do have a couple of folks who've asked to testify. The chair now calls Gavin Gadberry, General Counsel of Texas Healthcare Association, testifying for Senate Bill 270. And again, we know folks are making their way down, so if Gavin, there we go. All right, thank you, welcome. Take your time and you get settled in down there, and look forward to hearing your testimony.
This is the first time I've been around folks in a while in a hearing as well. Good morning, Mr. Chair and members. My name is Gavin Gadberry. I'm from Amarillo, Texas. I serve as General Counsel to the Texas Healthcare Association. Yes, all the way from Amarillo. It was a little colder a couple of weeks ago up in our neck of the woods, I can tell you. I'm here today in support of Senate Bill 270. Senator Perry, thank you for your support on this issue. It's a difficult issue, and I'm going to focus, I think Corey McDonald's be coming down, he'll be testifying as well, but I'm going to focus on the Medicaid side. Medicaid beneficiaries that reside in nursing facilities, they help pay for the portion of their care. A lot of people don't know that. A lot of people think Medicaid pays 100%, but their Social Security income is applied to their Medicaid bill, for lack of a better term. In other words, it could be considered like a copay. It's not, but it's kind of like a copay. And when you have that in place and somebody misappropriates their funds, the nursing facility has no ability to go make a claim for those funds. And when that happens, unfortunately, it still looks like the money went to the beneficiary in the eyes of the commission. So you have a hole of, say, $1,200 on Social Security income, the applied income, and there's no way to collect it from anyone. Because the Medicaid beneficiary, when they go into the facility, somebody's going to sign the admission contract for them, but you can't require them to guarantee that. You can say in the contract that they're going to use the resources of the Medicaid beneficiary to pay. But the Social Security income is generally nowadays, used to be a check, but it's wired into the person's personal account. There's no way to collect those funds because the facility doesn't have access to it. This creates a cause of action, which is a reasonable cause of action. It says, if you do misappropriate the money, the facility has a cause of action to go claim those funds. And that's simply what it does. It creates a cause of action in favor of the facility to go after the person that stole from the resident. And it's important to remember that there's two provisions, one in state and one in federal law, that say you can't have a guarantee in these situations, especially with regard to Medicaid contracts. With that, Senator Perry, thank you very much. Mr. Chairman, thank you.
Mr. Gadberry, thanks for your testimony. Senators, any questions for the witness? Thank you for being here. You're excused. The chair now calls Corey McDonald, General Counsel, Leading Age Texas, testifying for Senate Bill 270.
Thank you for having me. As you said, I'm General Counsel to Leading Age Texas. That's the State Association of Nonprofit Aging Service Providers. They do have many nursing homes that are part of their association. As previously mentioned, many nursing home residents' finances are managed by third parties, usually their children. This situation, unfortunately, can leave some vulnerable to abuse and exploitation. This situation of misappropriation is one of the most challenging things that the nonprofit members of Leading Age Texas face. They make charitable assistance available to people who truly outlive their assets, and that does happen quite frequently. But that whole system of charitable assistance is jeopardized by situations where it's not because someone outlived their money, it's because someone's spending their money, and the bill is for the care being provided is not getting paid. That jeopardizes the charitable care system. It also can jeopardize solvency of some smaller organizations. If you have one or two of these a year, the numbers can really add up. So there's not many tools to address this. The provider, the organization can notify Adult Protective Services. They can issue a discharge letter. This rarely stops the misappropriation in time. The facility can sue the resident, but this is just punishing the resident, and it has limited value when another person is the one controlling the assets and has spent the money, as examples gave, on a resort or some other use like that. So this bill simply clarifies that the facility can name the misappropriating third party in a lawsuit, can obtain an injunction to get that misappropriation to stop, and then ultimately allow the resident to use their own funds to pay for their own care. This bill, as previously said, does not allow the facility to pursue the personal assets of the responsible third party. So overall, SB 270 creates a limited but important tool for protecting Texas seniors against financial abuse. It applies only to instances where a resident has the financial resources to pay for the care, or the Medicaid copay, as Gavin said. A third party contractually commits to apply those funds to the care, and the third party misappropriates the resident's funds in violation of that contractual commitment. If passed, SB 70 will go a long way towards protecting the rights of nursing home residents to use their own funds to pay for their own care, free from financial abuse and exploitation. Happy to answer any questions.
Thank you very much. Committee members, any questions for the witness? Thank you for being here. You're excused.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 270? Seeing none, public testimony is closed. The bill will be left pending at this time. By way of announcement for those watching for testimony, wanting to testify, if you are here to testify on Senate Bill 155 or Senate Bill 247. So if you're here on 155 and or 247, please make your way into the Senate chamber. Senate Bill 155, Senate Bill 247. And let the folks outside know you're going to be testifying on one of those bills. And with that, the chair lays out Senate Bill 155 and recognizes its author, Senator Perry, to explain the measure.
Thank you, Mr. Chair and members. As the legislature, it's a job to ensure that we have free and fair elections that the people of the state can trust. This bill seeks to create a new tool in the toolbox to tackle or prevent voter fraud in our state. Under current law, if a person is summoned for jury duty but identifies him or herself as a non-citizen or a non-resident of that county, they are excused from jury service. Their name is then sent to the appropriate local officials through the Secretary of State to have their name removed from their voter rolls. A jury will is then developed from the voter registration list for that county and DPS driver's license list. However, current law prevents these lists, which can be obtained through open public records request, from being used to identify if a non-citizen or non-resident of a county voted in an election. This comparison is a Class C misdemeanor. SB 155 allows for the comparison of the names of those excused from jury duty to the list of the names of the voter roll, as well as those are non-citizens that may have voted in error, and allows the Attorney General to compare these lists quarterly. I do have resource witness with Secretary of State and the Attorney General. Be glad to take a few questions, and I will defer to those on the technicalities.
Thank you, Senator Perry. I think the Senator Birdwell has a question for you.
Okay.
Thank you, Mr. Chairman. Thank you, Senator Perry. Does the Attorney General has the ability to collect the information, but does the bill in any way allow the Attorney General to supplant local county clerks, district clerks, as it might relate to misdemeanor charges?
So to be clear, the jury list is already something that's done, as well as the declaration from a resident, non-resident, pretty much already done. The Attorney General can't review that to date. So all this does is allow them on the backside of a vote to look at those lists and compare and make sure those votes that were cast by people that were legitimately supposed to vote, either by county or by citizenship. And its jury list is where you start, and now that would, if this bill's passed, be actually given, the AG would have the authority to review that. They currently don't have that authority to compare the jury list to the voter list.
But it's not, the way I read it, it's not intended for the AG to have prosecutorial.
No, it doesn't, let me back up. It doesn't change any of the other processes as far as registration, as far as voting, as far as jury selection. It doesn't change anything on the back end. If the AG had questions that they thought there might have been a voter irregularity, then they could use that as a tool to get there, but it doesn't change what they do in the process once that's determined.
Okay. Thank you, Senator Perry. Thank you, Chairman.
Thanks, Senator. Members, any other questions for Senator Perry? Okay, members, I'll also point out that, as Senator Perry said, we do have a resource witness here. Anybody have any technical questions or anything else they'd like to ask to the Secretary of State? Senator Perry, do you want to question the resource witness?
No, I'm good. I just didn't know if they had something that they really needed to get out there, but it's pretty much allowing for a tool that the AG currently doesn't have to do a comparison that the citizens already adopt. I mean, hey, I'm non-citizen or I'm a non-resident. So it's just taking that information and making sure it's valid through the process.
The floor is now open for public testimony, and the chair calls Bob Green, Robert L. Green, Travis County Republican Party Election Integrity Committee. Welcome back.
Thank you, Mr. Chairman. Members of the committee, again, my name is Bob Green. I'm the chair of the Travis County Republican Party Election Integrity Committee. And obviously, I'm very much in support of this bill. I'd like to thank Senator Perry for filing it. It is the first step towards ensuring that we have clean, scrubbed voter rolls. It just gives us an extra tool to ensure that every legally cast vote is counted and no illegally cast vote is counted. There are several areas that are of concern, obviously, in ensuring our safe, fair, and transparent elections. After reviewing a lot of the documented ballot and process irregularities in the November elections, I believe that Texas must pass legislation that requires every Texas county to clean their voter rolls before the primaries in every election year, at least, to remove the deceased, the move-aways, plus non-citizens and felons. We must prohibit the mail-out of unrequested absentee ballots. We must require monitored signature verification of absentee ballots and any mail-in ballot that shows up. We must prohibit any internet connection to any county's vote tabulating machine. We must require only tabulating machines that cannot be programmed to add, remove, or switch votes between any candidate or weight them one to the other. A documented chain of custody for all vote recording devices like flash drives from the time they leave the polls to when they are actually tabulated at the central counting location must be created. And finally, prohibiting the Texas Secretary of State from granting any waivers to current Texas election laws, one of which requires that ballots be consecutively, not just uniquely numbered. Thank you. I'll be happy to take any questions you might have.
Mr. Green, thanks for your testimony. Members, any questions for the witness? Thank you for being here.
You're welcome.
Very much. Chair now calls Michael Openshaw, testifying for Senate Bill 155. Mr. Openshaw, welcome. So I've got to ask you a question. Mr. Openshaw, are you a lobbyist?
No, I'm not, and I do notice that one of the things that's been lost since last session is a sense of humor, since I'm having to wear my jacket in here.
And Mr. Let me interrupt you for the benefit of those listening. Mr. Openshaw is a citizen who frequently testifies and professes that he is not a lobbyist. I just wanted to make that clear.
Not
good to see you.
lobbyist.
Thank you for being here. Go ahead.
Anyway, yeah, I want to testify on this bill because it's something I've been looking for over 4 years, because I'm a data hack. I was a data hack for 30 years before I recently retired. And it just made no sense to me that there's a situation where you have an individual who may have an affidavit saying they're not a citizen here, and then they sign another affidavit saying that they're a voter here. Now, those are conflicting affidavits. And so somewhere a law has been violated, whether intentionally or not. And it's just a matter of matching the data. I mean, this is something I would do if given the data sources in a week, and be able to provide to the counties to address those issues. And it's simple. I don't expect that they'll find much problem with this, but whatever problem it is, it's a very simple one to address, and then it'll be up to the counties. My concern there, of course, is that it's up to the counties, and there are some counties, as we well know right now, that are not interested in prosecuting all sorts of laws. And so, again, I don't know what the legislature can do about addressing those aspects that are coming up that are not only have to do with election law, but other laws in terms of theft, shoplifting, and the like. But the people have a right to have a clean voter list. They have a right to have a clean vote. They have a right to have their laws prosecuted to the extent that they need to be. So, but this one's simple. I ask you guys to support it. I don't see how anybody could actually oppose it, because it's conflicting affidavits from an individual. Thank you very much. Any questions?
Mr. Openshaw, thanks for your testimony. Members, any questions for the witness? Thanks for being here. You're excused. The chair now calls James Slattery. There's Ms. Slattery. Welcome. Just get situated there and take your time, and then introduce yourself, tell us who you represent, and begin with your testimony.
Thank you for having me. I'm James Slattery. I'm a senior staff attorney with the Texas Civil Rights Project. Thank you for the opportunity to testify against SB 155. I wish to express great concern about several aspects of the current bill. Sections 2 and 3 would require county clerks to send a list of those who have been excused from jury service for lack of citizenship or lack of county residence to the Attorney General for an investigation without any evidence at that point to suggest that these individuals have actually committed a crime. It is not a crime to be on the voter rolls with an out-of-date address. It is a crime instead if the person lied about their address at the time they registered. Because voters sometimes forget to cancel their old voter registration until an imminent election prompts them to do so, the overwhelming likelihood is that most individuals referred for a criminal investigation under this bill will have simply just not yet updated their registration. Further, there are important safeguards missing in the bill. For instance, the bill does not require the clerk or the attorney general to check whether the individuals being referred for investigation register to vote after being excused from jury service and after obtaining residence or citizenship, which would make them eligible voters despite the jury excusal. Further, the information forwarded to the Attorney General is less than what is necessary to establish even a so-called weak match to a specific voter registered in the county. Similar efforts to match voters on the rolls to lists developed by non-election agencies have often led to disaster in Texas, most recently with the 2019 voter purge. Without more stringent protections, the bill risks another costly debacle for the people of Texas.
Ms. Slattery, thanks for your testimony. And Senator Safferini has a question for you. Senator.
Thank you. Do you know how current law treats persons who register in a county in which they don't reside, for example, college students?
who are registered in a county in which they don't reside.
For example, college students.
Right. So a voter has to be registered where they reside. So if they, for instance, change their address, they move from where they grew up, and they were registered to vote there. When they go to college and they now consider themselves to be residing there, they need to update their voter registration, either through a new voter registration if it's in a new county, or merely updating their old registration if it's within the same county.
So that would impact their listing on the voter list and the jury list.
Yes. Also, the jury list comes from two sources. It comes from the voter registration list, but it also comes from DPS. So the list that feeds into this one being referred to the Attorney General for investigation includes people that come from DPS who are not necessarily even registered.
Do you know what protections are in place for people with the same name? For example, a man who does not use the suffix senior, or a man who does not use the suffix junior?
Yes. So the Secretary of State has promulgated, in particular in the context of deceased voters, a delineation between strong and weak matches. And in that context, for instance, a weak match would require more than SB 155 requires, which only requires a name and address. But a weak match would be name and usually either date of birth or social security number, which is heightens the chance that we are not misidentifying a voter.
Okay. Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator Safferini. Members, any other questions for Mr. Slattery? Thanks for your testimony.
Thank you.
The chair now calls Ed Johnson, or recalls Ed Johnson, and closer this time. Mr. Johnson, welcome back. How did it go this time as far as getting in here and being ready to testify?
Much better. Thank you very much. I didn't have to go up and down the stairs 3 times.
Thank you for helping us with it. Welcome back. Introduce yourself and proceed with your testimony.
Ed Johnson. I'm with the Harris County Ballot Security, Republican Party Ballot Security, and also spent 20 years working in elections. I was the director of voter registration under tax collector assessor Paul Betancourt many years ago. So I know quite a bit about this. This is a great bill. It helps Texas actually become more compliant with the Federal Voter Registration Act. That act requires all states to have an updated, accurate voter roll. And that's what this bill would do. It helps you update and make sure your voter roll is accurate. What is being added in this bill is not going to cancel any voter registrations at all. It's actually going to help people get registered. When you say that you no longer live at that address, what's going to happen in Texas election code is you will send them a confirmation notice. They will then be updated to wherever their new residence is and be registered to vote there, so when the next election rolls around, they can actually vote where they live. It is a great tool for voters here to help make sure we have a clean, accurate voter roll. The second part, where he's adding the AG into this process, is really good. It helps people, more particularly with if they're dead or non-citizens, make sure the voter roll is cleaned of that and make sure that the counties are doing what they should do with the election code. There were a lot of inaccuracies in the previous testimony that referred to that, but this bill helps register voters and helps make sure the roll is clean according to federal law.
Mr. Johnson, thanks for your testimony. It looks like Senator Hall may have a question for you. Senator?
Thank you, Mr. Chairman. Yep, Mr. Chairman, I've been an election judge, I've been a poll watcher, and I've observed a number of people that come in with a problem because they think they're registered one place and they show up to vote in another. I agree with what you said. This is a bill that not only gets us in line with the federal law, but also helps the people to make sure that they end up going to the right place and not end up with a provisional ballot or with a limited ballot that you see quite often.
No, this is a good tool to help with that. It would make sure that you're registered, when you come up to that big election, that you're registered where you live so that you don't have to drive and maybe move to Dallas. Well, on election day, under Texas code, you would have to drive back to Houston where you were registered if you were registered there before, and you wouldn't be able to make it to vote. So this helps people actually get the right to vote.
Right. Thank you.
Thanks, Senator Hall. Members, any other questions for Mr. Johnson on this bill? Thanks for your testimony.
Thank you.
The chair now calls Ken Moore. Ken Moore testifying for Senate Bill 155.
Good morning, members. Thank you for this opportunity to speak for this bill. I'm still kind of getting my sea legs on this. It's been a while since I've testified in front of one of these committees, and I had to do the paper chase also up and down the stairs to find out where to go.
Well, thank you for going to the trouble to be here, and just relax, and we're glad you're here. Go ahead and introduce yourself, tell us who you represent, and go ahead.
Okay. Again, my name is Ken Moore. I am currently serving as the chairman of the Ballot Integrity Committee for the Missouri County Republican Party. I did not put that on the card, but I handed it in a while ago because I'm not here representing the party. I'm here representing myself and the experience I've had. I have been involved in elections for the last 10 years in one capacity or another, mostly as a presiding judge, but quite often as an alternate judge. We are citizens of this country, and we are the ones who eat the food here. We're the ones who drink the water, who breathe the air here. We're the ones who pay the taxes. We're the ones who send our children to the schools. It should be up to us, the ones who have to live under the system, to choose our representatives. Outsiders should not have this. Even if you're not talking in the context of people who are here from other countries, even if you live in one county, you cannot vote in and have property in another county. You cannot vote in that second county. It is your choice to have property in that county, and yes, you'll be amenable to the taxes and all the regulations that go with it. This bill closes what can be a very big loophole for people to come into the back door and vote in our elections who have no stake in our government. And I very much urge you to pass it. It may be argued that this is not much of a problem, but this morning when I left my house, even though I lived in a good neighborhood, I locked the door before I walked out. And I'm asking you people to please lock this door. Thank you very much.
Thank you for your testimony. Senators, any questions for Mr. Moore? Thanks for being here. Now, those are all the witness cards we have, so I'll ask if anyone wishes to testify, anyone else wishes to testify on, for, or against Senate Bill 155. Seeing none, I will close public testimony. The bill will be left pending at this time. The chair now lays out Senate Bill 247 and recognizes its author, Senator Perry, to explain the bill. Welcome back, Senator Perry.
This will be my last one, guys. Thank you, members and Mr. Chairman, for hearing these today. First Amendment of the United States Constitution states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This bill is a preemptive action to address the current cancel culture growing attacks on freedom of speech and the expression of religious beliefs. The American Bar Association, or ABA, created a model rule for state bars to adopt that would limit the free speech of many lawyers of their faith. Here in Texas, the State Bar has discussed the rule but has not adopted it as of today. It's my understanding many states have not adopted it as of to date. Therefore, the bill seeks to ensure that no person is hindered from seeking a law license or risks threat of losing their law license based on the practice of their faith. Senate Bill 247 prohibits the State Bar from adopting any rule, policy, or penalty that unreasonably limits a person's exercise of religion. The bill does not permit an individual to violate any federal or state existing law. If a person comes from the state before the State Bar based on their speech or conduct, this bill provides a defense to losing their license as long as their speech or conduct is based on sincerely held religious belief. This bill does not protect a person from being fired, sued, or arrested. It just provides a defense from losing their livelihood through their loss of their law license in practice of their sincerely religious held beliefs.
Senator Perry, thank you. Members of the committee, any questions for the author on Senate Bill 247? Very good. We'll open up public testimony on Senate Bill 247, and the chair calls Jonathan Sines, Esquire, president of Texas Values, testifying for the bill. Mr. Sines, welcome back.
Good morning, Mr. Chairman, members of the committee. My name is Jonathan Sines, and I'm president and attorney for a nonprofit Christian organization called Texas Values. I am here to speak in support of Senate Bill 247. I have been honored and grateful to be a member of the State Bar of Texas since 2003, for over 17 years. And for over the past 15 years, a large amount of my work has been focused on constitutional rights, specifically free speech and religious liberty. And during that time, I've continued to see growing attacks and pressure against people of faith, including members of the bar. Now, I started my study of law with the hope and the dream and the desire to protect constitutional rights and specifically religious liberty, because I heard of attacks on people of faith, particularly Christians. And I've seen over the years how those attacks have grown. And now that I've focused my work in this area, not only do I hear members of the bar that don't practice in areas of religious liberty talking to me about their concerns, I at times feel concerned about my own ability to do the work that I do, which is defending people of faith. And oftentimes they don't talk a lot about it publicly. But because of some of the court cases and trends in other parts of the country, you hear people and you see pressure from our own state bar to really put a target on people of faith, particularly Christians, because of their beliefs on issues related to marriage, sexuality, and life. There can be disagreement when it relates to constitutional rights and religious liberty. We're not always going to see things the same way. But as a member of the bar, we should be able to be in that position to stand up for members, other members of the bar, and for them individually to not feel like what they do on Sunday and say on Sunday as a leader or a member of their church cost them the right to do what allows them to practice their livelihood on Monday. And with that, Mr. Chairman and members of the bar, we testified against this rule at the State Bar 8.4G, and so did many others. And it's because of activity like this in our state, this law is needed now. Thank you.
Mr. Sines, thank you. Senators, any questions for the witness? Very good. Thank you for being here. The chair now calls Holt Lackey, Equality Texas, testifying against Senate Bill 247. Mr. Lackey, there we go. Welcome. Mr. Lackey, you're welcome. When you get situated, introduce yourself, tell us who you represent, and proceed with your testimony.
Thank you, Mr. Chairman, members of the committee.
My name is Holt Lackey. I'm an attorney in Austin and chairman of the board of Equality Texas, a nonprofit working to secure full equality for lesbian, gay, bisexual, transgender, queer, intersex, and asexual Texans. I'm testifying against SB 247 because as a licensed attorney, I feel strongly that my Texas bar card should not be a license to discriminate. The legislature should not create special rights for lawyers to engage in forms of harassment and discrimination that are generally prescribed in other professions. ABA Model Rule 8.4G, which has not been adopted in Texas, but ostensibly inspired this bill, proposes that lawyers should not, quote, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status. Even if this proposed rule were adopted, it would not require any lawyer to change his or her beliefs or good faith advocacy. It would require refraining only from harassment or discrimination. That is to say, it would require only basic decency and professionalism. There is no epidemic of attorneys being disciplined for any form of speech. The only people who would be protected by this bill are the likes of Jason Van Dyke, a Texas attorney and former leader of the Proud Boys, who had his license suspended for threatening to kill a man he was suing, and who admitted to threatening to kill a, quote, effing N-word, close quote, on Twitter. Mr. Van Dyke did not use the abbreviations. He was appropriately suspended from the bar for that conduct. He does not need a new special defense applying only to lawyers that would allow, when the Religious Freedom Restoration Act and First Amendment already cover what this bill purports to provide.
Ms. Lackey, thank you. Senators, any questions for the witness? Thanks for your testimony. You're excused.
Thank you, Mr. Chairman.
Chair now calls Gregory McCarthy, testifying for Senate Bill 247. Mr. McCarthy, make your way down. Welcome. Please introduce yourself. Tell us who you represent and go ahead with your testimony.
Yes, howdy. Good morning, Chairman Hughes and members of the committee. My name is Greg McCarthy, and I am the Policy Associate for Texas Values Action. I'm here to testify in favor of SB 247, and I will say as a side note, this is my very first time ever having a public testimony, so I think this would be a very appropriate bill for me personally to have my first testimony because this bill protects what I would like to do with the rest of my career. Just this past December, I graduated the University of Texas here in Austin, and this fall, I will start my first semester of law school. As an inspiring lawyer dedicated to preserving religious liberty for all Americans, I pose a legitimate and sincere concern about the implications of not passing SB 247 and how you should. It is my own personal relationship with God and not hateful discrimination that has placed the burden and calling on my life to protect religious liberty and ensure that future generations of Texans and Americans will have the freedom to experience the joy of living for God. I know God has his own plans for me, but Lord willing, I will one day argue a religious liberty case before the Supreme Court. Recently, in our government, there has been a steadfast resilience to impose gender identity and sexual orientation. Initiatives like this, if signed into law, would bring danger to the religious beliefs of many Christians. As someone who deeply believes biblical views, I'm concerned that those who do not agree with me on my beliefs may try to cancel me. After 3 years in law school and the passage of the bar exam, I could be denied obtaining a law license here in Texas because of my sincerely held religious beliefs. I hope my very personal testimony you are able to understand how SB 247 represents a clear necessity and legitimate applicableness. My testimony exemplifies how average Americans, as myself, hold sincere religious beliefs that may be in danger if not protected. So Texas protects and upholds religious liberty, and so I implore you to do the same in passing SB 247. Thank you.
Mr. McCarthy, thank you for your testimony. We're proud that this was your first testimony offered before a committee. We're glad to have you here. In the fall, what law school do you plan on attending?
So actually, March the 15th, I'm going to submit my applications. And so we'll see from a month in, but I'm definitely going to law school this upcoming fall.
So Senator Bardwell says that the chairman should ask tough questions of a first-time question. So I'll ask, so what's the best law school in Texas that you could go to if you were going to?
Well, you know, especially with constitutional, I mean, I am a Texan, so hook 'em right there. But, you know, Texas really has a good law school, but really I'm going to a law school that would really help with religious liberty. Yeah.
No, thanks for your testimony. Thank you for being here. Members, any other questions for the witness? Thank you very much. The chair now calls Ash Hall, testifying against Senate Bill 247. Ash Hall, make your way down here and we'll make the place ready for you. Welcome. Please get situated, introduce yourself to us and tell us who you represent, if anyone, and give us your testimony.
It's good to be back. Hello, and thank you for having me. My name is Ash Hall. I represent myself, and I'm testifying against this bill. So, first of all, what needs to be taken into account here is that if lawyers are given this option of religious refusals, it's probably not going to affect somebody like me who lives in Austin, who has many, many options for what kind of legal representation I could get. But when we start moving away from big cities and looking in rural areas where the population dwindles and perhaps the politics or the religious beliefs start to change as well, that becomes a really big problem for LGBTQ Texans in those areas, religious minorities in those areas, and other folks who may not have access to anybody else. I don't think that one's zip code should determine whether or not they're able to get legal representation in this state. Everyone deserves that. That's a basic right that folks should have. So that's my first issue with this. The other thing that I think about is that I am surrounded on a constant basis by lawyers, and they all have stories about clients they've represented who either made them a little bit uncomfortable or who they didn't necessarily agree with as people or who maybe did have a different religious affiliation than them, but they speak about it with a sense of pride because every single time they did that, they learned something and they became better lawyers for it. As somebody who is also considering perhaps becoming a lawyer myself, I think those kinds of experiences are important and they make the legal profession stronger and more noble. Our nation, I think we all can agree, is spiritually kind of broken right now in need of healing. If we're not willing to help each other, regardless of who that person is, we're not going to heal. Thank you for hearing me out.
Thanks for your testimony. Senators, any questions for the witness? So, in the interest of consistency, since you mentioned going to law school, what's the best law school in Texas that you might want to go to?
I think it's got to be UT.
Okay. Well, I'll just say, respectfully, there's one practicing lawyer on this committee who did not, and that's not the law school he went to, but that's okay. You guys both had the same answer, so it won't hurt the bill or help the bill. So thank you. No, and thank you for your testimony. We appreciate you being here. Thank you very much. Chair now calls Jeffrey Morgan. Jeffrey S. Morgan. We should quit while we're ahead, Senator. You're right. Ms. Morgan, welcome. When you get situated, introduce yourself, tell us who you represent, if anyone, and offer your testimony.
Thank you very much. My name is Jeffrey Morgan. I am from Dallas, Texas, and I am representing myself. I wasn't planning to testify on this bill, but now that I've heard about it, I would like to do so. In our Texas state constitution, we have freedom of worship, and it says no human authority ought, in any case whatever, to control or interfere with the rights of conscience in matters of religion. And this is something that also needs to extend to our attorneys. They should be able to exercise their rights of conscience. It's very interesting because with some of these things that were being talked about, if you look at the State Commission of Judicial Conduct, they issued a public warning to Honorable Diane Hensley because she refused to perform a same-sex marriage. Now, if you look at our Texas state constitution, the Texas does not even recognize this type of a union as far as marriage is concerned. If you look at the Texas Family Code, this is forbidden, but she was given a public warning because out of her dictates because she was obeying her conscience, her sincerely religiously held beliefs, and she gave other options for them. There were other judges around. She gave options of people who would do it, but she could not do this. This is a very important issue that our attorneys need to be able to exercise their freedom of conscience. Just because you become an attorney or a public official, you should not have to abandon this very sacred right in our Texas state constitution. There is a difference between the U.S. Constitution as far as the First Amendment and the Article 1, Section 6, and there is a Justice, Kem Thompson Frost, in 2001 wrote about this issue, said that the federal Constitution is negative. It prohibits certain things. The Texas state Constitution actually says you must take affirmative actions to protect the person's religious rights. So I stand for this bill, and for those people that would think otherwise, they have other options. That's ridiculous. It's actually that they're trying to force a person to violate his or her conscience. I'll be glad to take any questions.
Ms. Morgan, thanks for your testimony. Senators, any questions? Right. Thank you for being here. You're excused.
Thank you.
The chair now calls Stephen Rudner. Stephen Rudner says testifying against Senate Bill 247. Mr. Rudner, we'll have you ready in just a moment there. Have a seat, introduce yourself, and offer your testimony. Welcome.
Thank you and good morning. My name is Steve Rudner. I'm an attorney from Dallas, here to oppose this bill, which strikes me as a solution to a problem that does not exist and an attempt to go out of our way to declare Texas to be a state which is prejudiced against members of the LGBTQ and other minority communities. I believe the bill that you're considering would have, most certainly have, unintended consequences, which would have significant negative impact to the practice of law in the state. And allow me to explain. I graduated from the UT Law School, the best law school in the state, 34 years ago. I founded my own law firm in Dallas 26 years ago. Our firm has a unique specialty. We represent hotels and resorts all around the world. And as a result, lawyers in our firm practice in courts throughout the country. We accomplish that in two ways. I'm a member of the bars, in addition to the State Bar of Texas, of New York, Colorado, Arizona, and the District of Columbia. Other members of my firm are licensed in California, Florida, and other states. I was not required to take the bar exam in the District of Columbia or in Colorado because they extend reciprocity to Texas lawyers. In many states, our law firm retains local counsel, and we're permitted to practice in those courts for purposes of a single case on a pro hoc vice basis, a courtesy that those state courts extend to us. Based on what we've seen sister states do to various laws which have been perceived to be discriminatory adopted by this legislature, it seems very clear to me that some of those sister states would, should this bill be passed, withdraw their reciprocity and not allow Texas licensed lawyers to waive into a case or to make it more difficult for Texas lawyers to appear in their courts for the purposes of a single case. This would have a devastating impact not only on law firms like mine, but also on the biggest law firms in the state. I also oppose this bill because it spits in the face of the best and most honored traditions of the practice of law. In To Kill a Mockingbird, Atticus Finch defended an innocent man who no one else would defend because he knew it was the right thing to do. It doesn't take much imagination to imagine, in the wake of September 11th, a lawyer refusing a Muslim client. In today's environment, a lawyer refusing an Asian American client. It doesn't take much imagination to imagine a lawyer turning away an LGBTQ client. This is discrimination that we don't need, and there is no issue that justifies the adoption or even consideration of this bill.
Ms. Rudner, thanks for your testimony. Senator Zaffarani has questions for you.
Yes. Could you explain how passing this bill would hurt reciprocity between states regarding licensed attorneys?
Sure. Well, I'm sure that you recall, Senator, that in response to legislation that was adopted either in the last session or the one prior related to the state funding of child welfare agencies that were allowed to discriminate in regard to the placement of foster children with LGBTQ families, other states like California banned state travel to the state of Texas. That was their reaction. Several states did the same. The states which allow reciprocity, which allow Texas lawyers to become members of their bar, do that as a courtesy. They're not obligated to do that. And so I feel very confident that those bars, several of those bars, the New York State Bar as an example, would look with some very deep concerns the adoption of this, and it's within their discretion to say that they would no longer extend that reciprocity. And the same exists not only for admission to their bar, but also to admission to the courts of their state for the purposes of a single case. And if that were to happen, it would affect, obviously, interstate commerce and have a significant negative impact on the practice of law here in Texas.
Thank you, sir. Thank you, Mr. Chairman.
Thank you, Senator. Members, any other questions? And Council, I have a question along those lines as well, and thank you for your testimony. I practice law. I'm licensed only in Texas. I do from time to time handle matters in other states and admitted pro hoc vice to do that. And so I was going to ask the same thing that Senator Zaffarini asked. I understand the hypothetical. Are you aware of any case in America where a state bar has refused admission, either pro hoc vice or reciprocity, to a lawyer from another United States state? I'm not. I'd like to know if there is one.
Well,
let's don't leave anything unclear.
Sure. I'd say two things. I don't think that, I think we have just seen, as I indicated, what other states have done to Texans in response to legislation that those other states perceive to be discriminatory. I don't know why that wouldn't extend to bar admissions. But to answer your point more specifically, it's a great question, Mr. Chairman, and I say this with all due respect. The answer to the question is, I don't know of any such case, but nor do I know of any case of a lawyer here in Texas who was forced to represent a client that they didn't want to represent or who was not allowed to speak their mind. And so if my hypothetical is a bad one, it's equally as bad as the bill that you're being asked to consider. There is no lawyer that's being threatened in any way for his or her beliefs.
I think Senator Zaffarini has another question for you, then we'll go to Senator Powell. Senator Powell, you go ahead.
Mr. Rudner, would you suggest then that this is a potential vehicle bill rather than a direct attack?
Absolutely. Absolutely. So, for example, in the city of Dallas, we have a non-discrimination ordinance, and I operate a business, my law firm there, and if I were to turn away a client for any reason in violation of the non-discrimination ordinance, I would be subject to penalties in the city of Dallas. I don't know how you reconcile this bill with the cities that have non-discrimination ordinances. I think there are a variety of unintended or perhaps intended consequences that would flow from this bill.
Thank you.
Thanks, Senator Powell. Senator, any other questions for Mr. Rudner? Thanks for being here. Thanks for your testimony. You're excused.
Thank you.
Chair now calls Jonathan Covey, testifying for Senate Bill 247. Mr. Covey, there's Mr. Covey. Make your way down. Mr. Covey, welcome. Please take a seat, introduce yourself, tell us who you represent, and offer your testimony.
Thank you, Mr. Chairman. Good morning, and members of the committee. My name is Jonathan Covey, and I'm the Policy Director for Texas Values Action. We are the largest organization in the state of Texas for faith, family, and freedom, and we have over 100,000 supporters in all 254 counties. And I am here to testify in favor of SB 247. As you are aware, this bill protects against dangers to religious freedom from policies such as the American Bar Association Rule 8.4G, and this rule would make it professional misconduct for a lawyer to engage in conduct related to the practice of law that he or she should reasonably know is harassment or discrimination on the basis of 11 different categories. However, since ABA Model Rule 8.4G was promulgated in August of 2016, the United States Supreme Court has issued two major free speech decisions that seriously call into question the constitutionality of the rules restricting professional speech. One is National Institute of Family and Life Advocates v. Becerra in 2018 that has to do with state restrictions on professional speech that are presumptively unconstitutional and subject to strict scrutiny because they are content-based restrictions on speech. The other is Mattel v. Tam. In 2017, a federal law that prohibits trademarks for disparaging speech and is unconstitutional viewpoint discrimination or viewpoint restrictions on speech, and that cannot survive strict scrutiny. Rules such as the ones prohibited by this bill raise a number of sticky and tricky scenarios and potentially burden a lawyer's ability to maintain licensure. For example, is a lawyer subject to discipline for discussion of hypotheticals while presenting a continuing education course or a CLE course? Is a lawyer subject to discipline for participating in panel discussions touching on controversial political or religious or social viewpoints? Or is a law professor subject to discipline for a law review article or a class discussion that explores controversial topics? So we think this bill addresses those issues, and those scenarios would be in danger, and we appreciate Senator Perry's sensitivity to this issue. Thank you.
Ms. Covey, thanks for your testimony. Senators, any questions for the witness? Thank you, Ms. Covey. You're excused.
Thank you.
Anyone else? I'm sorry, we do have some resource witnesses, and so we'll call these folks if we need them. So, Senators, for your benefit, we have resource witnesses from First Liberty Institute, from the State Bar of Texas, and from the Attorney General's office. Does any member of the committee or Senator Perry wish to have the resource witnesses come?
No, I don't need a resource witness. I'll just
Very good.
comment to get out.
So we'll, if there's anyone here wishing to testify on, for, or against Senate Bill 247, hearing none, we'll close public testimony and recognize Senator Perry.
Yeah, members, I want to leave you with a couple of thoughts. I'm a man of faith. I fell woefully short every day. But it is not determined by my zip code, where I choose to exercise that. We're not called to leave it at home when we close the door behind us. We're called to a great commission to spread the truth. So first of all, it is about a fundamental value that we are unique in the world on, and it's clearly delineated in our Constitution. Secondly, the most chilling impact, if this goes to fruition, this ABA rule or rules like it or policies that are being discussed, when you remove a person of faith in the only civil process our society has established to defend that faith, you purge that person from that for fear of losses of licenses or taking of those licenses to defend their faith and those that think of faith, then you create a void in the system that can only be filled with no good. So as we talk about these issues, whether they're needed or not needed, when you purge the Christian attorney, or for that matter, any person of faith that may have different value systems or different perspectives than what seems to be a loud voice today, you leave a very big gap that we will pay horrible, horrible consequences for long term. So that's the real consequence here, is when you shut out the legal profession from people of faith being able to defend their faith, as well as those people that believe in their faith and exercise that, you create a void that can only be filled with problems. So that's the real consequence, and that's really where the path we're on today if we don't let these kind of bills get through the process to protect. First of all, is only a defense for threat of licensure. It doesn't mean you can't have that conversation about taking my license, but it establishes a clear and definitive defense in that license based on my sincerely religious held beliefs in defense. Thank you.
Senator Perry, thank you. Senator Campbell
Senator Perry.
has Senator Perry. Senator Campbell has a question for you.
Thanks.
I think.
And I'm sorry I missed the layout. I think it's a good bill, but I think some of our witnesses got off on a different track. This is not a bill about which cases an attorney picks up. This is a bill that addresses whether or not an attorney or somebody applying for their license or already has a license might be denied that or it taken away because of their own personally held beliefs.
That is correct.
So it's not about, when they were talking about cases, it's not about that. This is actually protecting attorneys. This is a bill that's protecting lawyers.
Correct. It's a defense of people of faith, whether you're an attorney or not.
Correct.
That's where the principle stands.
And it's defending, excuse me, what somebody holds dear, their whether it's religion, in this case specifically religion. So I agree with you 100%. I just wanted to make it clear that this is something that actually protects lawyers and it protects their right to hold a sincere belief and that their license cannot be taken away because of what they believe.
Correct.
Thank you.
Thank you.
Thank you, Mr. Chairman. Thank you, Senator Perry.
I'm sure it's probably not going to get full vote on this one, so I won't ask that it goes to local and uncontested. Thank you, Mr. Chairman.
Questions? Senator Perry, thank you very much. And the Anyone else? I know we've already closed public testimony, but just to make sure, because folks are kind of in and out, anyone else wishing to testify on for or against Senate Bill 247? No. I'm glad I asked.
Forgive me, Senator. I have not testified here before. I'm from First Liberty Institute. I did submit my written comments. I checked the box as a resource simply because we're a neutral party, didn't want to advocate for or against. My comments have been submitted with Ms. Corkle. I'm happy to say them here as well, but I want to be a resource too.
So for the benefit of the committee and the record, tell us who you are, who you represent, even though I know, and then go ahead.
Yes, sir. I'm Jeremy Dice. I'm special counsel to First Liberty Institute. We are a nationwide religious liberty legal organization dedicated exclusively to defending religious liberty for all Americans. Members of the Texas State Bar Association are subject to regulations governing their professional conduct. While it is appropriate to ensure professional conduct, no licensees should be subject to regulations that negatively curtail their civil rights, including the right to the free exercise of religion, free speech, and the freedom of association. SB 247 makes that clear, that Texas, the state of Texas, may not limit the civil rights of members of the Texas State Bar. And Justice Thomas explained in Nifla versus Becerra, quote, "As with other kinds of speech, regulating the content of professional speech poses the inherent risk that the government seeks not to advance a legitimate regulatory goal, but to suppress unpopular ideas or information. Just as doctors require the freedom of candor to help patients make informed decisions, attorneys must be afforded the freedom of speech to zealously advocate for their clients. But if the state is able to regulate professional speech, as Justice Thomas explained, it would have, quote, unfettered power to reduce a group's First Amendment rights by simply imposing a licensing requirement. Further, curtailing the civil rights of bar members would restrict the guarantee of free exercise, stifling debate by lawyers for fear of disciplinary reprimand. Worse, it could prevent access to legal counsel altogether. As just one example, First Liberty Institute recently represented the law firm of Brenna, Bell, and Clarkson, PC in Anchorage, Alaska, which represented the Downtown Hope Center, a religiously affiliated women's shelter accused of violating Anchorage's non-discrimination policy for preventing a biological male self-identifying as a female from residing at the facility. After local media outlets published stories about the case in which their attorney was quoted, the Anchorage Equal Rights Commission filed charges against the shelter's law firm, forcing him to withdraw from representation. Had we not intervened to reverse those charges, the Regulatory Commission would have deprived this nonprofit's women's shelter of one of the hallmarks of our republic, the right to counsel. Finally, the proposed regulation of lawyers in some jurisdictions could restrict a lawyer's freedom to associate with a number of political, social, or religious organizations. Again, as the U.S. Supreme Court noted in Roberts versus USJC's, implicit in the right to engage in activities protected by the First Amendment is a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. So permitting the state bar to institute discipline against one of its members for membership within a faith-based organization, whether that would be a church or a group like the Christian Legal Society, that goes against the very fabric woven into our republic. Finally, Senate Bill 247 protects the freedom of lawyers in the state of Texas to engage in rigorous debate over matters critical to our fundamental freedoms, our economy, and our health. Thank you. I've taken up a lot of your time. I'm happy to answer any questions and be a resource to you if I can be so.
Thank you for your testimony. Senators, any questions for the witness? Senator Campbell.
The acoustics are, welcome. The acoustics are a little hard in here, so if you said it as you were
I was speaking fast, Senator. I'm sorry.
So have you seen cases where attorneys have come under attack, lost their license, or because of their religiously held belief?
Yes, ma'am. That was the example I provided, and forgive me for speaking fast and loudly within the acoustics here. Yes, ma'am. In the state of Anchorage, or in the state of Alaska, in the city of Anchorage, Alaska, the Anchorage Equal Rights Commission actually did discipline a lawyer for representing a group called the Downtown Hope Center, which was a women's shelter. They had been accused of violating the Equal Rights Commission ordinance up there as well. That attorney, because he was advocating for his client, when the press inquired about that case, was brought up on charges himself. And the law firm themselves were almost, on the verge of losing their own license to practice law in the state of Alaska for advocating a position that their client held. And so we were able to intervene, thankfully, and reverse those charges, and thankfully that law firm remains active today. But yes, ma'am, we are seeing that as a concern.
And you are for the preemption that this bill provides?
Look, I think the bill is written correctly and well and applies a very tried and true standard that we borrow from TRFRA. Also, the federal RFRA has worked in this state since the year 2000 as well as beyond since 1993.
Thank you very much. Thank you, Mr. Chairman.
Thanks, Senator Campbell. Members, any other questions for the witness? Thank you very much, Counsel.
Thank you, Senator.
Anyone else wishing to testify on, for, or against Senate Bill 247? Seeing none, public testimony is closed, and the bill will be left pending at this time. In a moment, we're going to lay out Senate Bill 26 and also Senate Joint Resolution 27. Everyone who's here to testify on SJR 27 is also registered on 26, and so we'll allow the authors to lay their bills out, then we'll take the testimony together. Now, because we can't get everyone in the room at the same time, we'll take this testimony in panel. So as the authors make their way, we'll have Senator Paxton with SB 26 first. As the authors make their way down, I'm going to ask the following witnesses to make their way into, oh, I'm sorry. So hold tight if you're a witness. Don't come yet. Okay, if you're a witness, hold tight. We're going to call you down in groups because we can't get everyone in here at one time. So if you're a witness on one of those two, hold tight until we call you down. I apologize for the confusion. We'd love to have you all down here, but the protocols won't allow it yet. So we're going to call you down in panels. Everyone's going to get to testify. So we'll ask the following people to make their way down: Jonathan Covey, Kathy Turner, Brother Bob Long, Sean Adair Hall LaCour, I'm sorry, forgive me. And then Hanoi Avila. So we'll ask those folks: Jonathan Covey, Kathy Turner, Reverend Bob Long, Sean Adair Hall Lacuna, and Hanoi Avila, to please make your way into the Senate chamber, and then we'll be calling our witnesses in panels or in groups like this. So with all that, Senator Paxton, thank you for your patience. The chair now lays out Senate Bill 26 and recognizes its author, Senator Paxton, to explain the measure.
Well, thank you, Mr. Chairman and members. Certainly, many lessons have been learned as we've all observed and been engaged in responding to COVID across both the country and across the great state of Texas by government, businesses, communities, and individuals. One area of concern has been the use of executive orders that limited religious assemblies and activities. Some of those executive actions, along with judicial decisions related to the interpretation of those actions, has revealed a need for us as a legislature to take action to clarify and ensure the right of worship, the right to worship and assemble in the event of future executive orders in Texas. And members, I do have a committee substitute that I wish to lay out. Senate Bill 26 seeks to protect freedom of worship by preventing future across-the-board closures of churches, either statewide or within specific geographic regions, through the exertion of emergency powers. SB 26 simply extends the existing Texas Religious Freedom Restoration Act, RFRA, to protect places of worship from being categorically closed by executive order. And it ties into the existing legal mechanisms for protection of religious freedom. The existing Texas RFRA law provides a waiver of sovereign immunity, a private cause of action, and also the ability of government to cure an executive action, order, or ordinance within 60 days of receiving written notice of a violation. Senate Bill 26 specifies in the application of this chapter of law that the RFRA statute cannot be considered a regulatory statute by an executive order, and it cannot be suspended or waived by executive order. The committee substitute simply makes this bill a legislative council draft. And in closing, I would simply remind us all that this legislation is simply and beautifully tailored to protect freedom to assemble in places of worship, to practice faith, from future orders issued under emergency powers by amending the Religious Freedom Restoration Act. And I respectfully request passage of Senate Bill 26.
Senator Paxton, thank you for that explanation. Members, any questions for Senator Paxton? Senator Campbell.
Thank you, Chairman. It's not really a question. I just wanted to make the comment. I think this was needed. Happy to have joint authored with you on this bill. And, I think it's timely. We needed it. So thank you very much. Thank you, Mr. Chairman.
Thank you.
Senators, any other questions for the author at this time? Senator Hall, go ahead.
No, I commend you on this bill. It's a good bill. It's overdue. Wish we'd have had it this past year. But in light of some of the things that we see happening around, maybe we should consider this moving it up to a constitutional amendment. So to provide real protection in the future. As things are changing, I think this is one of the most important things we have to do here in our legislature is to protect our religious freedoms. And as we are seeing that there are those who are coming after it very hard. And so maybe we should just a thought that we consider moving this up with a constitutional amendment to make sure it's preserved for future generations.
Well, thank you, Senator Hall, and I appreciate your support, also you, Senator Campbell, and it is certainly at the center of what it means to be an American and to be a Texan, regardless of any specific person's faith, that we protect everyone's freedom to assemble in places of worship, to engage in religious activities, and to worship together. Thank you.
Senator Paxton, thank you. And Senator Paxton explained to us that she has a committee substitute, which makes a conforming legislative council draft. Senator Birdwell sends up the committee substitute. Is there objection to the adoption of substitute? Hearing none, the committee substitute is adopted. Senators, any other questions for Senator Paxton on this bill? Great. And Senator Paxton, again, with your indulgence, we're going to have Senator Hancock present his joint resolution. Then we'll have testimony on both of those measures. So thank you for being here. And we're going to leave that bill open and also lay out the joint resolution.
Thank you, Mr. Chair and members.
And at this time, the chair will lay out Senate Joint Resolution 27. And good timing after Senator Hall's question, and we'll recognize Senator Hancock to explain the measure.
Yeah, thank you, Mr. Chairman. And Senator Hall, I heard your words, and so we drafted something real quickly based on that to present an SJR. On that, we do have a substitute.
Okay, Senator Bardwell sends up the committee substitute. Is there objection to the adoption substitute? Hearing none, it's before us. Go ahead, Senator.
Yes, thank you, Mr. Chairman and members. And I won't repeat a lot of the things that Senator Paxton pointed out. Obviously, they apply here as well. And as Senator Hall pointed out, having this as part of our Constitution does clarify it, and it provides clarity to literally issues that we'd like to say don't take place in the state of Texas, but we saw that in a number of counties, limiting worship. We all know that those of us that worship involves singing. Some tried to prohibit singing in places of worship. Worship involves community, a gathering of people. Some tried to limit the number of people gathered in community to 10 or fewer. And we know to abide by many of the scriptures that are represented here, that all those are commandments that we are to participate in on a regular basis. And so this would add it to our Constitution to make sure that that never takes place in the state of Texas.
Senator Hancock, thank you. Committee members, any questions for the author of Senate Joint Resolution 27? Very good. Senator, thank you for being here. And as we discussed, we'll lay out, we'll have testimony on your bill, your joint resolution, and Senator Paxton's bill at the same time. Very good. So we'll open public testimony, and we will first call Jonathan Covey. Jonathan Covey, call him back.
Thank you, Mr. Chairman.
Hold on just a moment. We're almost ready.
Yes, sir.
You're good. Thanks. Thanks, Mr. Covey. Welcome back. Introduce yourself and go ahead with your testimony.
Thank you, Mr. Chairman. It is a pleasure to be with you and the members of the committee, in particular my former boss, Senator Hall. And just wanted to tell you a good morning. My name is Jonathan Covey. I am the Policy Director for Texas Values Action. We're the largest organization in the state of Texas for faith, family, and freedom. We have over 100,000 supporters in all 254 counties, and I am here to testify in favor of SB 26 and SJR 27. As no doubt, excuse me, as no doubt many will say to you today, SB 26 and SJR 27 may be some of the single most important bills that come before this committee. Protecting places of worship from being closed by official order furthers the aim not only of the First Amendment Free Exercise Clause, but also federal and state religious freedom restoration laws. This is important because during the beginning of the COVID-19 pandemic, many churches and religious organizations were required by local order to close or severely limit their in-person attendance. Senator Hancock mentioned that word, limiting. In California, for example, casinos and liquor stores were permitted to stay open as essential, but churches were shuttered. In Texas, Harris County issued a stay-at-home order limiting religious worship to only video and teleconferencing. Cameron County, Texas, issued an order prohibiting Christian schools in the county from operating, and in McKinney, Texas, a church congregation was circled and observed by police while holding services in their parking lot. The courts have actually been very clear on this issue. Case law, which underscores the essential nature of religious organizations and their congregants, exists in abundance. For instance, the U.S. Supreme Court has said it has long recognized the importance of protecting religious actions, not just religious status. That was in Espinoza v. Montana, Department of Revenue. Last November, the Supreme Court enjoined New York Governor Andrew Cuomo from enforcing occupancy limits on religious services during the COVID-19 pandemic. In South Bay Pentecostal Church v. Newsom, the Supreme Court held that California had singled out religious activities for worse treatment than secular activities and enjoined an order by the California governor against meeting for this indoor worship. I believe that SB 26 will make it clear in statutory law that officials cannot shut down places of worship under the pretense of public protection, and that churches and places of worship are essential because faith itself is essential. Thank you, Mr. Chairman.
Mr. Covey, thank you for your testimony. Committee members, any questions for the witness? Thank you for being here.
Thank you.
Excused. The chair now calls Kathy Turner. Kathy Turner. And while Ms. Turner is making her way, let me make another announcement. And witnesses, thank you for bearing with us as we work through this process. So we're going to ask the following people to make their way to the Senate chamber so you'll be ready. So we'll ask the following witnesses to be making your way into the Senate chamber: Jeffrey Morgan, Gregory McCarthy, Mary Elizabeth Castle, Jonathan Sines, Jeremy Dyes. So, Jeffrey Morgan, Gregory McCarthy, Mary Elizabeth Castle, Jonathan Sines, and Jeremy Dyes, please make your way to the Senate chamber so you'll be ready to testify here in a few minutes. And Ms. Turner, welcome. Introduce yourself and offer your testimony, please.
Good day, Senators. My name is Kathy Conn Turner. I'm from McGregor in McLennan County, and I'm representing myself, a sixth-generation Texan and a Christian today. I'm testifying for both Senate Bill 26 and Senate Joint Resolution 27. I'm a resident of Senator Birdwell's district. A year ago, I would have never believed that our freedom to worship would be compromised by restrictions put in place by state or local executive fiat. But we have experienced that very situation. I, like many others, thought freedom to worship was an assumed part of the constitutional guarantee of religious freedom in the First Amendment of the U.S. Constitution. Worship and religious activities are an essential service, especially when people are hurting during a crisis, and as evidenced by the founding of our colonies and our nation's state of Texas. I had COVID-19. which I contracted from my husband. He died from COVID-19 related pneumonia in October 2020, so this is personal to me. We contracted the virus while we were out of state, and we did not contract the virus from a religious service, although we had been attending church regularly while we were in Texas, our home. My husband contracted COVID from a visit to a professional medical building associated with a medical system and a medical school, and this was a building that was regularly deep cleaned, had the appropriate ventilation, and observed COVID protocols. It was a so-called safe place. My husband was elderly and had underlying health conditions. Before he contracted COVID, he and I engaged in prayer and serious discussions over the matter of when to appear. We decided that the importance of honoring our God through in-person worship was necessary to obey the Bible's mandates to not forget the assembling of believers and to bring our tithes and offerings into the storehouse. Our conclusion was that we had to live our lives in a manner that demonstrated the faith we were willing to die for. And if my husband was here today, he would join me in support of SB 26 and SJR 27. I want to thank you all for the opportunity for public testimony. I want to thank the staff and everyone involved for allowing our state's legislative business to be open and the courtesies that we as plain vanilla citizens were shown, from the tents outside to the sergeant of arms to everyone involved. And I thank you all very much.
Mrs. Turner, thank you for your testimony. And my goodness, may I say to you that those plain vanilla citizens own this place, and everybody up here works for you, for us. So thank you so much. Senator Bardwell has a question for you.
Not a question, Mr. Chairman. I just want to acknowledge a fabulous constituent. Thank you for taking the time to come up and join us today, Ms. Turner. The personal experience you have, it's very important that we hear these things and able to discuss. And so thank you for joining us, just in all sincerity. Thank you for being here.
My husband would appreciate your remarks. Thank you. He does appreciate them. He hears them.
That's right. Mr. And Senator Campbell also wants to visit with you. Senator Campbell.
Just a comment. Is this your first time before a committee?
I worked for the state of Texas, and I was a resource witness occasionally, but I was never allowed to, of course, take a position.
Well, you took a position.
And I enjoy being able to be retired and take a position.
Amen.
Yes. Well, we appreciate you being here. We're sorry for the loss of your husband. So thank you for speaking for both him.
May I make a comment?
Yes, ma'am.
My husband is not lost. I know exactly where he's at.
Okay, that's a good point.
Amen. Amen.
He's got a great vacation now, praising the Lord.
Yes.
Thank you, ma'am.
Ms. Turner, we can't thank you enough for your testimony. It means a lot to us. Thank you for being here. The chair now calls for Bob Long. Bob Long, there he is. Make yourself down, and we'll get that place ready for you. And welcome.
Thank you.
Introduce yourself and tell us who you represent, and offer your testimony.
Thank you, committee members. It's good to be here. My name is Bob Long. I lead a ministry called Rally Call Ministries. I represent myself this morning, or what's left of it, or I don't know what time it is now, but I also am an active elder in several networks of Christian ministries that are all sizable. One is national, called Federation of Ministers and Churches International. There's 70 entities, mostly local churches in that. There's a statewide organization that I'm honored to serve in the leadership of, called Texas Apostolic Prayer Network. our own ministry, Rally Call Ministries, we do a training institute. I'm a born-again hippie kid from the 60s who never heard the gospel until I was 20 years old, living in the fourth generation Texas. And so there came a day when I finally heard that Jesus died for me and that he sets people free from all kinds of things. And I called on him and he delivered me overnight. Well, I'll just say it, from a couple of hundred hits of acid in the 60s culture, and I was changed overnight. And I've spent the rest of my life, and to this day, preaching the gospel. And for the last 20 years, although 40 years in ministry, the last 20 years have been training leaders, mentoring leaders, pastoring pastors. And in those roles, this issue is very, very personal and very practical to me. Especially the free exercise clause. One of the things I'm so honored about, I spent 15 trips in 14 years to Cuba while Fidel was still alive. The 10 years of that was working with illegal underground churches. One of whom, the leader, ended up in a Castro prison for 2.5 years. He is now an American citizen and he votes. And the freedom of exercise clause is incredibly important. I was director of a Bible school in Dallas for 3 years. Lots of international students who, when the pandemic hit, they were trapped in their dorms. They couldn't go home to their nations. I had classes of 70 students, all leaders, 20 nations. And one of the things I've learned, and I close with this, is that we have to be laser sharp about the clause on the free exercise of religion. The communist constitution in Cuba for 40, almost 50 years stated there's freedom of religion, but the freedom of exercise or the freedom of worship was never in there, and they use it to this day. And so I want to say that this bill is important, that we have to be aggressive, proactive, and ever vigilant, not only about freedom of religion. The present administration in D.C. has already said, using the example of COVID and the shutdowns, that he would bypass the governors if they weren't working with him, and that he would go to the county judges, and that he would go to the medical. And we've seen this all over Texas, where it was restrictions, shutdowns of activities, of the freedom of expression, of religious activities all over the state, from county issues. We've seen it limited, restricted, canceled, zoning, permits, you name it, all across the board. It was never a question of freedom of religion. It was every single time a freedom of expression. And I want to say today that this is our challenge, that we guard the clause of the freedom of expression as much as we do anything, because it sort of gets pushed into the definition of freedom of religion when it's not. So thank you so very much for this time today. I'm honored to be here, and thanks for letting me share a little bit of my life. It's still in process, and we're raising up leaders to change the world and save America.
Amen. Well, thank you for your testimony. I mean that in more ways than one. Glad you're here, and thank you for the important distinction about that, the free exercise of religion. It's got to be it's not just a vague concept. It's got to be real. Members, any questions for Long? Thank you for being here.
Thank you. These bills are important. Thank you for support.
Chair now calls Ms. Sean Adair Hall Laquona, and when she comes, she'll hopefully be gracious to me and correct my pronunciation of her name. We're glad you're here. Do you have some written materials for us? Okay. Go ahead. Just take a seat, make yourself comfortable, and introduce yourself. Tell us who you represent, if anyone, and offer your testimony.
Yes. Thank you for having me here today, and you did pronounce it correctly.
Oh, well, thank you.
Thank you. He's passing out some written testimony. I was going to give him a minute, or would you like me to start?
That's fine. You can, if you want to go ahead and begin your remarks,
all right.
And we'll have this.
All right.
We'll pay attention to you while you're talking, but then we'll have this to look at later, unless you want to direct us to it.
All right. Well, my name is Mrs. Sean Adair Hall Laquona, And I have been practicing the law for, going on 34 years, wherever he sends me, in this state, in this nation, and abroad. I've lived in another nation and practiced U.S. law in that nation, in Europe. And I'm here to support SB 26 and others that are here and at the will of our Father God, that they will pass. Love is a permanent statute. I am a cavernous cathedral. I and anyone else who would believe in the Almighty God, a supreme being, and how he leads us and directs us. I thank you for the opportunity to provide my part this morning. Why should this legislature take steps such as passing measures, including but not limited to SB 26, to protect our Freedom to Worship Act? Well, at 12:01 a.m. last Friday, March 5th, every lawyer lost a vote, and therefore every lawful citizen of whom they represent did also. I will circle back around to this point shortly. What does it mean to worship Almighty God according to the dictates of one's own conscience? Well, that's what I'm doing right now. For us who believe in him who is Christ Jesus, it means to revere him at all times and in all ways in devoting our actions to his use. In life, whether in our law practice, ministry, or church, we obey him, and even if we are the only one, because he is worthy of our affections, and in this we have peaceable enjoyment here on earth as it is in heaven. The word of God is the word of truth. Therefore, to stand knowing that is God inside, who is Christ Jesus, is to worship him. To honor one another in love is to worship him. To walk in the spirit of truth is to worship him. To speak his word in good faith is to worship him and bear true witness of his goodness, even when having been faced with unseen but very real evil. Christ Jesus always comes through keeping the word of God as it is written, and as has been made alive in the course of our history and Constitution. But it is the duty of the legislature to pass and have passed laws necessary to protect people like me equally, so that when we come through with a precedent-setting victory, there's a place to go to fully implement the victory in the law for peaceable enjoyment of all. When it is learned that a human authority controlled or interfered with the rights of conscience in matters of religion, it is the duty of the legislature to pass such laws to protect the peaceable enjoyment. Consequently, as the legislature acts to pass bills such as SB 26 and others for which the Lord God Almighty will cause to be supported, Texans will awaken to the newly found freedom like never before. There is a summary of the events in support of this my legitimate testimony, which may be found in the unopposed motion for reconsideration and supplemental motion to intervene in support of case number 20-50448 in the United States Court of Appeals for the Fifth Circuit, otherwise known as the State Bar case. As you come to see and hear, understanding more fully how the cost to worship Jesus Christ, a supreme being, has included my vote in the State Bar of Texas rules election, having been concluded the day after Texas celebrated its 185th birthday of independence. I'm grateful that you have heard the truth and that your prayer for wisdom and stamina has already been answered as you proceed forward in God trusting. I have with me that I just received yesterday.
Ms. Lacona, so we're so thankful for your testimony, and we do need to wrap it up, though. You can finish this point, but and we have your written testimony as well.
All right. So I just received this yesterday from the United States Supreme Court Clerk's Office. It's dated February 17th, 2021, but I just received it yesterday because of this snow event. And it just is a reiteration of what happened in the United States Supreme Court. They upheld my blood covenant in marriage in God Almighty. Amen.
Very good. Thank you for your testimony. So if there's any questions for the witness, thank you for being here. And we have you in the record and your written testimony as well. Thank you. The chair now calls Hanoi Avila. Hanoi Avila Get that place ready for you. Come on down. Testifying for Senate Bill 26, Pastor Avila, welcome. Introduce yourself and give us your testimony.
Good morning. My name is Hanoi Avila, and I am a pastor of Iglesia Edificadores. I represent a small community of faith in Leander, Texas. I'm also the president of CICI, which is a collective of Latino pastors in the city of Austin. Before I begin, I want to thank you for your service and for the dedication. Know that I am committed and praying for each of you. I am here to testify in favor of this bill. As you took office, you made an oath to preserve, protect, and defend the Constitution and the laws of the United States and of this great state. Be minded that you were instituted among the people and for the people of the state, but overall by the sovereignty of God, your Creator, to preserve and protect and defend our God-given rights as it is the right to worship. I believe that SB 26 is precisely a reflection of the faithful execution of your duty, and for that, I commend anybody that votes in favor of this bill, regardless of which side of the aisle they sit on. What took place during this initial stage of the pandemic, and in regards to the church, both by the judiciary and executive, was unprecedented and far overreaching, such as when some of our government officials deemed church unessential and ordered them to pause. I know and I understand that we all want security, and I also understand that it is your duty, desire, and responsibility to protect the people. But at what cost, may I ask, by sacrificing our liberties, such as the freedom to worship? I may want security, but I need liberty. So preserve, protect, and defend the latter by voting yes. Know that I'm not saying this lightly. I'm speaking here as a Cuban American who had to flee his country on a homemade raft precisely because the government failed to protect those freedoms. Thank you so much. Be encouraged, and remember always that the church in America are essential, not only for this state, but for this nation and for the rest of the world. Again, thank you, and God bless you.
Pastor, thank you for your testimony. Senators, any questions for Pastor Avila? Thank you for being here. That's a great American testimony. Chair now calls Jeffrey S. Morgan, and while he's making his way down, for those folks who are outside the chamber and planning to testify, we're going to ask these people to make their way into the chamber. Julie Dahlberg, James Dukas, Pastor Jorge Tovar, Lana Nimri, and Frank Pomeroy. So, again, Julie Dahlberg, James Dukas, Pastor Jorge Tovar, Lana Nimri, and Frank Pomeroy. Please make your way into the Senate chamber so that we'll have you close and ready to go here in a few minutes. So, Mr. Morgan, welcome back. Introduce yourself and offer your testimony.
Thank you. My name is Jeffrey S. Morgan. I am from Dallas, Texas. I am for the bill. I'm not sure that I'm going to be able to add much more than what other people will say, but I want to thank you for talking about the issue of religious liberty. And again, I go back to the Article 1, Section 6 of our Bill of Rights in the Texas State Constitution. All men have a natural and indefeasible right to worship Almighty God according to the dictates of their conscience. And the difference between the Texas State Constitution and the U.S. Constitution is that the legislature has an affirmative duty to pass laws to protect this right. So as looking at what you have right here, this is great. I want to talk a little bit about something that's going to seem a little bit off target, maybe off the bill here, but I think it's still important. Because when you look at religious liberties, I believe our religious liberties have been under attack for a number of years by the state. And bear with me on this. When you look at the institution of marriage to Roman Catholics and Eastern Orthodox, it is a sacrament of the church. If you look at Protestants, they believe it was ordained by God. This is a religious institution. And yet in our state right now, we have unilateral no-fault divorce that will destroy that marriage unit that sacrament, that ordinance. Now, if we believe in the separation of church and state, however you decide on that, that is a very big issue. And one gentleman here talked about communist Cuba. If you go back to 1918, one of the things that Vladimir Lenin did to destroy religious influence in the society was to attack the institution of marriage. He made the institution of marriage, which had formerly been underneath the church, put it underneath the state, and then he also created unilateral no-fault divorce. As Christians, we believe that marriage is the living symbol of the relationship between Christ and the church. I support this bill, but I also hope, too, that the committee members here will look into this other issue, because this is a very deep issue. We have been attacking religious liberty in the state of Texas through our marriage code, just as Vladimir Lenin did. And with that, I close. Thank you very much.
Ms. Morgan, thanks for your testimony. Senators, any questions for Mr. Morgan? Very good. Thank you for being here.
Thank you so much.
You're excused. Chair now calls George McCarthy, Texas Values Action, testifying for Senate Bill 26. Mr. McCarthy for his second testimony before the Senate State Affairs Committee and ever. Glad you're here. And Mr. McCarthy, we have you as testifying in favor of Senate Bill 26 as well as Senate Joint Resolution 27. Is that correct? The bill and the constitutional amendment?
That is correct, Mr. Chairman.
Very good. Please proceed.
Thank you. Good morning, Mr. Chairman and the members of the committee. My name is Greg McCarthy, and I am the Policy Associate for Texas Values Action, and I am here to testify in favor of SB 26 and SJR 27. Senators, do not California my Texas. In California, Governor Newsom went so far as to impose discriminatory and onerous regulations on places of worship that forbid all indoor religious services. At the same time, however, comparable secular businesses were allowed to operate. This went on for about 7 months until South Bay United Pentecostal Church, a church forced shut by California, won their lawsuit at the Supreme Court. And in Nevada, casinos allowed in hundreds of people to gamble, but for spiritually broken people beat down by this pandemic, church doors were barred from reaching out to help. In New York, Governor Cuomo lost his battle with the Supreme Court when he imposed severe regulations on places of worship to the extent that in some red zones, only 10 people could attend services, while comparable secular essential businesses could allow in any desirable number. We, Texas, are not like those other states, as we are one state under God. Let's ensure Texas doesn't ever encroach upon and usurp the religious freedoms of its residents. Let's continue to persistently reassert that here in Texas, we protect religious freedom. Thank you.
Thank you for your testimony. Senators, any questions for the witness? Thank you very much. You're excused. The chair now calls Mary Elizabeth Castle. Mary Elizabeth Castle testifying for Senate Bill 26 and Senate Joint Resolution 27. Ms. Castle, welcome. Good to see you. When you get situated, introduce yourself and give us your testimony.
Good morning, Chairman Hughes and members of the committee. My name is Mary Elizabeth Castle, and I'm the Policy Advisor for Texas Values Action. We're the largest organization in the state of Texas that stands for faith, family, and freedom, one of those freedoms being religious freedom. Last year, we witnessed many unprecedented things. One of those things, besides the pandemic itself, was the government closure of churches. Pandemic restrictions on religious organizations are a relatively new phenomenon for religious freedom. Ironically, the church was closed during a time when people needed to be connected to their places of worship more than ever. According to a Kaiser Family Foundation poll, more than half of Americans reported that the coronavirus crisis harmed their mental health. According to a Washington Post article, a federal emergency hotline for people with emotional distress saw a 1,000% increase in calls in the month of April. By that time, places of worship in Texas had been closed for a month. Places of worship serve as a place of refuge for so many Americans, as this is the place where their emotional and spiritual needs are met. Moreover, people needed access to their pastors and religious leaders during a confusing time of illness, economic downturn, and loneliness. Like grocery stores and doctors' offices, churches need to be open and tend to the spiritual elements of society. Whether there is a pandemic or some other desire for the government to close places of worship should be open. Thank you for your time, and I am open for any questions.
Thank you for your testimony. Senators, any questions for Ms. Castle? Very good. Thank you for being here. You're excused. The chair now calls Jonathan Sines. Jonathan, there he is, and he was close by. Jonathan Sines, Texas Values. And I think we have you on in favor of Senate Bill 26 and Senate Joint Resolution 27. Is that right?
Good morning, Mr. Chairman and members of the committee. My name is Jonathan Sines. I'm president and attorney for Texas Values, and I'm here to speak on behalf of Texas Values in favor of Senate Bill 26 and SJR 27. I'll never forget that night. As a matter of fact, it was about a year ago today. There I was on a Saturday evening, getting ready to go to bed, wrapping things up, and deciding with my family what the next day was going to look like, what the church schedule was going to look like, and how we were going to spend our time. I'll never forget because it was pretty late in the night when I got the message that a local government in this area had ordered that churches be closed. Not just by the next day, but by 2 a.m., maybe 5, 6 hours from that point of getting notice. That's the amount of disrespect in the attitude that some people have when it comes to the issues of churches. Now, look, there were a lot of churches that thought, well, okay, maybe, in the short term, this is what we'll do. Maybe this makes sense. Surely it will just be temporary. And then it wasn't. We were ordered by the government. You cannot go to church. The church was told you must be closed by the government. I want to make sure everyone understands that and we remember that, because some people are still fighting this battle at the U.S. Supreme Court in other parts of the country. But you know what? We have the blessing in our organization to represent churches all across this great state, and they called us looking for help. And I'm so glad that our Lieutenant Governor Dan Patrick made this a priority item, because it is a priority item. We must do something. And those pastors, one after another, said never again. They will not close their church because they know churches are essential. But let's not wait for them to end up in court. And you know what? We will be there in court if we need to be. But I don't think that's the most efficient way to handle this issue. Our friends at First Liberty, others, there'll be attorneys there. We can solve this problem now by making it clear in state law how these issues are handled, and that's what Senate Bill 26 and SJR 27 do. And it's not outside of Texas. These issues came up in Austin, San Antonio, even in McKinney. Government officials had to be reminded that they do not have the right to close churches and that churches are essential. And those are the many reasons why we support Senate Bill 26 and SJR 27, and we ask you to pass these bills.
Ms. Sines, thank you for your testimony. Senator Safraini has a question for you.
Thank you, Mr. Chairman. Sir, what governmental entity issued that order?
I know here in the city of Austin, also the city of San Antonio, and the mayor in the city of McKinney. As a matter of fact, after sort of the initial time period of March or April, we sent messages and communicated our concern to the Attorney General's office, and the Attorney General had to put out additional orders making it clear, because some local government officials in Austin and San Antonio still seemed to act as if there was some confusion, and the words we were getting from even San Antonio that they were still being told that there were limitations on them being able to open. As a matter of fact, some churches held parking lot services. Many of us remember that as a way to sort of be a good community actor, if you will. They still had property, they had a parking lot, and they had services outside. That even wasn't good enough. We were getting reports that law enforcement was circling parking lot services of churches to make sure that people were farther enough apart, that certain restrictions were in place on Sunday.
Thank you.
And there likely are more. I'm sorry, Senator
Thank you.
Jeffrey.
And what group or groups filed the lawsuit and against whom?
In the state of Texas, well, in McKinney, thankfully, a letter was good enough in McKinney for that government officials. But if that letter had not been submitted, and that was from First Liberty Institute, who knows what would have happened to those churches. And a lot of times what we hear is churches, they don't know who to call, and once they do, they don't want to spend their time in court. They don't want to spend their time figuring out what a letter needs to say, a demand letter to send to a government official. It shouldn't reach that point. We saw this recently with the bad weather here in Texas. Churches step up. The Austin Disaster Relief Network is one great example. The churches need to be open during those time periods almost even more so they can meet the needs, oftentimes being used as shelter in other circumstances. So we're glad that we've got people that are willing to step up, but it shouldn't come to that. We need to eliminate any doubt and make it clear in state law how these issues should be handled, and that's what Senate Bill 26 and SJR 27 does.
Thank you. You also mentioned action pending at the Supreme Court level. What were the outcomes at the original court level and at the appellate court level?
Well, I know that the court case that's happening in California has really been ongoing, and and thankfully there's been some relief at the Supreme Court. It's been divided. Those haven't been unanimous decisions. Thankfully in California, the Supreme Court has ordered that in-person church services be allowed. And we're glad that we at least got that decision precedent from the U.S. Supreme Court. And I think that gives this body the ability to say what we're doing is right along with what the Supreme Court is ruling. But I think there's a word of caution I want to have in that as well, though, that even though the Supreme Court so far has been getting some of these issues right, because some of the circumstances are different, they're not the same. We shouldn't have to wait to go up to all the U.S. Supreme Court. There are lawyers on this committee. The amount of time, expense, and effort, if the Supreme Court takes your case, and it's the same way here in our state, you don't get your case does not automatically get accepted by the Texas Supreme Court, maybe less than 10%. So you could end up with an appellate decision, a lower court decision, and you're stuck with that. But again, this is not the hostile environment that churches should be operating within. They are essential. Let's treat them that way by passing Senate Bill 26 and SJR 27.
Thank you. But to the best of your knowledge, there's no pending case in the state of Texas?
Not in the state of Texas, thankfully.
Thank you, sir. Thank you, Mr. Chairman.
Thank you, Senator Saffarini. Members of the committee, any other questions for Mr. Sines? Thank you for your testimony. Mr. Sines, you're excused. Chair now calls Jeremy Dice testifying on Senate Bill 26 and Senate Joint Resolution 27. Mr. Dice, welcome back. Introduce yourself, tell us who you represent, and go ahead with your testimony.
Thank you, Mr. Chairman, and I'll say that I think my earlier miscue, for which I apologize again, is likely due to the fact that I went to neither Baylor nor UT Law School.
Well said.
Senate Bill 26 and 27. Again, I'm Jeremy Dice from First Liberty Institute, Special Counsel over there. Senate Bill 26 and SJR 27 are helpful, and I'd like to provide some information that will be, I hope, helpful to you as you evaluate these measures. If we've learned anything that elected officials have made any mistake during the pandemic that we've now lived through, it has been that of treating our houses of worship as some sort of social club of minimal value compared to laundromats, liquor stores, and banks, rather than the dynamic, essential service that sustains the literal heart and soul of a nation. Just a few stories, two from the state of Texas and one from a more broad experience in the country. In the early days of the lockdown, the city of Frisco, Texas, directed its residents to stay home except for essential activities. They deemed houses of worship to be non-essential, but permitted a scant 10 people to gather in a church building in order to stream their modified religious services. And that means that they allowed childcare services to remain open, restaurants providing takeout meals to remain open, and even news media entities were deemed to be essential services. But in order for houses of worship to provide the spiritual care to Their congregants, not even numbers in the amount of the 12 disciples, could have gathered in order to provide those services, even for a drive-in church service. Government officials also in the city of McKinney likewise ignored not only the protections of the First Amendment, but the Article 1 of the Texas Constitution, as well as the Texas Religious Freedom Restoration Act, by issuing restrictions preventing even 2 people from gathering for religious purposes in one geographic location. That makes it even more difficult for people of faith to be able to gather and receive the care that they request. Nationally, First Liberty filed a lawsuit on Good Friday of last year against the city of Louisville, Kentucky, after its mayor threatened to record license plate numbers and force drive-in churchgoers that were going to attend their Easter services at On Fire Christian Center. He was going to force them into a 14-day quarantine period, sending the city police out to enforce it. Judge Justin Walker enjoined that mayor the very next day, the day before Easter, and he said that the city of Louisville failed to demonstrate, quote, that churches are less essential than every other business that was allowed to be open, liquor stores among them, unquote. Justice Gorsuch, I think, writing recently at the Supreme Court of the United States in the South Bay decision just earlier, February 6th, I believe, he was invalidating, or the court was invalidating, the restrictions on in-person religious gatherings in the state of California. He looked back over our experience in 2020 and observed this, which I think is especially relevant for your consideration this morning. Government actors have been moving the goalposts on pandemic-related sacrifices for months, adopting new benchmarks that always seem to put the restoration of liberty just around the corner, unquote. Senate Bill 26, SJR 27 helped correct the thinking by too many government officials that the only material things are essential, neglecting things like character, charity, hope, love, liberty, and peace, the true essentials to our society that our houses of worship undergird. Thank you for allowing me this testimony. I'm more than happy to answer any questions you may have.
Mr. Dice, thank you for your testimony. I think Senator Bardwell has questions for you. Senator.
Thank you, Mr. Chairman. Jeremy, thank you for joining us. I'm going to first appreciate what First Liberty does. Actually, you can blame your boss. I spoke with Kelly Shackelford yesterday about these bills, and I want to ask a couple of questions, because as well as they are written, there may be some areas that are the 99.9%. Yeah, we don't want churches shut down. But are there some unintended consequences, particularly as was it 15 years ago or so, Mr. Jeffs out in West Texas, as it related to child marriages? Are there unintended consequences here that we might need to tighten up so that on those areas where there is God forbid, some denomination say human sacrifice or child marriages or other things that, as we sit here today, are not within the realm of conduct that we would want done. Can you comment on, as these bills are written, that the state has an interest in making sure those types of things don't happen, so we're protecting people's religious liberty as we're sensing it from the pandemic, but we're not creating a future problem with a new definition of religion 10, 15 years from now, or a new denomination?
Indeed. In fact, who could have imagined that we would have lived through this past almost 12 months now in various stages of lockdowns, and how it applies to Christian schools, for instance, which we also had to defend in South Texas as school resumed. I think if there is any concern that you or the other senators might have related to that, a very simple solution to that might be just to simply borrow from what, again, I sound like a broken record at this point, I suppose, but we know has worked very well, and that is the Texas Religious Freedom Restoration Act. Simply inserting that language or that standard that, let's be clear, it goes back beyond 1993 to the Sherbert standard, as the chairman will be familiar with, I'm sure, as a lawyer himself, and you as also. That standard has been very easily applied throughout the country, in just requiring the state officials to first assert a compelling justification for their substantial burden upon the free exercise of religion. And if they can demonstrate that they have a compelling justification for doing so and are doing so in the least restrictive means possible, that action can continue. Having that helpful and necessary check on local officials in particular, I think would have prevented this situation in McKinney and Frisco and elsewhere. So if you have a concern about that, Senator, I think a very simple porting over of that language into this statute or perhaps into the resolution would be welcome.
If Senator Hancock's SJR was adopted, would it vacate our child marriage laws? Would it, since it's a constitutional amendment as opposed to statutory things, would it vacate those types of things?
I don't think it would have a direct impact on that because those would be governed on criminal law procedures and the like. But again, I think the simple standard of allowing the Texas RFRA language, the compelling justification language, would be of help to you and to the rest of the state to be able to navigate those issues.
Because it still gives the state that some freedom of maneuver for that compelling interest in the lead.
Yes, sir.
As they're written now, my sense is the ultimate check on the state is the people, and it takes some freedom of maneuver from the state should some future circumstance exist that we don't anticipate at this moment.
Yes, sir. And what that allows is no outcome, obviously, no obvious outcome. It just simply permits the process to occur, utilizing a standard that goes back for several decades now that lawyers are all too familiar with. We call it strict scrutiny. Some call it the Sherbert standard. Some call it something else. It's just a simple way of ensuring that the government is checked before its actions continue to deprive citizens of their First Amendment freedoms and other civil rights.
Yeah. Thank you for what you and your team do, and say hey to Kelly when you see him.
Yes, sir.
Thank you.
Senator Birdwell, thanks. Members, any other questions for Mr. Dias? Thank you for your testimony. You're excused. The chair now calls Julie Dahlberg, and while Ms. Dahlberg is making her way down, we'll invite some other folks to make their way here. And so for those who are still waiting to testify, we're going to ask the following people to make their way into the Senate chamber so that you'll be ready. That's Michael Openshaw, Michael Weaver, and Michael Burdick, and that was not intentional. Mike Openshaw, Mike Weaver, Mike Burdick. So you guys make your way down. And Dahlberg, welcome. Please introduce yourself and offer us your testimony.
Good morning, Mr. Chair and members of the committee. My name is Julie Dahlberg. I'm representing myself today in support of Texas Senate Bill 26. As a member of our church safety response ministry, I'd like to bring the committee's attention to the importance of protecting our religious liberties from a different vantage point. Our safety response ministry upholds a mission of ensuring an environment of comfort, refuge, learning, and worship to all members and all visitors who come through our doors. We take that mission very seriously and have a zero-tolerance policy on interruption of services in order to maintain that safe and secure environment for our church family. If ever there's been a need for comfort and refuge for people who are hurting in these uncertain times of trials and fear, the last year has been it. Due to the governor's unchecked mandates regarding which businesses and activities are essential or not, the confusing and unclear expectations in enforcement of pandemic-related mandates against gatherings, and an inconsistent understanding by state and local authorities, our First Amendment protections have been threatened. When we all saw the media reports of instances across the state and across the country where law enforcement officers were locking church doors, threatening church family and church leadership with citations and arrests for simply attempting to exercise their right to worship, church protectors like me are forced to envision a scenario where we could potentially have to become that last barrier between law enforcement officers who have sworn an oath to protect our constitutional right to freely worship and our church family trying to exercise that right, and forced to decide between our great respect for law enforcement and protecting the right of our church family to worship without interruption. A scenario like that should never be imaginable in a free America, and certainly not in the great state of Texas. This overreach has placed church leadership at odds with law enforcement and local leaders, relationships that generally would be one of strength and collaboration in support and protection of the church family's free expression of their faith. Even though I find it unbelievable that we even need to have this conversation, the pandemic response has clearly shown that without this additional protection in our state law, the constitutional guarantees for Texas citizens are open to interpretation by those in authority who may not respect those protections. We cannot allow this to continue unchecked. Passing Senate Bill 26 would ensure that in Texas law that the appropriate hands-off language is made perfectly clear as it applies to religious liberty. I urge each of you to publicly support and vote for Senate Bill 26 to protect religious liberty in Texas. I thank you very much for your time and your service. I'll be happy to answer any questions.
Ms. Dahlberg, thanks for your testimony. Senator Saffarini.
Ms. Dahlberg, you testify in favor of Senate Bill 26. Do you also favor SJR 27?
I don't know that I know enough about that. This is the bill that I focused on for my purposes and how it affects me.
They're being presented together, so you might want to look at that and register for that too.
Will do.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator.
Thanks, Senator. Members, any other questions for Ms. Dahlberg? Thank you for your testimony, Ms. Dahlberg. You're excused. The chair now calls James Dukas, testifying for Senate Bill 26. Mr. Dukas, welcome. We'll have the place ready for you in a minute. Make yourself comfortable and introduce yourself and offer your testimony, please, sir.
Yes, sir. My name is James Dukas. I'd like to first thank you, Mr. Chairman, and the committee for allowing me this time to speak to you. I also thank you for your service that you do in the time that you spend under hard conditions that have been going on. I'm basically here to just basically say that I never thought in my lifetime that I would have to speak to my representatives about keeping a church door open. I come to the Lord about 10 years ago, and I have absolute faith in my Lord and Savior and my Father-loving God. Some people say, well, we need to close the doors to protect people. I say this is a time that you have the doors open and you go to Jesus. You go to the Father. We were going to a church that decided on their own to close the doors. So we went to the church we're at now, and they kept their doors open. And I will say this, the church that closes doors has more COVID cases than the very few that we had at this church. I have people who live in Ohio that are family whose churches have been closed. They've been basically told to stay home. And it seems like there was more COVID than if they were allowed to go to church. Once again, I have served this country honorably in a service. I served my community for 24 years as an honorable law enforcement officer. And again, I just cannot believe that I'm here today to basically beg you to keep the church doors open. I am in for the SB Bill 26. Again, I thank you for the time that you allotted me and the service that you give for us.
Mr. Dukas, thank you for taking time to testify. Thank you for serving. Senators, any questions for Mr. Dukas? Thank you very much, and you're excused.
Thank you.
The chair calls Pastor Jorge Tovar. Pastor Jorge Tovar, testifying for Senate Bill 26. There he is, all right. I was going to say good morning, good afternoon. Help take a seat there, make yourself at home, and when you get situated, introduce yourself and offer your testimony.
Yes, good afternoon. My name is Pastor Jorge Tovar.
pastor de Jordan River Church in Laredo, Texas. And I have been a retired firefighter for 9 years and 3 months. And I served Laredo Fire Department for 27 and a half years. As a firefighter, I was trained to go into building swamped with dangers like compromised structures, over 1,000 degrees heat, and of course fire, just to name a few. And those were known as a belt alarm for me, a building on fire. Our priorities were to save lives first and as much property second. Ready to go into a building without hesitation whenever everyone else would run out. I served at the time when slogans ran strong, like first in, last out, and you go, I go, and I got your back, and I know you got mine. Once a firefighter, always a firefighter, 24/7 frontline firefighters, and when injured, that's what happens when one is in the front line, but eager to heal fast to come back to the line. As a pastor for 26 years, we are frontline warriors. We save lives from the gates of hell. A year ago, I got the alarm equivalent to a belt alarm, a virus that would take lives and damage and or loss of property. We responded to help save not only our own congregation, but our community as well. We were there for the community 24/7, distributing food, sanitary supplies, water, prayer, counseling, encouragement, fellowship, lending a listening ear, and to be an escape for the stressed. I got injured. Somewhere, somehow, the virus got to me and then my wife. But the church, the people continued at the trench and held the line. After about a month and God's healing and all the red tape, my wife and I were back on the line, on the front line with them again. This is our calling, our passion, to be a lighthouse to the world in darkness, more so when our community was sent to a deeper, unprecedented darkness like this pandemic. When the executive order was issued and announced that we were house of worships were essential, Laredo pastors and I considered it a blessing for the church to be called essential, for it permitted us to do what we did along with other churches in Laredo. And Romans 13 tells you and me, or you and I, everyone must submit to governing authorities, for all authorities come from God, and those in position of authority have been placed there by God. And verse 4 says the authorities are God's servants. I believe our calling have similarities. You are servants of government institution as we are servants of a church institution. We serve for the best interest of our congregation and community as you serve the best interest of your constituents. We are called to do this because we are servants of authority placed there by God. We have all been called by God to serve in our own institutions. And I believe these two institutions go together. We teach and preach God's word to our congregation to be a blessing to familias as member of Church Ambassador Network, a ministry dedicated to recruit pastors all over Texas, including legislators, as part of our outreach to come pray, encourage, and share God's word with you so you can continue moving forward, being a blessing to your constituents. This is why we are essential. As groceries businesses are essential, so churches are essential for the spiritual food for the people. If we were not essential, people will starve. And I close with this scripture that says, Proverbs 29, verse 2, when the godly are in authority, the people rejoice. And when the wicked are in power, they suffer. God bless you. Thank you.
Pastor Tovar, thank you for your testimony. Senators, any questions for Pastor Tovar? Very good. Senator Bardwell says you said it well. So thank you for being here, and you're excused.
Thank you very much.
The chair now calls Lana Nimri Testifying for the bill, Lana Emery, Arabic Church of Houston. We'll get that spot ready for you in just a second. And we're very thankful to the Senate team that's making all these arrangements and getting that space ready in between witnesses. Thank you for doing that. Thank you very much. Ms. Emery, introduce yourself and go ahead.
Can I run away?
It's real friendly here.
Okay, that's my first time ever testifying in something, so excuse my nervousness.
You're fine. Just tell us who you are and who you represent, and just walk on through it. We're fine.
Okay, my name is Lana Nimri, and I am the Sunday School Director of the Arabic Church in Houston, Arabic Christian Church. Of course, as you may have recognized from my name or the church, I'm originally from the Middle East, from Jordan. One of the reasons we moved to the United States is to exercise your freedom of religion, to be free to go to church, to be able to operate with no limitation, and not somebody shutting you down just because, they want to do that. So during the pandemic, I was really puzzled. Why was closing the church on top of their priority while they left liquor stores, strip clubs open? When churches is the place that gives you, comfort, that gives you, to know how to deal with stress, and it teaches us how to obey and, the law and be good citizens. It eventually teaches us how to obey you. So why you want to shut us down? Why you want to close us when we offer help, we offer comfort, we keep, it keeps us sane. And don't you want, don't you want citizens who are sane, who know how to cope with stress and all that? So I do favor both bills, please, and I ask you to pass it. Thank you.
Ms. Emery, thank you for being here. Senators, y'all have any questions for the witness? So when did you leave Jordan and come to America?
Oh, I've been here 24 years.
Okay, so your family...
So I'm a Texan.
Your family came when you were a child, okay?
Yes, I'm a Texan, so maybe not by blood, but by heart.
We know you're a Texan. There's no question about that.
Yes.
We're glad you're here. Thank you for testifying. The chair now calls Frank Pomeroy. Frank Pomeroy testifying for Senate Bill 26. Pomeroy, come on around and get set up there and introduce yourself and offer your testimony.
Well, good afternoon, Senators. I appreciate your time. Frank Pomeroy, representing myself and a concerned citizen as well. I can take this off. The events of this last year, I think, has put forward an idea that the church has not been essential. We've heard this. I don't have a whole lot to add to the stories that have been shared here already. But I would like to share something with you. This is Martin Luther was the father of Protestantism, and he also wrote a pamphlet during the time of the plague in 1527, a plague in which he also lost his daughter within that plague. And he laid out the order and the rules of what the church should be doing during a plague. And in so doing, I wanted to grab one of his quotes. He said, "We die at our posts. Christian doctors cannot abandon their hospitals. Christian governors cannot flee their districts. Christian pastors cannot abandon their congregations. The plague does not dissolve our duties. In fact, it turns them to crosses on which we must be prepared to die." I share that with you for this reason. It doesn't matter about faith. It doesn't matter about the denomination at this point. What matters is that people tend to grab, as the sister before me just said, their peace and their security from being able to gather with friends and family, to be able to pray and gather together and worship, to be able to come together in unity and lift one another and encourage one another and strengthen one another. I think we saw over this past year with the difference of priorities being placed, whether, as she said, liquor stores, strip clubs, whatever, placed in a position to where the church has become just something to tolerate. And we need to go back to the Constitution. The fact that we have to pass a law to give teeth is unheard of to me when we know that this was a constitutional right. So we need to be able to give our governors, our mayors, our judges, all those people an opportunity, a way to be able to stand behind the churches within the area that they are called into leadership. Thank you, and I am in support of both the Senate Bill 26 and the Senate Joint Resolution 27.
Pastor, thank you very much for your testimony. Senators, any questions for the witness? Very good. Thank you for being here, and you're excused.
Thank you, Senators.
The chair now calls Michael Openshaw, testifying for Senate Bill 26. Mr. Openshaw, welcome back.
My name is Michael Openshaw, Plano, Texas. I'm testifying as myself, and this is generally a heretic. Many of you may not know that my first background was in medical microbiology and virology, and I have followed this COVID pandemic situation since before it ever left China. I've read all of the papers at the scientific level and am very updated on everything. I will say this. There are cases, multiple cases, of super spreader events occurring in churches. Churches are a problem in terms of an epidemiological aspect. I will also say something not with any pride, but it's a fact. I'm not an attendee of a church on a regular basis of any particular denomination. But why am I here testifying for this bill? It's very simple. This is about the First Amendment to the Constitution of the United States. We cannot be shutting down churches. We have a freedom of religion, and of is a very important word there, not from, of. So now, mind you, government should be able to, how should I say, encourage certain behavior that would hopefully alleviate some of the epidemic. But to shut churches down, that is a completely incorrect solution and is a direct violation of the Constitution of the United States. It's sad that we have to pass such bills as this one, 26, and the SJR 27, but it is essential to make the point that this is a constitutional right, and government cannot shut down the business and comfort of church.
Mr. Openshaw, thank you for your testimony.
Thank you very much.
Senator Birdwell, Senator Safran, any questions for the witness? Thank you for your perspective on this, for being here. And Chair now calls Michael Weaver. And while Mr. Weaver is coming, let me just say for anyone listening, whether I have called your name, if you're here to testify on Senate Bill 26 or on Senate Joint Resolution 27, please make your way in the Senate chamber because we're getting toward the end. And so if you're in the gallery, maybe I haven't called your name, or if you're listening, you want to testify on Senate Bill 26 or Senate Joint Resolution 27, please come to the Senate gallery and make sure we have all your paperwork ready to go. And with that, Mr. Weaver, welcome. Introduce yourself and go ahead with your testimony.
Good afternoon. My name is Michael Weaver, and I'm a pastor of a cowboy church out in the hill country, Wild Ride Ministries, and our slogan is "Experience the Excitement of Jesus," and that's what we've done the last year. Maybe not all the ways we want to, but it's been a learning experience. Whenever the pandemic first started, I had in February a year ago, I had been at a ministers' conference, a cowboy ministers' conference in San Antonio, came home, got so sick, I had no idea what it was. I was out for 3 weeks. We came back, got back into church, and 2 weeks before Easter is when everything was just shut off. And I was like, if that's what I had, I'm in agreement with shutting down for the moment. Because at the time, we didn't know what it was. We were 2 weeks off, and on Easter Sunday, our team said, you know what, why don't we have church outside? So we bought a transformer, trans receiver, whatever, where we broadcast our services in the parking lot in the cars. And that was good for a little while, but I noticed something, that people were not encouraged. They were glad to be there to get out of the house, but there was still that lack of touch. There was still that lack of a hug. The scripture comes to mind in 2 Timothy 1:7, for God has not given us a spirit of fear, but of power and of love and of a sound mind. So it dawned on me, look, this is not of God for us to be distant from each other. Hugs, smiles, encouragement all breed hope. Fear breeds anxiety, worry, doubt, and eventually rebellion. I don't think, as one of the other ladies, as a lady just said, that why would you not want us to gather to build hope and encourage each other? These are our sincerely held religious beliefs that we must gather. I was blessed several years ago to work on the Pastor's Protection Bill, which I was so excited that we got passed. But at this point, I'm thinking, what good is the Pastor's Protection Bill if we can't pastor, if we can't gather together and actually pastor? I do appreciate all that you all are doing, and I know that my thinking was when all this started, how in the world do they know what to do? None of us knew what to do. But we're a year past that, and I think my experience is now, as a pastor, as a minister, that we have got to be able to keep our church doors open, to keep our people encouraged, to keep them in hope, to keep them just in fellowship, and to let them keep seeing us smile at them and know that we care about them and love them. So anyway, God bless you. Thank you for what you do.
Pastor, thank you for your testimony. Senators, any questions for Pastor Weaver? Thank you very much. You're excused. The chair now calls Michael Burdick. Pastor Michael Burdick, testifying for Senate Bill 26. And again, anyone in the sound of my voice who wishes to testify on, for, or against Senate Bill 26 or Senate Bill 27, please come into the Senate chamber so we can make sure we have all your stuff. Pastor, welcome. Introduce yourself and go ahead with your testimony.
Thank you, Chairman and members. I'm Pastor Michael Burdick in Fredericksburg, Texas. Speaking for myself, but also a precinct chair for the Republican Party in Fredericksburg, and also a member of the Fredericksburg Tea Party, so also speaking somewhat for them. Appreciate the opportunity. Also recovered from COVID-19, and of course stayed in quarantine away from the church for a period of time, and of course church, for the most part, all I know of are very law-abiding citizens, and churches have this year gotten very creative and of course operated with responsibility and love towards people, keep people safe. And so there in March, Easter, doing services, live stream. But doing that experience, it's very clear that service online is not church. It's not a substitute for church. There is assembly required to, at the least, see each other's faces. And many pastors experience the challenge of preaching to a camera and not preaching to the faces. And so we have a mandate from our Christian founding documents to meet, to not forsake the assembling of ourselves together. And of course, in Texas, people came to Texas, and Texas was founded for freedom of religion as one of its fundamental reasons, as well as the United States of America. And so, yes, churches have been responsible to operate as safely as anything that was essential to operate during this pandemic, and to be very creative to meet people's spiritual, relational, family, physical needs, supporting with food and helping even businesses however we could who are struggling during this time. But as we got online and Zoom meetings and Facebook, those things, we're glad to do those and reach people that we didn't even reach before. But those don't take the place of church, which requires meeting. So thank you very much.
Pastor, thank you for your testimony. Senators, any questions for the witness? Thank you for being here. And I would just say, as the pastor exits, the point he made about how the response to the pandemic and going remote allowed churches to reach folks they weren't reaching before. But someone said earlier, this was a horrible experience and some good things did come out of it, but we do have to learn these lessons and get these things right. So I'm glad he brought that up. Those are all the witness cards we have on Senate Bill 26 and Senate Joint Resolution 27. Is there anyone present, or anyone in the sound of my voice, who wishes to testify on, for, or against Senate Bill 26? Is there anyone who wishes to testify on, for, or against Senate Joint Resolution 27? Senate Joint Resolution 27. Okay, public testimony on Senate Bill 26 is now closed. Public testimony on Senate Joint Resolution 27 is now closed. The chair's intent to leave Senate Bill 26 pending at this time, and the chair will leave Senate Joint Resolution 27 pending at this time. Senator, are you ready on 45? Okay. The chair now lays out Senate Bill 45 and recognizes our colleague, its author, Senator Safraini, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 45 relates to the prohibition against sexual harassment in the workplace. It is an identical refile of Senate Bill 46 from the last session, which the Senate passed unanimously. Unfortunately, it died on the House calendar 7 bills away from a vote. Mr. Chairman and members, protections against workplace sexual harassment in Texas apply only to persons who work for an employer with 15 or more employees. By that standard, almost all of our Senate and our House of Representatives offices would be exempt. Senate Bill 45 would establish clearly that sexual harassment by any employer, regardless of how many persons he or she employs, including Senate and House members' offices, is unlawful. This change would ensure that all Texans enjoy protections against inappropriate behavior in the workplace. Generally, then, Senate Bill 45 would codify the definition of sexual harassment currently applied in workplace discrimination against cases in Texas. It makes no changes there. It would provide that sexual harassment against a paid employee is an unlawful employment practice if his or her employer employs one or more persons, but exempts small business owners from liability for sexual harassment by third-party contractors they hire. Thank you, Mr. Chairman and members.
Thank you, Senator. Members, any questions for Senator Zaffarini on the bill? Very good. We will open public testimony, and we have Holt Lackey testifying for Senate Bill 45. Sorry, Mr. You know what? I should have let people know to come down from the gallery. So, Mr. Lackey, take your time. And while Mr. Lackey is coming down, there's also a resource witness from the Texas Workforce Commission. Brian Snoddy is the Director of Civil Rights. Do we have any questions for the resource witness, members? Very good. And while Mr. Lackey is making his way down, I'll ask if anyone else is present who wishes to testify on, for, or against Senate Bill 45.
Mr. Chairman, if I may, we had numerous witnesses who wanted to testify in favor, but because of the pandemic, they simply said they would submit written testimony.
Of course, that makes sense. And we do have a number of groups who have expressed their position, and they'll be shown, their position will be shown in the record. But you're right, that's going to be a challenge for us this session, isn't it? Many folks who would otherwise be here are been on.
And that's why we invited only a resource witness, too.
Yes, ma'am, that's right. Thank you very much. Mr. Lackey, I apologize for not giving notice to bring everybody down. Thank you for letting us know and getting down so quickly. Welcome back. Just take your time, get prepared, and we'll look forward to your testimony on Senate Bill 45.
Yeah.
All right.
Mr. Chairman, Senator Zaffirini, thank you for having me here. My name is Holt Lackey, and I'm an employment and civil rights attorney in Austin. I'm testifying for SB 45 because sexual harassment at businesses with fewer than 15 employees is a profound problem that is currently beyond the reach of any Texas or federal law. 4.7 million Texans work for small businesses, almost half of Texas's private sector workforce. SB 45 is necessary because the half of Texans who work for small businesses deserve the same protections from sexual harassment as the half who work for bigger businesses. Every Texan has a right to earn an honest living free from sexual harassment. Though estimates vary, reliable surveys indicate that almost half of American workers and most American working women have experienced sexual harassment at work. Over the past few years, thanks to movements such as Time's Up and Me Too, we have learned of countless cases of exploitation, harassment, and abuse, and understand that the problem exists in businesses of every size. In fact, we know that the conditions that are most likely to lead to the worst abuses are unfortunately more likely to exist in firms that are currently beyond the reach of the law. Studies show that the most important risk factors for workplace sexual harassment include a hierarchical structure with significant power imbalances between the leaders of the organization and its employees, and a lack of accountability for harassers who are in charge. Essentially, the more one person holds the power in an organization, the more likely abuse of that power will occur, all too often in the form of sexual harassment. The most dangerous situation is one in which the boss knows that they can get away with harassing their less powerful employees. As a partner in a small business that employs fewer than 15 employees myself, I am sad to admit that these risk factors are, if anything, particularly likely to occur in small businesses in which one or two proprietors hold nearly all of the power over their employees. Businesses with fewer than 15 employees are also less likely to have clear policies for reporting and redressing harassment, particularly when the harassment is carried out by the boss. I'm a lawyer who represents victims of workplace harassment. I regularly hear some of the most brutal and harrowing accounts of harassment, only to realize that the victim has essentially no legal rights just because they work for a small business. But sexual harassment is wrong no matter the size of the workplace. Texans who work for small businesses should have the same right to pursue their careers free of harassment and discrimination. SB 45 is a noble attempt to protect the rights of Texans who work for small businesses. I respectfully ask you to support it and thank Senator Zaffirini for introducing it.
Ms. Lackey, thank you for your testimony. Senators, any questions for the witness? Thank you for being here and coming down again.
Thank you.
You're excused. Anyone else wishing to testify on, for, or against Senate Bill 45? Seeing none, we'll close public testimony and the bill be left pending at this time. For the benefit of those listening and watching, in a moment we're going to take up Senate Bill 12. So if for those wishing to testify on, for, or against Senate Bill 12, please come on down to the Senate chamber so we'll have you here and ready to go. So Senate Bill 12 will be coming up next. So again, anyone wishing to testify on, for, or against Senate Bill 12 will please come down. And with that, I'm going to yield the gavel to the Vice Chair and ask him to, I guess. You might do it from there with us. So I'll yield the chair to the Vice Chair, Senator Chair Bardwell, and so that we can present Senate Bill 12.
Excuse me. Chair lays out Senate Bill 12 and recognizes the author, Senator Hughes.
Mr. Chairman, thank you. Members of the committee, thank you very much. Senate Bill 12 deals with a matter we're all familiar with to probably some great degree. Back in 2017, it was Justice Kennedy in an opinion joined by many of the members of the court that said those social media platforms are now the modern public square. And he acknowledged that for many, these very few dominant sites, the very few that really occupy the vast majority of the market, I'm going to quote him, they are the principal sources for knowing current events, checking ads for employment, speaking and listening, unquote. He went on to say, quote, perhaps the most powerful mechanisms available to a private citizen to make his or her voice heard. And that ends his quote. We realize that today we're acutely aware that a handful of social media sites really do drive the national narrative, and they have a massive influence over the progress and development of medicine and science and social justice movements and election outcomes and public thought writ large. When you have inside documents like the one that was discovered from Google outlining the practices of the good censor, or you look at the political donations of the leadership of executives of Facebook, it's pretty clear that the content moderation practices of this elite class are not viewpoint neutral, not even close. We have a handful of people with immense power who want to be the gatekeepers for free speech in our country. And their practices primarily limit and remove conservative speech. But I want to stress this. The concern is about free expression of ideas and having a debate, having an exchange. And we want to make sure that viewpoints are not discriminated against, whether they be conservative, liberal, or in between. This is about viewpoint discrimination. That's very important. And so to lay out the bill, I want to illustrate the problem and explain why we believe Senate Bill 12 is the right solution. Just a couple of examples that I'm sure you're aware of, and you could list more for us, but there's a blogger named Megan Murphy, and she was permanently suspended from Twitter for writing, I'm going to quote, "Men aren't women." The only tweet that they referenced when they permanently banned her was one where she referred to a man who presents as a woman but still uses his male name. She called him. Again, confusing, maybe not an intentional snub, but banned from Twitter based on that. How about the former Navy SEAL and FBI agent Jonathan Gillum? He saw a tweet in which Congressman AOC, Elizabeth Ocasio-Cortez, she had tweeted language about conservatives, and she's expressing her opinion, which she's entitled to do. He took her tweet, and when she said red states, he replaced it with Democrats and put the exact tweet out, and he was banned from Twitter for over a week. A pure apples to apples comparison. Some folks know the Susan B. Anthony list. It's a pro-life group, and they had ads that were exposing former Vice President Biden's support for late-term abortions. Well, Facebook, relying on a fact check from a group called The Dispatch, blocked those ads. Now, The Dispatch eventually retracted its fact check, admitting it was wrong, and Facebook then, after the fact, reinstated the ads. We could go on, and I won't bore you with a lot more details, but one more, the photo-sharing platform Instagram. There's a conservative commentator named Ashley Sinclair. On November 21st, she posted a photo with a gun after she'd been hog hunting. And she shared screenshots that showed Instagram had removed her photo for, quote, coordinating harm or promoting crime and violence and incitement. And her Instagram story reporting on this. So she put this on Instagram reporting on it, and that was removed for coordinating harm or promoting crime. You get it. You get it. People are being blocked, banned, deplatformed because of their viewpoints. We're not talking about violence or obscenity or anything like that. We're talking about viewpoint discrimination. So what does Senate Bill 12 do? What's our proposed solution? The bill includes a legislative finding that the biggest social media sites are acting as common carriers of public speech, and then draws a critical distinction, to which I was just referring, between censoring based on content as opposed to viewpoint. Of course, they have to moderate content, violence, overtly sexual posts, but they can't deny you participation based on your viewpoint, your religion, your political preferences. So, under this bill, social media sites of over 100 million users would be prohibited from censoring a person or the content that person posts based on the person's viewpoint or the viewpoint expressed in the post. If a site does block or restrict a user based on viewpoint, the user can file suit against the site to get back online and to get their attorney's fees back. The bill also provides for the Attorney General's office to represent Texans in the same process. Now, I anticipate that witnesses today may talk about Section 230 of the Communications Decency Act. It's a federal statute that limits what can be done. Much protection is given to social media companies by Section 230, and it provides this. It prohibits holding websites liable for restricting access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. It also prevents us from treating websites as the publisher or speaker of any information provided by another user. Now, that's what Section 230 says. However, that very same Section 230 says states are expressly allowed to regulate websites so long as those regulations are consistent with federal law. And that's what Senate Bill 12 does. Now, let me say, we believe Section 230 has problems. We believe it's unconstitutional. But laying that aside, Senate Bill 12 threads the needle allowed to us under Section 230. It complies with it because it does not impose liability for content moderation practices. It just enforces a prohibition on viewpoint-based speech censorship. If the social media site refuses to put the user back online, the court can hold the company in contempt and fine the company until it complies with the order. And one more thing on Section 230. Just last year, Justice Thomas wrote that made a very important point. There's a lot of talk about Section 230, but we haven't yet had a case that actually examines what 230 says. This bill, we believe, follows the language of Section 230. We believe it's going to be completely consistent with that law. There is a committee substitute, Mr. Chairman, I'd ask to be sent up.
Senator Hughes has a committee substitute. Senator Hall sends up the committee substitute. Is there any objection? Hearing none, committee substitute is adopted. Chair recognizes the author to lay out the differences between the bill and the committee substitute.
Mr. Chairman, thank you. The committee substitute does make several changes we believe strengthen the bill that are consistent with the bill's purpose. First, it offers a clear definition of social media platform. It also, so that we can have transparency in this process, it requires a social media platform to publicly disclose on an accessible website how the platform selects the content users get to see and what sort of content they allow. The committee substitute would also require a social media platform to implement an easily accessible complaint procedure for users to submit a complaint regarding illegal content or the platform's alleged removal of content. So when you see illegal, harmful content, there should be a way to report that so that that can be dealt with. Appropriate constitutional content moderation the companies should be engaging in. And the bill would also require the platform to investigate any report of illegal content within 24 hours of receipt of the complaint and allow a user whose content's been removed to file a complaint and get feedback and a review of that removal decision. And that's what the committee substitute does. We look forward to the discussion. This topics can get technical. And again, we believe based on the plain meaning and the plain wording of Section 230, Senate Bill 12 is the right way to get folks back online consistent with federal law.
Thank you, Mr. Chairman. Members' questions? Senator Schwartner, you're recognized.
Thank you, Mr. Vice Chairman. Senator Hughes, the relief afforded to an individual is, from what I can understand reading the bill, is injunctive relief as well as attorney's fees only. There's no exemplary damages that could be sought by that individual that was found to be wronged by censorship of their viewpoint. Is that because it would be in violation of Section 230, or is that a different reason? What is the thought on that regarding essentially the pressure?
Senator Shorten, you're exactly right. You'll recall the bill along these lines that the Senate passed last session provided for damages under the Deceptive Trade Practices Act to hold these companies accountable. But you're correct. Senate Bill 12 does not provide money damages. And yes, it's because of Section 230. As we read Section 230, as constitutional scholars read Section 230, the bill would not allow us to impose liability, that is, to award money damages against one of these companies. But the bill does allow us otherwise to regulate their conduct to get folks back online. So you're correct. The only relief available would be getting back online and your attorney's fees. And that is because we want to comply with Section 230. We want this bill to take effect and not be struck down.
Thank you for that clarification. Are there other types of relief for repeated actions like this that could be sought and are implemented that the bill has not really entertained regarding operation of that company within a certain jurisdiction, in this case, Texas? Has that been looked at?
There certainly are. Different states have taken different approaches. And I will say this, I didn't give much attention to this, but the court, in its power to enforce its orders by contempt, if we have a situation where a Texan is deplatformed in violation of their First Amendment rights, and then the company refuses to put them back online after the court orders them, the court can then hold them in contempt, fine them. The court has a lot of power in a case like that. So for a repeated bad actor, there are remedies built in that we think are still consistent with Section 230. Thank you, Senator. Good questions.
Okay. Other questions, Senator Powell?
I have a question for Chairman Hughes. If this bill is targeted toward political and religious speech, let's say in the course of a political campaign, people start to make unrealistic attacks on a candidate's family members or those kind of things. Is that kind of speech protected in this?
Senator, that's a very good question. What this bill attempts to do is to take 200 years of American jurisprudence about protected speech and about what's not protected. Of course, you can't yell fire in a crowded theater, right? We understand that. Obscenity is not okay. So the law is very well developed in America about what is protected by the First Amendment. This bill would seek to take all of that jurisprudence and apply it here, so we wouldn't have to plow any new ground. So if you think about what would be protected, we mention religious speech and political speech because those are the ones that we most see, being affected. But we're talking about First Amendment protected language. So that's what we're targeting here. So the good news is questions like that have been litigated or that we can pass laws about that will all apply to this bill.
And so to sort of stay in that same vein, would this bill protect people who are Nazi sympathizers or KKK sympathizers or racists who make broad racist posts in the name of their political beliefs?
It's interesting. The language in Section 230 is actually pretty helpful here, again, because the language that they're specifically prescribed to moderate is obscene, lewd, lascivious, filthy, excessively violent, harassing. So speech like that is not protected speech would not be protected. But unpleasant speech, opinions I differ with, you bet it. You know, of course, that in free speech, sometimes I have to listen to things I don't like. But of course, that's part of what gets us to the right place. But no, if we're talking about obscenity, if we're talking about speech like this, there's no special protection for that.
Thank you, Chairman.
Oh, thank you, Senator.
Members, other questions? All right, hearing and seeing none, we'll move to public testimony. Members, before we do that, we do have one resource witness from the Attorney General's office, Mr. Grant Dorfman, if Deputy First Assistant Attorney General, if anybody has any questions for the Office of the Attorney General. For those that have wished to testify, let me go ahead and bring down Jeremy Dias On the bill, Jeremy, if you would take the stand, so to speak. And then next will be Servando Esparza. You're on deck. With that, Chair recognizes Mr. Dice. Thank you.
Thank you, Mr. Chairman. Members of the committee, my name is Jeremy Dice, as you know, and I represent First Liberty Institute as special counsel there. Our commitment to religious liberty is facing a new challenge these days, and that's the censorship of religious viewpoints on social media. When private companies purport to promote the principles of the First Amendment, including free speech and religious liberty, but then favor certain viewpoints while censoring others, America's commitment to freedom and religious freedom in particular is often undermined. I'd like to give you two contrasting examples that may be helpful to you in your deliberations. First, in Allen, Texas, Cottonwood Creek Church developed a series of Facebook advertisements inviting local residents to attend their Easter services. Facebook summarily deleted the ads with little explanation. After First Liberty intervened and connected the church with contacts inside of Facebook, the ads were quickly restored. Ads for a church service, though, should never have been removed from Facebook, but mistakes do happen. And when they do, using the principles of the First Amendment that we know produce greater freedom, policies can be and have been adjusted to correct course. However, the experience of Focus on the Family, the Christian ministry to families worldwide located in Colorado Springs, is quite different. After using Twitter to express moral opposition to a presidential nominee in January of 2021, Twitter locked the account. Since that time, First Liberty and Focus on the Family have repeatedly reached out to multiple representatives of Twitter in an effort to understand and resolve the situation, as I think most of us would try to do. Over a month later now, we are still waiting for any response from Twitter as to why this viewpoint triggered the locking of the account when other accounts with differing viewpoints remain simply unaffected. Professor Philip Hamburger recently observed in the Wall Street Journal, quote, "Under the Constitution, government cannot immunize powerful private parties in the hope that they will voluntarily carry out unconstitutional policy," unquote. Permitting social media companies to do what government cannot is to turn a blind eye toward the propagation of freedom itself. Let me close by quoting the Supreme Court in Rosenberger versus the Rector and Visitors of the University of Virginia. It's helpful to consider here, although it's from a different viewpoint, from a different context. It says this: "The guarantee of neutrality is respected, not offended, when the government, following neutral criteria and even-handed policies, extends benefits to recipients whose ideologies and viewpoints, including religious ones, are broad and diverse." That ought to be the animating principle of America's social media companies as well. Human history has not looked favorably upon censors and book banners. If nothing else, Senate Bill 12 sends a message to Texans and, frankly, to all Americans that the promise made by the Founding Fathers is to encourage the free expression of broad and diverse ideologies and viewpoints, including religious ones. Thank you, and with that, I'm happy to answer your questions.
Members, any questions of Mr. Dice? Thank you, Jeremy, for joining us today. Mr. Esparza, you're next, and on deck, Paul Anthony Hale. Mr. Esparza, if you would, state your name for the record, whom you represent. The floor is yours.
Mr. Chairman and members of the committee, for the record, my name is Servando Esparza, and I'm Executive Director for TechNet in the Southeast region. We're a national bipartisan network of tech companies that promote the growth of the innovation economy nationwide. I'm testifying today in respectful opposition to the committee substitute to Senate Bill 12. Our members are committed to keeping their users safe online, which is why social media companies review millions of pieces of content every day in order to remove harmful content that conflicts with their policies. Texas should encourage these companies to have content policies that they govern the removal of content showing the exploitation of children, bullying, harassment, pornography, and spam. Instead, Committee Substitute 12 creates an incentive for companies to not prohibit and remove objectionable content in order to avoid frivolous lawsuits that this bill would create. The committee substitute only allows interactive computer services the ability to remove harmful content that is specifically authorized to remove by federal law or unlawful expressions. This would prohibit an interactive computer service from banning harmful content that is not specifically unlawful which includes bullying, pornography, spam, and other objectionable content. Section 4 of the committee sub also states that the act is being enacted amid uncertainty about the application of the United States Constitution and relevant federal statutes, so it will inevitably fall on Texas courts to play the referees in these social media disputes. The committee substitute runs counter to American free speech, law governing content liability on the internet. Section 230 has empowered online intermediaries to remove harmful content while providing them the same conduit immunity that commonly exists in other real-world offline contexts. The example is holding a bookseller liable for a book that includes libel, but rather instead holding the individual that committed the libel. It also appears to give deference to federal law, but it must be settled by a judge every single time. But for those reasons, we oppose Committee Substitute Senate Bill 12.
Members, questions of the witness?
I've got a question, Senator. After everybody else does, I've got a question. So I'll go last.
Senator Schwartner, you're recognized.
What are the companies in your organization?
We have over 80 tech companies. Out of the ones that I imagine that you're interested in, Facebook, Google,
Twitter,
a couple others.
Facebook, Google, Twitter. Yeah. So, I mean, your testimony was all about harmful content and that this bill would prohibit your organizations that you represent from essentially regulating harmful content to the detriment of those users. You didn't really talk at all about viewpoint censorship or the concerns raised by members of this committee and really tens of millions, if not hundreds of millions across this country regarding censorship and how those companies delineate the difference between harmful content and censorship of viewpoint. Can you speak to that?
Well, speaking to that, I would say that that their social media companies understand and have an obligation. There's millions of posts, hundreds of millions actually, of posts every day that both artificial intelligence and human reviewers review those posts. The companies can't get it right 100% of the time. And they provide some recourse for folks to say, hey, this was a mistake, you know, here's, and then the companies rectify that issues. What we're saying on that specific piece is for the penalties are very severe for one of those mistakes for hundreds of millions of posts that happen every single day.
So what I just heard was that acknowledgement that y'all don't get it right all the time regarding the algorithms, AI, that y'all utilize, that the companies utilize, as well as like personnel that are, quote, trained to look for harmful content in the words that you would use. Are those shared are those public, or is that an internal proprietary information regarding how you go about analyzing content regarding its harmfulness versus censorship?
So many of the platforms include kind of the content guidelines, what is acceptable, was not acceptable.
Specific words that an AI algorithm would use, you know, Trump, church, guns, whatever.
I don't know, sir. I don't know the inner workings of that specific companies.
So they're not really public record other than kind of the drop.
No, I just personally don't know.
You do not know? Okay. All righty. Well, the concern here is not harmful content. I think everybody on this panel believes that the harmful content as delineated by Section, I guess, 230 and should be monitored. But the pushing of that allowance into censorship is something that really invades our Constitution, constitutional rights, and offends and really puts our constitutional republic in jeopardy. So I'm obviously very strongly for this bill and opposed to the actions that your companies that you represent are taking.
Members, other questions?
I've got one, Mr. Chairman, at the end.
Senator Hughes, you're recognized.
Thank you, Senator. And thank you for being here. Thanks for your testimony. I'm going to show you an exhibit. We want you to take a look at it. We'd like to get your opinion on it. The committee should know we asked, go ahead and let him look at it if you don't mind. We asked Facebook and Twitter and Google in writing, invited them to come, and they're not here. And so now they've got folks all around here. But anyway, so I want you to take a look at that. And I'm going to show this to everyone else. I'm going to represent to you that that's a picture of a Facebook ad that the Senate Republican caucus tried to run during the last session. I'm going to read this, and then I'm going to show it to the cameras. And the language, it's not too long. It says Texas Senate Republicans do not want a repeat of what happened in New York and Virginia, which is why passing Senate Bill 23, Texas Born Alive Infant Protection Act, is of the utmost importance. All of the Republican female senators are joint authors of this bill: Colcourse, Buckingham, Campbell, Huffman, Nelson, and Paxton, and Senators Betancourt and Perry are co-authors. Senator Colcourse said it best: any baby born in Texas is going to be respected as a human being. Where Washington, D.C. has been unclear, we're going to be very clear. Texans stand united for life. Share if you care about protecting those who cannot protect themselves. Did I read that correctly?
I wasn't following, but I believe so, sir.
I'm sorry, I couldn't hear you. Did I read that correctly?
I believe so.
Okay, and I'm going to turn this around. Do you see that picture of the little baby on the ad? I'm going to turn this so folks who are watching on TV can see this. So it's got the text that I read, and it's got a picture of a little baby. Am I representing it well?
Yes, sir.
So you were talking about harmful content. Now realize you weren't part of the decision, or I hope you weren't part of the decision to block this. Tell us what's harmful about that.
Sir, I have no opinion. I don't work for Facebook, and I can't speak on their behalf.
So let's put it this way. Based on what you know about content moderation, you're here representing these companies, should a post like this be blocked?
First of all, let me correct. I represent TechNet, which has members of the companies. I can't speak for those companies, and I don't know the inner workings of Facebook and their content moderation policies and what occurred in this specific case.
So laying aside what happened here, let's give it a hypothetical. Let's say I wanted to run this ad today. I'm asking you as a Texan, as an American, and as someone familiar with content moderation, should this post be blocked?
Sir, I have no opinion on that. Again, I can't speak for a company. I don't know the inner workings of a social media company with their guidelines, so I can't.
Do you believe there's anything harmful based on what you see on the page in front of you?
I don't see anything harmful, sir.
Do you see anything lewd, obscene?
No, sir.
Lascivious?
No, sir.
Filthy?
No, sir.
Excessively violent?
No, sir.
Harassing?
No, sir.
Okay, just making sure. Thank you very much. Thank you, Mr. Chairman.
Thank you. Thank you, Mr. Esparza. Next witness is Paul Anthony Hale. Mr. Hale, if you would join us. And then on deck, Steve Del Bianco. I hope I'm pronouncing that correctly, Steve. You are on deck. Mr. Hale, if you would, state your name for the record, whom you represent. And then the floor is yours when the green light comes on.
My name is Paul Anthony Hale. I'm from Cass County, Texas. I represent myself and many citizens from Cass County. Let the record show I wholeheartedly support Senate Bill 12 by the Honorable Senator Brian Hughes. I have several reasons, and my first one is freedom. I was born and raised in Cass County in a free country, and I find it appalling that billionaire technology companies abuse the freedom given them by our founders, ancestors, and living veterans of wars. It sickens me to see these companies use their freedom to take away mine. These companies capitalize like no others in history and turn against not only the nation that gives them this ability, but also against their very own customers. As they abuse the freedom to capitalize, they encourage communism, uplifting it by allowing the offensive postings and promotions of it while stifling the ones that speak against it. Almost unbelievable here in the land of the free. Big tech takes hypocrisy to a new level. while scolding the leaders of foreign nations for suppressing free speech that disallow their companies there, they suppress their own loyal customers' free speech in the free nation that put them where they are. They uplift enemies of the very nation that made them successful by siding with them, no matter how wicked, evil, terroristic, or repulsive they are. They have dishonored our flag by blocking postings of the Star-Spangled Banner. They have been very successful in proving just how much they hate America, the nation, and its citizens. All of this is so baffling and against common sense. I think it's time to launch massive and exhaustive investigations into these heavy-handed technology companies that now have so much power and money, they do not care what anybody thinks, are in the positions to lose millions, even billions, to carry out the obvious agenda of hatred toward the citizens of the nation that gave them rights. What we see each day is too troubling to ignore the question of which nations are pulling their strings while we attempt to defend ours from enemies. A grim reminder is given daily as we witness big tech companies take part in the hideous cancel culture, siding with anything and everything that is downright evil. Big tech sides with mainstream media and stifling, blocking out, and canceling truths that affect our culture in negative and divisive ways. They have taken sides so unconditional with groups that are so wrong, the footage of the subject violence on the news scares children in the presence of a broadcast of it. The siding with evil is now manifested in a faction of our U.S. government that is actually encouraging hostility, even to the point of violence to anyone that doesn't agree with anything and everything they say. These companies block postings of certain politicians' recorded footage and speaking to cover for their embarrassment, lies, and evil deeds, while also blocking the good deeds of others and allowing negative postings of them and fraudulent lies against them. This assault on freedom of sharing truth of legislative culture disheartens many people's confidence in our political system, confuses others, and provokes anger and frustration from those who only want the truth. Tech companies should be fined for intentionally distorting truth by political discrimination. Tech companies should be fined more for taking away someone's freedom. I cherish my freedom more than any other right allowed by God and prescribed by our founders. My freedom underlines and upholds all my other rights I hold so dear. My next reason is religion.
Mr. Hale, in the interest of other folks that have testimony as well, I want to open it up to questions among the members. We do have your written testimony.
Okay.
Members, questions of Mr. Hale?
Mr. Chairman.
Senator Hughes, you're recognized.
Mr. Hale, thank you for being here, taking time to be here. And I know when we spoke about this before, you told us about how you, on social media, you like to comment on things. And of course, I know you're a gentleman. I know you're a Christian. I know you're careful what you say. You don't post ugly things or offensive things. But as I recall, you were telling me, but because of all these people getting blocked, it's caused you to pull back and be real careful what you say, lest you get knocked off. Will you tell us about that? I want to make sure I got that right.
Yes, sir. I've got common sense. I can tell what people get put off for, and so I have. I've held back, particularly with religious things. I didn't want to start a fight, one that I couldn't win. I don't want to take a knife to a gunfight, and so I've held myself in check. I started using one of the companies in 2019, and I never was a user until 2019. I really didn't want to do it, and I went fishing all over the country. I went to all 50 states fishing. I wrote a series of articles called Fishing America, and everybody that I knew wanted to see the pictures, and so I started Facebook by that. I never had any trouble with them on that. I've only had one line of my personal postings tagged, and they tagged me for a question that I asked regarding COVID-19. That's their holy grail, and they don't want anybody questioning any narrative, period. And so they tagged one of mine when I questioned why was this man-made disease manufactured. So I'll give it to them. I don't have proof. I can't see it, but it seemed that it was. But I would like to I won't read all that, but I would like to touch on one of those religions. I have a friend that lives right up here at Round Rock, and I called him last week, and he told me of a ministry that he had. I called him. I said, "Hey, are you guys having service Wednesday night?" He said, "Yeah, we're having a Celebrate Recovery," is what he calls it, and he reaches out to the troubled citizens of Round Rock. And as my written testimony will show, this guy and his wife pours their heart into this community, and they tried to invite people from the community and just post their website and just post the name of their church up, and it got pulled down. And so my question, as you'll see, is why in the name of all that is good and for the love of God would someone pull down a post that invited troubled people to a place when they have no other place to turn to? These people are drug addicts and alcoholics, and their ministry is doing something that most ministers will take off and run from. And so I guess I'll leave with that question regarding religion. And I had several other points on it, but I know, and I do respect the other witnesses too, but I want to thank everybody I want to thank the Lieutenant Governor and the whole Senate body for letting me testify. And thank you so much, Senator Hughes, for doing this. You're doing something that the U.S. government should have done for us, but we've got to start somewhere. Thank you from the bottom of my heart.
Thank you, Mr. Hale.
Thank you.
Thank you. Chair calls Steve Del Bianco. Steve, I don't know if I'm butchering that or not. And then on deck, it looks like James Hines of Round Rock. You're on deck, Mr. Hines. I think that's how it's spelled. With that, Mr. Del Bianco, you are recognized. You have 2 minutes. The floor is yours.
Thank you. I'm Steve Del Bianco. I'm president of NetChoice. That's a national trade association that represents the tech industry, including Amazon, Facebook, Twitter, and Google. And naturally, my members have grave concerns over SB 12 and the committee sub, but I'm really here to explain why this bill is a bad move for conservatives. As a lifelong conservative, I remember in the 1970s going door to door for Richard Nixon, canvassing to find members of the silent majority out there. And I can tell you there was no way for people in the silent majority to find each other across town or around the country. But today, when I share conservative views, my conservative views on social media, I tone it down so that it appeals to moderates and independents who are among my friends on social media. And that kind of reach was impossible before the era of Facebook, Google, Twitter. So I am alarmed to hear conservatives wanting government to regulate social media in ways that would actually alienate moderates and independents who determine elections in state and federal. You know that the government, your government, cannot force the Austin American Statesman to carry your op-ed which would favor the end of COVID lockdowns. You can't force them. Why? Because the First Amendment prohibits government from compelling people or newspapers to carry speech they don't want to display. So how do you figure that Texas can somehow force Facebook, Twitter, and YouTube to carry speech that's against their community guidelines? I'm not a lawyer, but I spent a pile of money with lawyers with the world's largest law firm who gave me a memo suggesting that this bill has provisions that will violate the First Amendment. It'll likely be enjoined by courts and overturned, and then what? All you'll have done is to encourage moderators by confirming that state governments are powerless to violate the First Amendment. Or if this bill were to survive a First Amendment challenge, then what? Texas is working right now to lure Silicon Valley companies to relocate here. But what does this legislation say about Texas's respect for the company's First Amendment rights? And I get that Texas conservatives, like me, want to attack social media for their content moderation, but please, channel your outrage and provocative talent on right-leaning social media websites like Parler, MeWe, Gab, and Rumble, where they don't moderate nearly as bad. And to close, I would say, let's preserve and participate in those huge social media platforms that reach a broad range of modern independent voters, because that's where we can get our message out. So if you're more interested in winning elections than fighting the culture wars, I think you're a no on SB 12. I look forward to your questions.
Members, questions of Mr. Del Bianco? Are you pushing? Senator Swartner, you're recognized.
Thank you, Mr. Vice Chairman. You call it content moderation, but really what's happening is that individuals are being blocked, posts are being taken down indiscriminately in the opinion of certain individuals. You saw the last, you represent Facebook, right? Look at that right there in front of you, which was a Facebook post that the Senate Republican caucus of the state of Texas put out regarding a pro-life measure. And it was taken down. What do you have to say about that? Is it an inappropriate post according to the content moderation policies of Facebook, a company you represent?
Mr. Chairman? Thank you for the question. Vice Chair Birdwell and I were both members of Emmanuel Christian Church, Emmanuel Bible Church, Springfield. I am as pro-life as anyone in this building. To my mind, this ad doesn't violate any guidelines. But I actually know the facts behind this ad.
Well, good. Tell us.
May I please? The ad violated Facebook's rules that say that when you pay for an ad, you can't say in the ad, please click here or please share. Strangely enough, when I run ads on Facebook, I'm subject to the same provision. So the pop-up that they gave as to why the ad was disallowed was ridiculous. It was stupid and wrong. That is not why the ad was disallowed. It was disallowed because they violated a particular ad policy, and 2 or 3 changes to the words in the ad should have restored it immediately. And these companies, as the previous witness had indicated, they get it wrong occasionally, maybe very frequently, but not high as a percentage of the millions of content that comes in. And when I say get it wrong, I mean they get it wrong against their own community standards. They are not held to the First Amendment. The First Amendment of the Constitution restricts government from imposing conditions on the speech of us as individuals, the church, the Austin American-Statesman, and Facebook, Twitter, and YouTube. In other words, the First Amendment protects them from you. It doesn't protect the rest of us from those companies. So there's a fundamental misunderstanding of what the First Amendment prohibits. It prohibits government forcing you to carry speech you don't want to carry.
But as such, these companies act as the town square in the modern day world. And as the town square, should not viewpoints be fully allowed to be expressed on there, as long as they are consistent with not being inappropriate regarding content? That is the question at hand that's trying to be addressed by this bill, I believe. And unfortunately, these companies have taken it beyond just content moderation to a point in which viewpoints, which should be welcomed, all viewpoints in America, in our country. Where's the line that's being drawn here? It appears to be a line that is tilted, a table that's tilted, and allowing certain viewpoints while oppressing and censoring other viewpoints. Who gets to make those calls?
Mr. Chairman, if I may, then
you don't have to be.
Okay, none of that formal
you make
stuff here in
dialogue
Texas.
without having to be recognized each individual time.
Thank you very much. It's a great question. And what's key to understand is that the Austin American-Statesman can have a slanted viewpoint. They are not going to run your editorials and op-eds or my letters to the editor on pro-life or pro-reopening of the economy, and they don't have to. It's the First Amendment that protects them from you forcing them. Facebook, Twitter, YouTube are in the exact same position. Now, Senator Hughes has argued that maybe they're a common carrier, or I heard you used an expression that Senator Hughes tried last Friday in the press conference with the governor. You called it the modern public square. And as for that argument, the notion there is that the First Amendment can be kicked to the curb because they're the modern public square. Well, the Ninth Circuit just last year affirmed that that is not the case. PragerU is a fabulous YouTube channel with educational videos that are conservative in nature. They enjoy free distribution on YouTube with over 1 billion views so far. But Prager sued Google a little over a year ago because 5% of Prager's videos were tagged as inappropriate for children, tagged by YouTube as inappropriate for children, so they were not visible in a home where the parents had turned on restricted mode. So Prager argued that that violated their First Amendment rights. Let me read what the judge ruled, and it was affirmed by the Ninth Circuit. Quote, despite YouTube's ubiquity and its role as a public-facing forum, it remains a private forum, not a public forum subject to judicial scrutiny under the First Amendment. So courts When they have litigated it, they're not looking at 230, Senator Hughes. They're looking at the First Amendment. And I haven't brought up 230 at all today, because that's not the issue. It's a First Amendment problem that your bill is going to run into. Your bill will be set aside by court, most likely, and at which point you'll have proven that states are powerless to force social media to carry speech they don't want to carry. And what you have to recognize is that the social media companies, they're just businesses. They ought to be respected in a place like Texas. They're just trying to run a business, and they are catching hell from both sides, Senator. You know that here in Texas, we're squeezing them for moderating too much content, but you know in every blue state and in Washington, D.C., they're getting hammered for allowing too much conservative content. So finding a balance in the middle there is a precarious place, and those companies have a tough row to hoe, but they are protected from you by the First Amendment, not vice versa.
So they're not the public square, they're just businesses trying to make a buck.
I thought the judge's words were better than anything I could say, is that despite their ubiquity and their role as a public-facing forum, the court said it is private, it is not public, and it is not subject to First Amendment scrutiny.
I would disagree with you, but thank you for your answer.
Thank you. Senators, other questions of the witness? All right. Thank you, Mr. Del Bianco. I appreciate it. Thank you for joining us today.
Thank you.
Chair calls James Hines. Did I say that correctly, James?
That's correct.
All right. Thank you, sir. And then on deck, after Mr. Hines, is Michael Openshaw. And Mr. Hines, when the light turns green, you have 2 minutes. Please state your name and whom you represent.
Okay.
Thank you, sir. The floor is yours. Turn the green light on. There you go.
All right, thank you, Mr. Chairman and members of the committee. I am James Hines, the Director of the Southern Region for the Internet Association. I appreciate the opportunity to address Senate Bill 12 today. We have submitted a letter to the committee addressing our opposition to the bill. I'll start off with SB 12 is unconstitutional because social media companies have First Amendment rights in their content moderation decisions. It is well established that companies covered by the bill have First Amendment rights in these decisions. Justice Kavanaugh relatively recently wrote for the Supreme Court that such rights are an inherent part of their property rights. So we believe that SB 12 is unlikely to survive scrutiny in the courts based on the First Amendment. But even further, Congress made it clear that it was the intent that Section 230 should empower social media companies to engage in content moderation. Section 230 has allowed platforms to make their services safer for users, to delete harmful content, dangerous content, and illegal content. And the companies are working very hard to do this consistently through the use of AI or machine learning and through human content moderation. And these are services that are continuing to improve over time. With respect to some specifics of the substitute on the disclosure requirements, all the disclosure requirements from the statements of acceptable use policy to notices to users to transparency reports are so detailed that they would make it easy for bad actors to evade detection. For example, having a social media platform disclose its search ranking and algorithms to determine results will inform bad actors how to get around the content moderators. With respect to the censorship portion of the bill, Section 143A, it is inconsistent with Section 230 because it prohibits the removal of lawful expression. And that's the dichotomy that's probably worth talking today, is talking about the difference between lawful expressions and unlawful expressions. If I may.
Thank you, Mr. Hines. Members, questions? Before we go to questions for the witness, Senator Schwartner, I have to go introduce a constituent and nominations in a matter of moments. So as soon as we take care of this, and I'll hand you the gavel and the remainder of the witnesses. So, members, questions of Mr. Hines? All right, hearing and seeing none. Thank you for joining us today, Mr. Hines. We greatly appreciate it. Chair calls Mr. Openshaw, and with that, I will pass the gavel to Senator Schwartner. And I'll be back momentarily.
Pass it.
Have a seat, sir, please.
I didn't know if you were passing it to get the hammer closer to me. I don't know.
Please state your name, position on the bill.
Mike Openshaw, Plano, Texas, and I am here to testify in support of this bill. I listened to the previous people who actually work for these tech giants. He says, well, they're a private company. You can go into Parler and do this. What did they do to Parler? The tech giants, as essentially board of directors with a monopoly of power of this town hall, this town square consideration we have, went out there and slew it. They just killed it. Okay? They are working as a monopoly, essentially, in conjunction with each other. It's like an oligarchy that's sitting around as a board of directors, deciding on what speech is going to be permitted. In that, because this starts to bring into stuff that's essentially antitrust, and we really need to pass laws like this that do end up as court cases. We do need those court cases to discuss a little more regulation or whatever, to the point where conversation isn't closed completely down. I'll give you an example. Google, a very simple question sometime. How many genders are there? First page gave me a list of 7, 12, 15, 21, 35, 53, 56, 63, and 64. The one answer that it didn't give is the one that the largest percentage of people in the United States believe: 2. Okay? Now, you can agree or disagree with that consideration, but the fact is that information is being massaged and opinions are being removed from this town square environment that is social media.
Thank you, sir. I appreciate your testimony. Members, any questions of this witness? Okay, thank you. Is there anyone else wishing to testify on, for, or against Senate Bill 12 orally? Hearing none, members, we do have Office Attorney General here as a resource witness. We'll let them not come up. And then there are a number of individuals registering on the registering a position on the bill but not wishing to testify. Without objection, we'll enter that into the record. So ordered. With that, Mr. Chairman, we will leave Senate Bill. We'll close public testimony and leave Senate Bill 12 pending.
Thank you, Mr. Chairman.
Chair lays out Senate Bill 219 and recognizes Senator Hughes to explain his bill.
Thank you, Chairman. Senate Bill 219 is about who bears responsibility when something's wrong in the plans or designs for a building project. There are 2 options for who should bear the burden. The current rule in Texas, and I'm quoting, for an owner to be liable to a contractor for a breach of contract based on faulty construction specifications, the contract must contain terms that could fairly imply the owner's guarantee of the sufficiency of the specifications which were provided to the owner by an architect. End quote. That's the Texas rule adopted in 1907 and reaffirmed back in 2014. It says the contractor is responsible not only for building the project, but also for the soundness of the complete design as well. Now, the second approach is this. And I'm quoting, if the contractor is bound to build according to the plans and specifications by the owner, the contractor will not be responsible for the consequences of defects in the plans and specifications, end quote. That is from the Supreme Court of the United States, and it's been adopted in the vast majority of other states over the last 100 years. It says if an owner is hiring and requiring a contractor to build according to the plans the owner provides, the contractor is not responsible for those plans given to him by someone else. Of course, when a court has a set of facts before it, it's limited to those facts and certain common law principles. Courts have limited options to solve these problems, as it should be. We, as the legislature, do not have those limitations. When courts get it right, the law stands, and when they do something that we think is inconsistent with good public policy, the people of Texas acting through the legislature can intervene. And so 36 states follow the second statement. Only one follows the other. And so I filed basically the same bill in 2017. It was Senate Bill 1215. It passed this committee 8-1 and the Senate 29-2. And the bill says this, that a contractor is not responsible for the consequences of or defects in a design that someone else created. The bill does not let the contractor off the hook if they build something wrong. If they build it wrong, they're liable. But if they perfectly build what someone else designed poorly, that is not the contractor's fault. The bill also does not let the contractor off the hook if the contractor was part of the design process, or if the contractor knows or becomes aware of conditions that make this design not working. If the contractor knows it won't work, he has to speak up or he'll bear responsibility for withholding that information. The witnesses will be able to fill us in on how these principles work in practice and why this bill represents the fairest way to assign responsibility for the role each person plays. Let me stress this. This bill is far from agreed to. I don't want to represent that to you. We've been working with stakeholders and leading up to this hearing, and today we want to hear from all the stakeholders, and then we'll spend this week working on solutions that retain the fundamental fairness principle here, but do so in a way that it's as tailored as we can make it. So I'll be asking the chair to leave this bill pending today, but we do want to have an important discussion.
Thank you, Senator Hughes. Members, any questions of the author? Hearing none, we're going to open up public testimony. The chair calls William Westcott of ABC of Texas, or AGC of Texas, I'm sorry. Thank you for coming. Please state your name, position, and begin.
I'm Ben Westcott. I'm here on behalf of ABC of Texas and AGC Texas Building Branch. I am the managing partner of Andrews Myers, a construction law firm. This is what I do all day long, every day. Senator Hughes said it best. What we're really after here is making sure that the party that prepares the plans is the party that is responsible for problems or defects that it creates in those plans. The simplest example I can give you is a triangle. The owner is at the top of the triangle, the architect or engineer is at the left side of the triangle, and the contractor is on the right side of the triangle. In Texas, we have a broken triangle. The large majority of the states, in fact, when you look at the case law and the statutes, 49 of the 50 states follow the opposite view of Texas. We have a problem in Texas. The contractor is the party that ultimately ends up being responsible for defects in the plans prepared by other people. We have a broken triangle. The broken triangle results from the contractor not being able to pursue the architect or engineer directly for defects in those plans through something known as the economic loss rule. So in order to fix this problem, the most effective way is through the statute that you have in front of you. It ensures that the party who is responsible for preparing the plans is in fact the party who bears the risk of dealing with the liability of those defects in the course of construction. And so, in our mind, the contractor right now is being unfairly burdened with the risks of defects in those plans and is forced to overcome the defects in those plans through contract language. The owner puts that risk on the contractor through the contract. That's the reality, and the contractor can't do anything about it. That's why this statute needs to be passed.
Thank you. Members, questions?
Yes.
Senator Lucio, you recognized.
Thank you, Mr. Chairman. So the legislative intent of this bill is to make sure that everyone understands the role of the contractor and that the contractor be free from liability if he follows the design plans of the engineer or architect, correct?
Yes, sir.
Who signs off at the end of the construction to decide whether or not the design, the plans were followed to the T?
In most instances, that's the owner or the owner's representative. They would do a walkthrough inspection at the end. They would also do periodic inspections throughout. And the owner is the party who designates who performs those inspections.
And once that is done, then the contractor is no longer liable under this piece of legislation for the part that he took place in the construction of that building.
Yes and no. Yes, to the extent that the contractor follows the plans. No, to the extent that the contractor does not follow the plans.
But you said that if it's whoever, the party that accepts the construction as is, signs off, at that point, the liability is lifted from the contractor. Is that true under this piece of legislation?
No, sir. That is not correct.
Okay. Well, tell us what is correct.
What is correct is if the contractor follows the plans as drawn or the specification as written, the contractor would not be responsible for defects in how those plans were drawn or how those specs were written. In other words, if the bridge was under-designed and it could not support its own weight, if the contractor built the bridge exactly as drawn and specified and the bridge collapsed, then the contractor would not be responsible if the bridge collapsed because the design was defective.
What I'm trying to ascertain is this, that someone at the end of that construction period is going to sign off that everything has been followed, every design that was put together by the engineer or architect or both has been fulfilled. What I want to know is at what point, if I'm the contractor, can I feel that I am no longer liable for that construction?
I'm going to try to answer your question as best I can.
You understand where I'm going?
I do.
Okay.
I think that certification would be a piece of evidence in the case about whether or not the plans and specifications were followed. I do not think that would prevent the owner or the owner's expert from providing contrary testimony that that certification was somehow inaccurate or improper.
So they still have an open door to the courthouse.
Yes, sir.
I liked the legislation, quite frankly, because I don't think a contractor should be held liable if he or she or the company fulfills, what the design calls for. I do feel that way, personally. But I want to make sure that, this piece of legislation does that, lifts that liability, but if it can be proven at a later date, it still doesn't relieve them of that responsibility. That's what I'm hearing from you.
Yes, sir.
Thank you.
Thank you, Senator.
I've
the same lines of Senator Lucio's questioning regarding the responsibility and liability of the contractor. The contractor in this bill is defined in lines 18, 19, 20 of the first page. Is that a general contractor definition? Is that a rewrite of what a contractor is, or is that a... When you say contractor, you're referring to general contractor, right?
It's a very common definition of contractor, yes. We have had some questions raised about whether it appropriately addresses subcontractors, and that's one of the things we'll be working on as part of the committee substitute process.
As a contractor, and I'll just hypothesize that this means general contractor, does a general contractor have an added obligation as kind of the go-between the owner and all the various parts that are helping build that, including design, including engineering, including subcontractors? They are what, I've built a couple of buildings, and I always look to my general contractor. I didn't go ask. They were design build, so I guess it's a little bit different. But I didn't go seeking out the engineer or seeking out the architect or seeking out the subcontractors. I always went to that point person. And as such, ridding the contractor of liability of the design would be somewhat inappropriate in the sense that they have an overall obligation to the project. Am I wrong in thinking that way as a consumer of a person that's built a building?
Yeah, I want to go back to something I said in my initial comments. The party that prepares the plans is the one that should remain responsible for those plans. And in your scenario, I heard you say design build.
Yeah, they were design build.
That's a big difference. If I'm being paid as the contractor to design the building, then this statute doesn't apply. Okay? Second point, if I am the contractor and I see something, I have to say something. And so this is not a situation where the contractor can just wait around for problems to fix themselves. So this encourages an interactive process as opposed to what's happening now with contract language. The owner is shoving all the risk on the contractor, and there's really not that much the contractor can do about it.
Other than not work with that
other
design
than
company again.
not bid the job, right?
Right. Thank you. Any questions?
Mr. Chairman,
Senator Hughes. Sorry.
Thank you. No, thank you.
I should let you ask.
Thanks. Mr. Westcott, thanks for your testimony. You were describing that triangle, and you mentioned the economic loss rule, how that interrupts it. Will you explain that for me?
Sure. So ideally, in other states, other than Texas, if I had a problem with a set of plans, the bottom of the triangle would not be broken. I could make a claim directly against the architect or engineer relating to defects in the plans or specifications. In Texas, that triangle is broken. There is no way for the contractor to make a direct claim against the architect or engineer because they are not in privity of contract. Many, many other states leave this issue to the courts, but in those other states, the contractor can sue the architect or engineer. We cannot do that in Texas, and that's why this statutory fix is necessary.
Thank you. Thank you, Mr. Chairman.
Members, any other questions for Mr. Westcott? All right. Thank you for joining us today, Mr. Westcott.
Thank you very much.
Mr. Chair calls Peyton McKnight, and then on deck is Jeffrey Brannon. Mr. McKnight, if you would, state your name, whom you represent, and you have 2 minutes, and the floor is yours.
Thank you, Mr. Chairman. My name is Peyton McKnight, and I'm the president of the American Council of Engineering Companies of Texas, representing about 450 engineering firms here in the state of Texas. Thank you, Senator Hughes. We've worked with his office and with his staff. As the bill is drafted, we're against it. As was explained previously, on the three-legged stool, this is shifting risk from the contractors to the owners. However, the third leg of that stool, the designers, the engineer, or the architect, when you shift risk, the owner is not just going to simply accept that risk. More than likely, they will turn to the designer and ask for perfect plans. And I will tell you, and probably anybody in this room will tell you, there's no such thing. And they will do that by asking for a heightened standard of care. There is language that is in this bill, or the second portion of the bill, that speaks to standard of care. However, it was incorrectly drafted, and again, because of that, we're still against the bill, but are working with Senator Hughes' office to try to get us to neutral. Be happy to answer any other questions.
Okay. Members, any questions of Mr. McKnight? All right, seeing none. Thank you, Mr. McKnight, for joining us. Chair calls Jeffrey Brannon, and on deck will be Hope Wells. So, Mr. Brannon, if you would, state your name, whom you represent, and you have 2 minutes, and the floor is yours.
All right, thank you. I'm Jeff Brannon.
I'm the Senior Vice President and Chief Legal Officer for Balfour Beatty Construction. We're a national builder that calls Texas home. This is our principal place of business. Y'all may know us because in recent past years, we've done more than $1 billion of construction in Texas alone. We've been throughout the state. And I'm here today to talk in favor of Senate Bill 219. As a builder, we build people's dreams. We adhere to one maxim: follow the plans and specifications that are drafted by others, that are created by others, that are dreamed by others. Our job is to build their dreams, not to draw them. That responsibility falls to the licensed professionals. Since 1937, the state of Texas thought it was important to license architects and engineers. It did this because what they do is difficult. It requires years of training, education, experience. In many cases, it requires specialization. Senate Bill 219, for me, reiterates that these professionals should be the ones held responsible for their actions. As a builder, we review the plans and specifications before we build things, but we don't redraw them. You don't want us to. But right now, we can be held liable for them, even when we follow the plans and specifications. Even when we raise the issue, we can be held liable. So we have to think about it in those terms. We can do our jobs perfectly, build it in accordance with the plans and specifications, and still get sued when those are wrong, even though we didn't draw them, even though we're not licensed to draw them. It seems fundamentally unfair, seems fundamentally wrong, and it seems anti-Texan that there's this lack of personal responsibility on the part of the professionals that we chose to license to do their jobs. Thank you.
Thank you, Mr. Brennan. Senator Lucio, you have a question.
Thank you, Mr. Chairman. Thank you for all the people you've hired over the years. It's important for me to understand, not being in the profession or the professional profession who draws up, designs buildings, but also wanting to know what people like you who are professional builders go through. And I really need to know from you, and I kind of visited a little bit in my remarks before and the questions I asked, at what point do you think you should be relieved from any burden of liability based on your work and what you believe you have fulfilled is in terms of specifications of a building?
If we built the building in accordance with the drawings and specifications and something was wrong with them, I don't think we should have liability for that. I think to Mr. Westcott's point, and one of the things that the bill addresses, is that there is responsibility to point out problems through the building process, through the pre-construction process. We absolutely will point out those things. And if we fail to do that, and if we saw something that was obvious and we failed to do it, like recently we built an almost 700-foot building in Austin, Texas. When we received the drawings and specifications for that building, the structural drawings and the architectural drawings were off by 12 feet on the height of the building. We sent in what's called a request for information, an RFI, and said, what do we do? Which way do you want it done? How do we do that? Now, the architect rejected our RFI, which to me wasn't an option, so we had to push the issue. But once we pushed the issue and we got the answer, and if we built it in accordance with the answer, at that point, yes, to your point, I think that's where that liability falls off. Now, if we didn't build it in accordance with it, that's where things come up differently. And when the owner checks off the box at the end and says, yep, you built it in accordance with the plans and specifications, that doesn't relieve me of liability unless I actually did build it in accordance with the plans and specifications. To Mr. Westcott's point, they will still argue that I have liability and that I ought to come back and fix things.
Well, there's got to be some kind of inspection that ascertains the fact that you did build it according to specifications, isn't there?
All along the way, there are lots of inspections that hopefully catches all of that.
So there are inspections along the way that brings you to be able to certify at the end whether or not the building, in fact, passed muster.
Yes.
Or all specifications were fulfilled by the builder, correct?
Yes, sir. Yes, sir, absolutely.
And that's what I want. I want to get to know what the process, what's involved in the process of building a building. I think this is a very good lesson for everyone, not only for legislators, but those listening and those trying to learn more about residential, commercial buildings that are being built. And in many cases, people that go into some kind of small business and they're going to be involved in this, for them to know exactly what's involved in the process. So I think your testimony is most important. And I certainly will be looking very closely at making sure that I totally understand that the builder actually went through a process by which there was inspection, the professional designers and those that prepared the plans were involved in those inspections, and at the end of the day, that square that was checked off and signed off should be good enough, to keep the contractors from being sued.
We all hope that's the case.
Well, that's we're going to have to make a decision here. Yeah. If we want to join other states or just keep doing what we're doing now. Yeah. Thank you, Mr. Chairman.
Thank you, Senator Lucio. Members, other questions?
Mr. Chairman, I have one toward the end.
Senator Hughes,
okay.
you're recognized.
Thank you. Thank you for your testimony. And I followed the exchange with you and Senator Lucio, and Senator Lucio was concerned about at some point we would do a walkthrough, we do an inspection, and we know where we are. But let me make sure that I'm clear, make sure that we're all clear. If this bill passes, the contractor is still going to be responsible for his own negligence, right? There's no question about that. This bill would not get you off the hook for any mistakes you made in the construction of the building, right? Even if this bill passes, the contractor is still responsible for their own mistakes, for their own negligence. Isn't that correct?
That's absolutely correct.
Before this bill, after this bill, that doesn't change, right?
That doesn't change at all.
Okay, just want to make sure. Thank you.
Thank you, Senator. Thank you.
Members, other questions? Senator Schwartner, Senator Powell, any? I can't see lights, so, okay. Thank you for joining us, Mr. Brennan. Chair calls Hope Wells. On deck, Jason Martin. If you would, Hope, state your name and whom you represent, and you have 2 minutes. Thank you.
Thank you.
The floor is yours.
Good afternoon, Chairman, members of the committee. My name is Hope Wells, and I'm with the San Antonio Water System. I am testifying today respectfully in opposition to Senate Bill 219 as it is filed. We have had some very good discussions with your staff, Mr. Chairman, and we very much appreciate your willingness to discuss our concerns. Each year, SAWS executes dozens of contracts for public works projects with value in the hundreds of millions of dollars. The opportunity to negotiate the risk regarding the sufficiency of a design document with contractors is critical to the protection of our ratepayer dollars. Current law allows us to negotiate which party accepts the risk for the adequacy and sufficiency of plans, and the contractor is compensated for the work and any risk that they accept. It is the contractor that is best able to inspect the plans prior to bidding and building, apply their expertise in construction methods, and determine if the plans are adequate for the construction of the project. No contractor is required to seek a contract with terms that it finds unacceptable. We therefore attempt to respond to reasonable concerns and feel like we have successfully negotiated a balance of those items in our contracting. Shifting responsibility for design defects to the project owner increases the risk for more change orders, which could potentially delay projects and make them more costly, especially with respect to critical projects for public health and safety like water and sewer. We would appreciate an opportunity, Chairman, to work further with you on language to address our concerns, and again, we appreciate the efforts thus far. Just briefly to describe them, in the critical infrastructure facility language that you have, it doesn't capture all the infrastructure essential to public health and safety, such as water and wastewater infrastructure that is not behind a fence. Much of SAW's infrastructure consists of water and sewer pipeline that's contained in the public right-of-way and not necessarily behind a fence. So we would suggest broadening the language to potentially include or to capture the facilities for public water suppliers like SAWs in that current language. We would also like to clarify what the definition of a person with respect to that critical infrastructure language, which is something we could talk to you further about. Finally, another suggestion would be striking the non-waiver language contained in the file version to allow an opportunity to contractually address this issue or address it by alternative delivery method we've talked a little bit about here today. Thank you for allowing me to testify. And again, we look forward to working with you further on this bill. Thank you.
Senator Schwartner, you're recognized.
Thank you, Mr. Chairman. I thought this only affected real property, but you're with SAWs and you're talking about water infrastructure in front of and behind the fence. So what's your understanding of what is covered regarding design defect bill?
Well, as it talks about construction of improvements, addition or repair, well, I'm sorry, I would probably have to get a little more clarification of that from the attorneys within SAWs that work directly on these projects and on our contracting measures, but my understanding from them is this would apply to those projects. Their understanding legally it would apply to those pipeline projects.
Pipeline projects as in water infrastructure?
Water infrastructure, yes, that this bill would be applicable to that.
It says in the first page, construction includes, well, it talks about real property. Then real property, then real property. Is that real property? Is that the definition of real property? Pipeline?
Those pipelines. Again, I would have to get clarification from the folks that were working on it, and we can certainly report back to your office on that, but that was my understanding that this would be applicable to our infrastructure in terms of the bill. And again, there's the language regarding critical infrastructure that's contained in there currently that we would want to potentially alter to be more inclusive of that, if possible.
Senator Schwartz, does that conclude? Okay. Senator Lucio, you're recognized.
I'd like to ask a question of the author of the bill. You've heard the witness, Senator Hughes, Mr. Chairman, and her response, or what she was told by her legal staff or attorneys, that this would include water and wastewater infrastructure, as I heard her right. Is that part of your legislative intent in terms of where we're going with this legislation?
Oh, thank you, Senator. In the filed version, we used a definition of critical infrastructure facility that's already in statute. We're going to clarify that in the committee substitute that will address this challenge.
Thank you.
Thank you very much.
Thank you. Mr. Chairman, do you expect a committee sub today, or is that a future?
No, Senator. We just want to have a discussion today. This week, we're going to try to iron out the details and get something that.
Okay, I just wanted to make sure I hadn't missed something in my.
No, it hasn't been sent. It hasn't been sent out yet. Thanks.
Thank you, Hope, for joining us today. We appreciate it.
Thank you very much.
Thank you. Chair calls Jason Martin, and on deck, Hector Rivero. Mr. Martin, if you would, state your name, whom you represent, and you have 2 minutes.
Good afternoon, Mr. Chairman, members of the committee. My name is Jason Martin. I represent the J.E. Dunn Construction Company. I am the general counsel for the South Central region of that company, which covers its Texas and Oklahoma operations. We are a national contractor, but I focus primarily in Texas and Oklahoma. Spend the majority of my time negotiating construction contracts and handling claims when they do arise. I'd like to make a point about the freedom of contract that we've talked about here today. As you may know, in the public arena, there is little to no freedom of contract. These contracts are contracts of adhesion, as we say. In the private sector, even if I've done my very best job and negotiated language very similar to what we have in Senate Bill 2019, due to the Lonergan case that I believe my colleague Ben Westcott talked about, issued in 1907, absent an express guarantee by the owner of the plans, the contractor inexplicably is held liable for the plans delivered and prepared under the owner, a decision which makes no sense. And I would submit to you that it is unachievable to obtain an express guarantee in the contract from the owner or the architect. So an artificially high and unachievably high standard created by the Texas Supreme Court, recently affirmed, or at least in 2012, in their Maztec decision. I'm here today to testify, obviously, in favor of Senate Bill 2019, which stands for the very common sense proposition, the simple proposition, that the party that prepared the design should be responsible for the design. If the owner prepared the design, or it was prepared for the owner should be responsible. If the contractor prepared the design, or it was prepared for the contractor should be responsible. That is what this bill stands for. It is what 49 of the 50 states in this country follow. It is what the United States follows. Texas stands alone in its inexplicable provision of holding the contractor responsible for defects in the design not prepared by him, by a contractor, by an architect under contract with the owner, chosen by the owner, not controlled by the contractor, that the contractor cannot ensure, and had no part in the design. We are bound to deliver a building that complies with that design. So even if I do my job perfectly, as we have discussed here today, I may still end up paying for issues that are not of my creation and are not my responsibility. The current law of Texas lacks any basis in logic or in fairness, and is against the public policy of this state as already has been recognized in its laws passed in the past legislative session in favor of highway contractors. Senate Bill 2019 is very similar to that bill. We ask that it be passed for all construction.
Thank you, Mr. Martin. I've got many more witnesses.
Certainly.
I don't want to.
Yes, sir.
So let me open it up to questions, members, questions of the witness. All right, hearing and seeing none. Thank you, Mr. Martin, for joining us today.
Thank you very much.
Appreciate it. Thank you. Chair calls Hector Rivero, and on deck, Chris Lambert. Mr. Rivera, if you would, state your name for the record, whom you represent. 2 minutes. And,
thank you.
The floor is yours.
Good afternoon. My name is Hector Rivero. I'm the president of the Texas Chemical Council. We represent 70 member companies who own and operate about 200 manufacturing and research facilities across the state. As you all know, the business of chemistry is a critical infrastructure sector, and our facilities are very sophisticated. The contracts for new investment projects or for improvements to those projects are also highly sophisticated and involve very complicated elements and designs. And the contractors that are involved with us in these projects are all also highly educated, very established, experienced, and sophisticated companies that have plenty of leverage in contracting. As you all know, as has been stated here, Texas has always been a free market state and has always historically protected the freedom to contract. And I think the concern we have that is if Senate Bill 219 were to pass as it is right now, it would significantly restrict the ability for two sophisticated parties to be able to negotiate allocation of risk in their contracts. And we think that that would be a setback. It would create a competitive disadvantage with other states that exist. Mr. Chairman, I want to thank you and your staff for reaching out to us and to work with us on a potential exception for critical infrastructure projects. I know that you recognize that these are very highly sophisticated projects. However, I think that there is some concern about the statute for critical infrastructure that was borrowed from the drone statute as it relates to this. And I know that we have some members that feel that their critical infrastructures that are not covered in the drone statute should be covered here. So we'd like to keep working with you on that. We also would like to make sure that we can discuss or continue working with you on maybe an exception for sophisticated contracts, and possibly make sure that we're clarifying where situations where we have a construction company that is actually actively involved in the design or elements of the bill as well. So happy to answer any questions you might have.
Thank you. Thank you, Mr. Rivero. Questions for Mr. Rivero, members? All right, hearing and seeing none. Thank you for joining us.
Thank you very much.
Thank you. Chair calls Chris Lambert, and then on deck, Tim Chauvenek. I hope, Tim, I'm saying that correctly. So, all right. So, Mr. Lambert, if you would, state your name, whom you represent, and
thank you.
You have 2 minutes.
My name is Chris Lambert, and I'm the president of Illinois Electric, a local electrical contracting company here in Austin, Texas. I'm also representing the Central Texas Subcontractors Association and the Texas Construction Association, both of which I'm on the board of. I'm here to support Senate Bill 219. Without this bill, I'm forced into a situation where if I see a defect and the engineer refuses to act, that if I install it per the design under the current law, I'm responsible if it fails. But if I fix it, then I'm engineering without a license. And so I'm caught in a catch-22 where I really have no good answers, and this bill will help close some of those gaps and provide a solution where I'm not being punished no matter what I do. I'm also a design-build contractor, and when my company is the engineer of record, I accept full responsibility for my designs. And if there are defects in the designs, I make sure and fix them. That's just guaranteed. And I have no problem accepting responsibility for those defects. And along those same lines of thinking, when I'm a typical subcontractor, I think the parties that provide the design documents should have to accept the same responsibility. Currently, I'm having to accept responsibility for somebody else's design. And because of this, I have to put my business and my personal assets at risk and on the line. And on top of that, most of these situations, insurance will not provide me coverage because I cannot carry professional liability insurance for anybody else's design. And this comes up more often than most people think. So I've currently got a project right now where I'm in an argument with an owner where he's insisting on installing these electric heaters that were shown on the design documents but weren't taken into the load calculation. And I pointed out to him on multiple occasions that if he does install them, it will overload the service. And he is refusing to submit an RFI to the engineer. And so now I'm caught in a situation where I know it's wrong, and I can't, but I have to follow the design documents. And so I'm caught in that catch-22. Another time, about a year ago, I was involved in a project where I looked at the service design for the project and started doing my calculations, and he had undersized the feeders that feed that project. I contacted the engineer, asked him that this was an issue, does not meet National Electric Code, and he directed me to install it as he had designed it. The GC came to me and asked me, can we just install it the way it's right? And once again, I was forced to tell the general contractor that I cannot change the engineer's design if I'm not the engineer of record, otherwise I'd be engineering without a license. Yeah. And so being a subcontractor, I'm kind of the bottom of the chain, and so oftentimes I'm contractually obligated to not just the general contractor, but the contracts that the general contractor signs with the owners and architects and engineers.
Okay. Thank you.
Thank you for your time. If you have any questions.
All right. Thank you, Mr. Lambert. Members, questions of Mr. Lambert? All right, hearing and seeing none. Thank you for joining us today.
Thank you, sir.
Thank you, sir. Chair calls Tim Chovanec, and on deck, Fred Wilshison. Fred, I hope I'm saying that correctly. Mr. Chovanec, if you would, state your name, whom you represent. You have 2 minutes. We still have a number of people still to testify. So as you see that red light blinking, go ahead and go to green if you would, Mr. Clerk. But as you see that red light blinking, bring your thoughts to a conclusion. Let the caboose on your train of thought come through the intersection. So thank you. With that, Mr. Chovanec.
Good afternoon, Senator Birdwell and members of the committee. My name's Tim Chovanec. I'm a lawyer for the Benbrook Water Authority, BWA, in Senators Powell's and Nelson's district, and I'm here to oppose Senate Bill 219 in its filed form. This is my first time testifying to a legislative committee. There are 2 sections of 219. BWA could, with minor modifications, support Section 1. It limits the liability of building contractors for unknown design defects. Section 2 of the bill, on the other hand, tips the scales too heavily against government entities like BWA in an entirely unrelated area, the standard of care owed by private engineers doing public work. Bridges, water towers, pipelines, vital public infrastructure will be at risk under Section 2. How do we know this? In 2002, BWA found waves in a welded roof of a new water tower up the hill from a residential neighborhood in Benbrook. Turned out the welds were bad, and after years of litigation, BWA won. Left alone, the defective welds could have failed, killing hundreds of people. The standard of care was the key to our case. Under current law, the law 219 replaces, a public works engineer is required not only to be licensed, but they must also be competent and have experience building what they've been hired to build. 219 deletes the competency requirement, which led to our defective tower. There are fixes that are under discussion. Hope has referred to some of the elements, as have other witnesses. And we respectfully urge consideration of those. Thank you.
Thank you, Mr. Chovanec. Members, questions of the witness? Senator Powell.
Mr. Chovanec, could you just concisely state what your proposed changes would be to SB 219 that would fix some of the dilemma that you had at Benbrook?
Yes, Senator. 3 things. Number 1, this is in Section 1, make a minor change to the definition of contractor to clarify that it does not include architects, engineers, and developers. Number 2, also in Section 1, adopt the Homeland Security Act's definition for critical infrastructure from Chapter 421 of the Government Code, instead of the much narrower drone overfly provisions of Section 423, which excludes well over half of BWA's critical infrastructure. So substituting the 421 definition for 423 would solve that issue for us, and I think for the SAW as well that Hope referred to. Section 2, again, this is a relatively simple fix, it would seem. If we can incorporate the definition of standard of care for engineers that already exists in the local government code, Section 271.904, and it's already on the books and it's been adopted. If you substitute that in Section 2 for the current definition of standard of care, governmental entities like BWA probably would not have near the problem with SB 219 that we do.
And had SB 219 been in effect, how would that have impacted your lawsuit?
Well, after our lawsuit, it was $1 million loss for us. And so we had to file suit to try to defray the shifting of the liability from the engineers and the contractors that built a defective tank to our taxpayers and ratepayers. So we took great stock after this event, and we redid all of our contracts to make sure that experienced engineers did our work, and number two, that contractors carefully read our bid specifications before they submitted our bid. Without those provisions, we are back to the pre-loss situation that we have now cured. SB 219, as currently filed, undoes those protections.
I have no further questions. Thank you, Mr. Chairman.
Thank you, Senator Powell. Members, any other questions from any other members? Okay. Thank you, Mr. Chominick. I appreciate it. Thank you. Chair calls Fred Wilshison, and on deck, Will Allensworth. Mr. Wilshison, if you would, state your name and whom you represent. And then you have 2 minutes.
Fred Wilshusen. I'm the general counsel for the Texas Construction Association, testifying in favor of Senate Bill 219. In addition, I've been a specialty construction lawyer. I'm in my 35th year doing that. So this is my area. This is what I do. You've heard really good testimony. You've heard from contractors, you've heard from attorneys, subject matter experts. So I'm just going to pick a few points just to re-emphasize because they're important, but you've gotten good, comprehensive testimony. A couple of points I'd just like to emphasize. As one of the contractors said, they are not licensed to correct any defect in the plans and specifications. That would be a violation of Texas law. You can't contract around that and get the right to correct plans and specifications. You can't get insurance to protect you when you're a contractor as opposed to a licensed design professional. And you have no recourse if the design professional, who are good people, refuse to correct the issue that you raise to their attention. And what if the plans and specifications are furnished by an in-house engineer, an in-house owner, in-house architect? Are they going to turn to themselves to blame themselves for the poor plans and specifications, which many times are very good, and I've represented plenty of design professionals. They're very good, very professional. But if they're in-house, they're going to turn that obligation over to the contractor. I want to emphasize the contractor has every incentive, even after this bill is passed, to raise issues that they see with plans and specifications. They want a building that works. That's in their interest. I don't see Senator Lucio, but I do want to say, this bill passes, it does not change the responsibility of the contractor for poor construction or for latent matters that are found where they did not follow plans and specifications. They are still responsible. Anyway, thank you for your time, and we encourage you to pass Senate Bill 219.
All right. Thank you, Mr. Wilshison. Members, questions of the witness? All right. Thank you for joining us today. Thank you. Chair calls Will Allensworth, and then on deck, Matthew Ryan. And Mr. Allensworth, if you would, state your name, whom you represent. You have 2 minutes. Thank you, sir.
Absolutely. Thank you all. My name is Will Allensworth. I'm here on behalf of the Texas Society of Architects and their 7,000 members. They're opposed to the bill as currently comprised, but come here in a spirit of cooperation to work with the chair and the committee to get a bill that we hope strikes the right balance, but primarily preserves freedom of contract. The major obstacle that we see with the bill is the non-waiver provision, which would interfere with parties' ability to contract outside of the rule. I think for introduction, I'm a construction lawyer. I'm a partner at a construction law firm here in town, board certified in construction law, and I'm also an adjunct professor at the University of Texas School of Law, where I teach construction litigation. I have a personal interest in construction law jurisprudence in this state, but also an interest on behalf of the Texas Society of Architects. Texas law today never has and does not right now require contractors and subcontractors to warrant the sufficiency of the plans and specifications. That's never been the law in Texas, and it wasn't the law. Instead, about 100 years ago, the Texas Supreme Court issued the Lonergan decision, which merely set forth a default rule that parties were free to contract around. Indeed, over 4 decades ago, in the North Harris Junior College case, a public owner had agreed with a contractor that the contractor was not liable for for design errors, omissions, or inconsistencies, and the court thoughtfully said Lonergan does not apply. Since they've put in that one-sentence language in the contract, it no longer binds the parties to that Lonergan decision, that being a default rule exclusively. 2004, the San Antonio Court of Appeals did the same in the Alamo Community College District case. There's been testimony here that contractors cannot, with public owners, negotiate outside of Lonergan. That's simply not true. The appellate record is littered with cases in which private contractors have negotiated with public owners outside of Lonergan. It's important, and the language that was used in those cases is part of the form contracts promulgated by the AIA, the AGC Consensus Docs, and the Engineers Joint Committee Contract Documents Committee. In the interest of time, I want to cede for questions, but our big point is that freedom of contract should be respected. The bill as currently comprised would interfere with owners, general contractors, and architects' ability to contract freely, and we'd relish the opportunity to engage with the committee to make improvements to preserve that freedom.
All right. Thank you, Mr. Allensworth. Members' questions. Senator Swartner, you're recognized.
Speaking of contracts, there's a doctrine in Texas, the economic loss rule regarding seeking redress for grievances amongst the contracted parties. Does this bill somehow affect that, that principle?
Thankfully, no. Not as it. In a way, it can. Let me try and answer your question. My colleague, Mr. Westcott, had raised the prospect that Texas is a triangle and it's broken, and he'd raised a case in the Texas Supreme Court to enforce the economic loss rule, which is simply a doctrine that says a party who's been harmed by a contract should look to their contract, and so you shouldn't be able to look to someone else for damages. You should look to with whom you contract. Any affront in the economic loss rule doctrine is substantively to preserve freedom of contract. The Texas Supreme Court is, so far as I can tell, the most protective court in the country of freedom of contract, and enforcing it as an indispensable partner of markets and commerce. This bill, as currently drafted, does attack freedom of contract, and so I think it does undercut some of the substantive supports for the economic loss rule, but thankfully it doesn't technically address anything with the economic loss rule, and I think it would be a profound mistake for this committee to interfere with the Supreme Court's doctrine of economic loss rule, which has been very good for commerce, very good for freedom of contract, and good for construction jurisprudence, in my view. Respectfully submitted.
Thank you.
Other questions, members? All right. Thank you, Mr. Allensworth. I appreciate it.
Thank you all for your time. Appreciate it.
Mr. Ryan, would you hold for one moment, if it's possible? The chair got a note. Todd Staples is also, his card is in, but former commissioner has to be over in the House for another hearing. So may I get him through here first, give him his wire brushing before yours, if I may, and then we'll bring you back up, Mr. Ryan, and then followed by Mr. McChristian. So with that, chair calls the Honorable Todd Staples. If you would, Commissioner, state your name, whom you represent, and of course you have 2 minutes.
Thank you, Mr. Chairman. Thank you, Senators. My name is Todd Staples. I'm president of the Texas Oil and Gas Association. I appreciate you letting me testify before you today. And I want to say thank you to Senator Hughes for your outreach, your work to try to bring together the differences of the parties concerned. And even with those changes, though, we still are in opposition to this bill. And I want to spend just a minute here today explaining why it's so important we do get this right. Texoga member companies contract with professionals to build our facilities, architects, engineers, and contractors. And because of the complexity of these projects, member companies negotiate very carefully to assign risk, and those parties are very sophisticated parties that are coming to the table to build these projects, sometimes in the billions and billions of dollars. they're doing that so that the experts designing and constructing the facilities are able to be responsible for the administration and the implementation of facility construction. One of our member companies said that they actually pay a contractor extra to look at the plans and specifications in order before they move forward with a project, and that's the role that they have hired them in to fulfill that responsibility. Every project's different. These are big. We appreciate the exemption, but it's not broad enough to cover everything that we do. To statutorily mandate that an expert party, here a contractor involved in the construction process, has no liability, just imprudently leaves premise owners and design professionals holding the bag. And that's what we're hoping to avoid. It eliminates our ability to freely contract. And I know it's been talked about a lot of what other states do. One thing in my remaining few seconds here, we know that no other state has passed a statute that would codify this. It's relying on court rulings. And so Texas would be an outlier, particularly in eliminating the ability to waive this provision, which is part of it. Thank you for hearing our testimony, and be happy to answer any questions that you might have.
Members, questions for former Commissioner Staples?
I've got one if nobody else does.
Senator Hughes, you're recognized.
Thanks. Senator, thank you for being here.
Thank you.
And for what you do and for working with us on this and everything else you work with us on. We understand the importance of folks to sit down and negotiate. You do a lot of that. You do it well in different contexts. Wouldn't it be fair to say, though, in this setting, under current law, when you sit down to negotiate and there's a blank slate, the contractor is already behind, because under current law, not in a design build setting, but in a regular setting where they have nothing to do with preparation of the plans, they're already behind the eight ball. So we're not talking about negotiation from an equal bargaining power, are we?
Well, I think you have some very big firms that are very much engaged in this process and have the sophistication to be able to go in and identify what their roles and responsibilities are and negotiate that. There are very many of them. And Senator, I even think about this from East Texas real estate appraisal days. Constituents of ours would see a set of plans from Southern Living magazine. They take it to a place in Tyler to get the blueprints or buy them. They write out what they want, and they go give it to a contractor. And that contractor builds that. And the way I read this bill, many people would eliminate their ability to have a conversation about what went on if this bill is written as passed.
I think I follow you, but I want to make sure I'm clear. In the situation you just described to us, remove their ability
doesn't
to
the
have
bill
a
just take out the
conversation.
contractor?
Beg your pardon?
Because the way I read the bill, it takes out the contractor from the liability.
It does not take out the contractor from the contractor's liability, but it takes out the contractor from liability for preparation of plans in which the contractor had no role in development or preparation of, and wasn't hired to review in the example you gave earlier.
And see, what we see here, these projects that our members are building are so big and so complex, that needs to be a fact basis that is determined. And if they're not, absolutely, I don't want to push liability on someone, but that has to be determined if that's the case.
Well, it's got to be determined. I think maybe we are sort of maybe we're chasing our tails. Under current law, once the facts are determined, if the contractor who had no hand in developing, preparing the plans, the contractor is still liable. So nothing in this bill would prevent development of the facts or discovery or finding out what happened. But at the end of the day, when we find out what happened, should the contractor be held liable for someone else's negligence, for someone else who developed the plans? No one is saying we wouldn't have a conversation, we wouldn't do discovery, we wouldn't find out what happened. But once we know the facts and we realize the contractor had nothing to do with developing those plans, under current law, he's still on the hook. Correct?
Well,
current law.
Well, I think these projects are so big that when they start that out and negotiate the contract and assign the liability and assign the risk, that every partner needs to be in there together, and your bill would exclude that up front, and that's the concern, that it doesn't allow that, and it doesn't, waivers are prohibited, and that's a concern.
Well, it would not allow a party with overweening bargaining power to, through an adhesion contract, force someone to accept someone else's liability. You're correct. Guilty. You're right. I'll stipulate to that.
I didn't hear everything. I heard the guilty part.
All right. That was the key. You got it. That was the key. That was the key. So it would not allow someone, if this bill would have come up, would not allow someone who has more bargaining power through an adhesion contract to make someone accept another party's liability. You're correct. We do want to prevent that.
Right, and they wouldn't have, no one can make anyone accept it today. If the terms aren't good, you need to walk away from it. There are very large contractors that, I remember companies want to be able to build their projects, and they don't want to get caught up and bogged down and things go on hold while you're waiting to deliver the essential things that are necessary. And I know you've got a waiver for some of those, but some of those wouldn't, are not included in that definition. And so it creates problems. It's just about, why would we want a situation where you couldn't, at the beginning onset of a project, assign risk and responsibility when you draw it up?
Well, Senator, if we're talking about responsibility, clearly, if at the beginning of the project, the contractor has responsibility for those plans, then this bill would not touch that situation at all, right?
I'll defer to you on that.
Okay. Well, that's certainly the intent. I just want to make sure we were tracking.
Yeah. And the whole premise is the ability to have those conversations up front and not to remove one party out of the ability to prepare these projects and get them built.
Got it. To be very, very clear, even on the final version, if we have that negotiation up front and the decision is made, the contractor will have responsibility in developing those plans. Of course, they're on the hook for that. Nobody's trying to touch that. I want to make sure that's
we understand that aspect. Yes, sir.
Good. Thank you. Appreciate you.
Thank you.
Thank you. Thank you, Commissioner Staples.
Thank you, sir.
For joining us. Good luck in the House.
Thank you.
So thank you. Chair calls Matthew Ryan, and then on deck, Sean McChristian, and Mr. McChristian is my last card, so anybody that has not filled out a card that wishes to testify on, for, or against Senate Bill 219, if you would go ahead and please move from the gallery down to the floor and register if you have not done so. With that, Mr. Ryan, please state your name, whom you represent, and you have 2 minutes, and you may certainly by all means testify without the mask on so we can understand what you're saying.
Yes, sir. Thank you.
Thank you, sir.
Mr. Chairman, members of the committee, good afternoon. My name is Matt Ryan. Thank you for the opportunity to testify today. As my law partner, Will Allensworth, has explained, we are here on behalf of the Texas Society of Architects. We are both full-time construction lawyers, and we both teach as adjunct professors at the UT School of Law in construction law and construction litigation. Very clearly up front, I want to make sure that we are just clear as a bell, that we are here to work cooperatively with the chairman, with the staff, with all the members of the committee to focus on alternative language that should be able to get the job done without impairing the freedom of contract that we see threatened here. I would say the same things to you all today that I would say to my law students in a general discussion about this bill. In that sense, this isn't that much about architects or, by extension, about design professionals generally. Our biggest concern is that Senate Bill 219, in its current form, runs against the principles of freedom of contract and private ordering, two of the greatest hallmarks of Texas law and this state's incredible economic rise these last 3 to 4 decades. What we're trying to do here today is to convince all of you that we are here, if we're proposing changes, those changes are only intentionally aimed at getting done what everyone wants this bill to do, and that is not to leave people facing responsibility that shouldn't be theirs. We're hearing proponents say that general contractors and subs are being forced to take on responsibility that they shouldn't. And that's a debate that goes back to 1907 when Lonergan was decided, as opposed to Spearman, the federal standard that is the governing standard in the majority of cases. The biggest problem with Lonergan, as my law partner Will explained, is that it ignores the fact that it's just a default rule and parties are still allowed to negotiate. The non-waiver provision, as I'm rapidly running out of time here, is the problem that we need to address in moving that out of the statute, allowing people to negotiate their own deals and treating Lonergan or Spearin, even if the legislature wants to turn Texas from a default Lonergan state to a default Spearin state, still leave the parties their ability to negotiate contracts and risk. There are mechanisms, delivery systems like construction manager at risk, where owners are looking to the sophistication of a contractor to guide them through, take a hard look at the design. There are fast track projects where the design is literally evolving as the project is getting built. This non-waiver potential here takes away from the parties their ability to negotiate who's going to do what by way of looking at the design. And that's all I've got. Respectfully submitted.
Members, questions for Mr. Ryan? Senator Hughes.
Well, thanks for your testimony and we know this is what you do and you're an expert in these matters. I want to be clear. And I think we're going to agree on this. Nothing in this bill and even the prohibition on waivers, none of that prevents an agreement whereby the contractor is involved in the design. If the contractor is involved in the design, the contractor is on the hook for that involvement under this bill. We would agree on that, right?
I think we'd agree to that to a certain extent, Mr. Chairman. There is a question about how much owners, and this is the underpinning of the Lonergan case in 1907. To begin with, the court went that direction by saying that who, more than a professional contractor, is in a better position to say, yeah, these look sufficient for building, and that if built according to these plans and specs, well, sure, the thing should stand up. And it didn't.
So if we're talking about negotiations on the front end and the parties coming together voluntarily determining the best division of responsibility in the work, I think we agree, I hope we agree, that under this bill, if on the front end we agree to a design bill, the parties agree, contractor, you will have a role in the design. You will be responsible for the design. If that's agreed to, then there's no question under this bill, then the contractor would then be liable for that work. You're not suggesting that we're preventing that kind of an agreement, are you? We're preventing a design build or something like that?
Certainly not, Mr. Chairman. In design build, though, that is certainly a delivery system that has risen and become a more popular delivery system, but we still have the triangle, which I'm not sure there's a bottom element to it because of the economic loss rule, but we still have design, bid, build systems. We still have these rising alternative systems. I talked about fast tracking. I talked about construction manager at risk. There's a sliding scale of sophistication whereunder parties should be free to negotiate the amount to which they can rely on a contractor to say, yeah, I'm going to look at this and I'm going to give you my comments on it, to sweep the table clean of the party's freedom of contract to negotiate whether they're going to undertake some responsibility for that. That's where the problem is, and that's why I'm circling back to this issue. My colleagues whom I've known for a long time, we may disagree on this, but when it comes around to the issue of whether Texas is a default Lonergan state, remember, only if the contract is silent, as opposed to a default Spearin state, which is the majority of states out there right now. That, at least, would give us, if the legislature sees fit to do this and it carries on through, that would make Texas a default Spearin state without inhibiting the party's freedom of contract to negotiate what's in there. It would only control if the contract was silent.
I don't know if our distinctions here are just a matter of semantics, but to be clear, nothing in this bill, in the strongest reading of this bill, would say that the parties are not allowed to negotiate an arrangement whereby the contractor takes responsibility in the development of the plans. If that agreement is made, the contractor is on the hook. No one's questioning that. The question is whether the contractor, who does not have any part in the development of the plans or any input or even power to alter the plans, should be held accountable. Just to make sure we're clear, I'm not sure, this is almost like I think you understand what I'm trying to say, even though I'm not saying it very well. we don't want to mislead folks and make them think this bill would prevent a negotiation where the contractor up front agrees to take part in the design process. If that happens, that contractor is on the hook for that work. Wouldn't we agree on that?
I think we would agree to the extent, again, that it's a design-build delivery system. The market carries a number of other delivery systems, and I think the non-waivable portion of Senate Bill 219 as it now stands does not even allow a contractor to go through the process of saying, yeah, I'm going to take some responsibility for these designs being complete. But that's exactly why we want to work with you with substituted language and continue.
Yeah, let's do, because I don't think your characterization is accurate. Let's do see if we can figure that out. Thank you.
Absolutely.
Thanks,
Yeah.
Mr.
Thank you.
Members, other questions? All right, hearing and seeing none. Thank you, Mr. Ryan, for joining us today. Thank you. Chair calls Sean McChristian, and this is my last card. If anyone else wishes to testify on, for, or against Senate Bill 219, please register. With that, Mr. McChristian, thank you for joining us. Please state your name, whom you represent. And you have 2 minutes. Thank you.
Thank you. My name is Sean McChristian, and I'm here on behalf of myself. I'm a construction lawyer from Houston, and I'm, like several of the other people who've testified today, this is what I do all day, every day. And I'm in favor of the bill, and I understand the concerns that have been expressed about freedom of contract. Freedom of contract is important. But what you have to understand is that in the context of many of the construction projects that we're talking about, the contracts that govern those projects can be 50, 60 pages long. They can be made up of multiple different documents. And inherently what happens, unless you hire one of the lawyers that are here today, is that you end up with conflicts in those provisions. And you'll have a provision that grants one right to one party, and then you'll have another provision that may grant a similar right to another party. And so what happens is you have a dispute that arises, and you have a court or an arbitrator or someone who's having to look at those different conflicting provisions and decide which one is going to control. And the issue, and really where this issue came from that we're here talking about today, is because the Texas Supreme Court was presented with an issue where you had seemingly conflicting provisions. And the court went through and did an in-depth analysis of the contract and came down in favor of one conclusion. But then they supported that by saying, oh, and by the way, since 1907, the policy of the state of Texas has been the Lonergan position that was advanced. And so that's the issue, right, is that even if you have people who carefully negotiate contracts, Texas law right now tips the scales against contractors. And that's what we need help with. We need help to restore it back to where the scales are balanced, and so that responsibility is put on the people who are capable of managing that risk and not put on others to be responsible for others' wrongdoing. So thank you for your time.
Thank you, Mr. McChristian. Members, questions for the witness? All right. Thank you for joining us today.
Thank you. Appreciate it.
Thank you. Members, I don't have any more cards, so I'll verbally say anyone else wishing to testify on, for, or against Senate Bill 219. Hearing and seeing none, public testimony is closed. I'll return the gavel back to the chairman. You're welcome. I'm going to step away from the chair.
Thank you, Senators, and thanks the able team members that put this together for us, and thank all the witnesses, folks working with us on the details, and especially you guys are keeping the trains running on time. If there's nothing else further from a member of the committee, we will stand in recess subject to the call of the chair.